exercise any jurisdiction. We don't have jurisdiction on this. Yes.
Let us, for the time being, let us take a situation where the arbitrator had not recused himself. Arbitrator's award was released. We were dissatisfied with the award. We had various reasons why we are dissatisfied. Where would I go?
34.
Correct. Now, therefore,
not in 226.
34.
Or 227.
Now, therefore, my lord, that is where it's about an arbitrator. There is nothing, and therefore maybe this court would be right in saying.
You have raised an important
issue. But now,
issue.
my lord, in this book, there is nothing that deals with a grievance with an arbitral center. There's nothing.
Absolutely.
Therefore, that void has to be effective.
That is the reason why we heard you so much. Because what you raised is an important issue that something needs to be looked into, but that's on a policy level, not on a judicial level. About what is the, of course, it's been pointed out also that the Arbitration Council of India has not been set up. The Honorable Chief Justice also has pointed out that needs to be set up for the purpose of the standard. But how SIAC will come under that, that's another issue. But this, we won't have jurisdiction. You'll have to go to the Supreme Court. As regards the substitute arbitrator, we'll observe that you can raise all these issues there. We will not be the competent forum.
My lord, the problem is when I go under 11, they will not allow any other issue because 11.6 is 11.6, which therefore means that the primary problem, that is the compromise arbitration center, has to be decided here, my lord.
And if Supreme Court gives you liberty to move out of this court, we'll take it up at that time.
Oh,
it won't be proper for us at this stage.
May I make one small request, my lord? My lord, may give me a direction or whatever to approach the Supreme Court.
Yes.
I'll be much obliged because
we'll record that. We'll record that.
I'm very grateful.
We'll record that.
I'm grateful. In the meantime, my lord, whether we can at least have an interim stay for some time.
We don't have jurisdiction. How do we give interim stay?
Fair enough. Fair enough.
Petitioner is before this court seeking for the following reliefs. Notice to the respondent is dispensed in view of the proposed order to be passed. The petitioner and respondent number 2 and 3 had entered into a hotel management agreement. There being certain disputes between the parties. The said dispute were governed by clause 18.2 of the said agreement requiring appointment of arbitrator and the arbitration to be conducted in terms of the rules of Singapore International Arbitration Center (SIAC) in Bengaluru. Even during the course of appointment of an arbitrator, there were disputes as to whether it was a tribunal consisting of the issue was taken up before the Honorable Apex Court, and the Honorable Apex Court in the reported decision in 2022 7 SCC 662 had appointed a former judge of, we won't mention names, a former judge of this court as a sole arbitrator to adjudicate the issues. It is contended that the sole arbitrator submitted his draft award on 11th December 2024. Thereafter, certain comments were submitted by the SIAC Secretariat to the arbitrator, pursuant to which a revised draft had been submitted by the learned arbitrator SIAC Secretariat. The Secretariat was of the opinion that it did not address the substantive comments raised on the draft award. And in that background, the award went back and forth until 29 December 2025. The Secretariat noted that despite multiple opportunities to ensure that the award complies with the comments and suggestions made by the Secretariat, the arbitrator had failed to do so and was of the opinion that the award in its current form was not suitable for finalization and issuance to the parties, and in that background came to a conclusion that the tribunal has failed to perform its functions within the prescribed time limits under the SIAC Rules 2016. and the SIAC Court of Arbitration was considering the removal of the sole arbitrator. In that situation, the learned arbitrator, who is a former judge of this court, via its letter dated 1/4/26, informed the petitioner of his intention to recuse from the matter, withdraw stroke recuse from the matter, and by his letter dated 1/4/2026, wrote to the Secretary General, Honorable Supreme Court of India, of his intention to withdraw stroke recuse from the matter. It is in pursuance thereto that miscellaneous application number 1485 of 26 was registered by the Honorable Supreme Court of India, and by order dated 8/5/26, the Honorable Supreme Court of India, taking into account the office report which had been submitted, which indicated the recusal by the learned arbitrator, was of the considered opinion that no fresh orders are required to be passed in the miscellaneous application and disposed of the said application. Subsequent thereto, a letter having been issued by the SIAC to the petitioners on 17/4/26, calling upon the parties to furnish details of their joint nomination of the sole arbitrator. The petitioner is before this court challenging the said letter, contending that the same is honest and void. Shri Naukesh Batra, learned counsel appearing for the petitioner, would make various grievances in relation thereto. Firstly, that an arbitrator who is a former judge of this court has not been treated properly by the SIAC Secretariat, inasmuch as the passing of the award is the sole discretion of the arbitrator, and the Secretariat cannot make any substantive comments on the said award, but could have only made comments on the procedure to be followed. The substantiveness of the award is always left to the arbitrator, and as such, his submission is the tribunal has exceeded his authority. The SIAC institution has exceeded his authority. His submission is that though the Act provides for various recourse to an arbitral award, but in this case, there's a peculiar aspect of the institution itself, allegations being made against the institution itself, as regards which the petitioner does not have any recourse under Section 34. And in that background is that this court has to exercise its jurisdiction in Article 226 and 227 of the Constitution. His submission also is that the counsel appearing for respondent number 3 and 4 before the
2 and 3, my lord.
2 and 3 before the arbitrator is also a member of the SIAC Court of Arbitration, and as such he alleges that such a counsel ought not to have appeared in the proceedings, which infers a possibility of bias on part of the SIAC court.
My submission is that SIAC ought not to have inducted her as a court member, knowing that they are conducting the arbitration. It's also SIAC at equally.
They could have, being inducted is different, being appearing is a different.
No, so either way they should have, they're administering, either when they know that she's sitting on their
Or in
board.
the alternative.
I'm sorry, because finally, my lord, it's not a pleasurable thing for me.
It
But
is not for us to.
unfortunately-
It is not for us.
Unfortunately, I owe a duty to the cause of justice and to my client.
Alternatively. What? I don't know. Alternatively, but it's not good for it to be recorded. His submission is that the arbitration having gone on from the year 2022 post the appointment made on 25th January 2022, the arbitration proceedings have not been concluded. The petitioner has made payment of substantial sums of monies to the SIAC for the conduct of the arbitration, despite which now the arbitration has to commence from scratch, commence
sorry.
from the initial stage.
My lord, I'm sorry. It's my mistake. They want to continue as an EP, expedited procedure with,
Commence from the stage of completion of the pleadings. Well, it will be from arguments now. Everything is
my lord, the award was passed. It was just held. And we know why. Because the beneficiary,
has to recommence despite an award, draft award having already been submitted by the earlier arbitrator. In this background, he submit that it is only this court which can exercise its jurisdiction in Article 226 and 227 of the Constitution. Heard Shri Naukesh Bata, learned counsel for the petitioner, peruse papers. Though serious issues have been raised by Mr. Batra in this present matter, I am of the considered opinion that this court would not have the jurisdiction to consider all these aspects, for the simple reason that the appointment of an arbitrator had been made by the Honorable Apex Court in the decision reported in 2022 7 SEC 662, while its order dated 25th January 2022. The appointment of a fresh arbitrator, if necessary, would also have to be made by the Honorable Apex Court, since it is the Apex Court who had appointed the earlier arbitrator. This issue had not been taken up for consideration by the Honorable Apex Court while passing the order dated 8/5/26 in miscellaneous application number 1485 of 2026. It is therefore always available for the petitioner to raise all the issues raised in the present petition while seeking for or opposing the appointment of an arbitrator, since the categorical submission made by Sri Batra is that the petitioner does not wish to proceed further with arbitral proceedings under the aegis of SIAC. These aspects cannot be dealt with by this court when the appointment of an arbitrator under Section 11 was made by the Honorable Apex Court in arbitration petition number 12 of 2019, as indicated supra, reserving liberty to the petitioner to approach the Honorable Apex Court. The petition stands disposed.
much obliged. I'm grateful.
Yes.
Serial number 5.
Appearing for the petitioners, my lords. My lords will be withdrawing the petition, my lord.
You will be withdrawing or you're filing a memo?
We will file a memo and withdraw the petition.
Has filed a memo, dismissed as withdrawn.
Much obliged.
Serial number 6. Sriram P. Nayak.
Yes.
Unilateral arbitration appointed by the respondent number 1, your lordship. Cooperative Society, Sahakara.
Cooperative society will have to go, cooperative society 72.
Yes, your lordship.
Then it'll have to go before the other bench, not before us. A perusal of the papers indicates that it relates to appointment of an arbitrator under the Cooperative Society, Multi-State Cooperative Societies Act 2002.
The challenge
Registry
the
is to
arbitration
verify
proceeding.
and post before the appropriate bench.
The challenge the arbitration proceedings.
It'll have to go before that bench.
Your lordship, the date may be fixed.
We can't fix a date for the other bench. Move the others as expeditiously as possible.
Serial number 7. Sri Abhijit.
Mr. Abhijit? Again, cooperative matter.
Direction to dispose of their appeal, my lord, before the principal secretary.
Principal Secretary.
Yes. 30 days time, my lord, will.
From when is it pending? 26/12/25.
Yes, sir.
More than 6 months. Now, DGA accepts notice for respondent number 1 to 3. ZP Bidar.
Sir Gaurish Kashampura.
Bidar really ಹೆಂಗ್ ಫೈಲ್ ಮಾಡಿದಾರಪ್ಪ?
Bidar.
Because principal secretary is here, they have filed it here. This will have to go to Kalburgi.
Bidar. Bidar itself.
So Abhijit, pass over.
Have to go to Bidar itself.
Kalburgi, we don't have jurisdiction.
Serial number 8. Rajesh Gowda.
Recreation Club.
Victory, all of it is today only, Alva? Today only, pass over.
Serial number 9.
Pass over.
10. Sirajuddin Ahmad.
And AGI accepts notice for response just on 22nd.
Yes.
My lords, in the last date of hearing, your lordship has passed an order, my lord, that day, file was missing with me. Your lordship has seen, and first, on serial number 10 on the,
This is. This year, there are two CTPs.
yes,
They
my
file
lord,
a single petition.
my lord, both are brothers, my lords, in the same case.
So
my
what?
lord.
You have to file separate petitions.
Oblige, my lords.
So you,
For one, I will withdraw, my lords, I will file for another. I will not press for another, one, my lords.
the allegation, the avowments, everything are different, Mr. Sirajuddin.
No, my lords, both are same case, two brothers in the similar case.
You file two separate petitions.
Oblige, my lords.
The above petition, when we are trying to dictate it, it is not. Petitioner, the above petition has been filed in respect of two detainees, reserving liberty to the petitioner to file two separate petitions. Petition stands disposed.
My lords, one may remain same, my lords. For second, I will not press, my lords.
Illappa, now dictate madak,
Oblige,
all the facts will change.
oblige.
11. Subramani.
Represent the petitioner, Your Lordship.
Hmm.
The present petition which was filed before the tribunal was for maintenance and welfare of parents, senior citizens, wherein the impugned order is at annexure A.
Hmm.
The honorable tribunal has cancelled the gift deed which was executed in favor of the grandchildren, that is petitioner and respondent number 3. Your Lordships may kindly peruse the page number wherein I want to strongly rely upon page number 27, Your Lordships.
Yes.
Para 3, Your Lordships.
Hmm.
The respondent has filed a memo dated 7/4/2006 praying for allowing the petition and undertaking to repay 50% of the loan with interest. All the parties have addressed their arguments in the meantime when there was an attempt for a compromise and the matter was referred for mediation. On dated 28/2/2000, Lok Adalat was conducted and the petitioner and the respondents and respondent number 2 as well as their advocates were present. After discussion and deliberations, respondent number 1 stated that if the loan of his part is taken over the petitioner, he is ready to release the rights in the name of the grandmother. Respondent number 2 agreed to continue to repay the loan along with interest. Why I made a reference of this, Your Lordships, further, the petitioner undertook that she will take over the loan on part of the respondent number 1. Accordingly, the parties and their councils have signed their order sheet. Thereafter, the matter was posted for filing of a joint memo as agreed in the Lok Adalat, and the matter was posted for dated 27/3/2000. The advocate for the petitioner and respondent number 2 filed a separate memo dated 7/4/2006 for settlement. The respondent thereafter untenable contentions and also filed a complaint against the presiding officer and the staff members. Further, opportunity was given to final argument as a joint memo was not filed. The submission made by the counsel for respondent number 1 was considered, and it was stated that the show cause notice will be issued to the concerned case worker or heard all the parties. Why I made a reference of this to Your Lordships is for this reason, based upon the memo filed by the one of the grandchild, the petition has been disposed of. And the contention what I have taken before the tribunal is that whenever I go to the court, my file will be misplaced. Neither the dates will be given wrongly, neither the file will not be traced at all. I filed a complaint to the concerned stating that this is happening. The concerned case worker has been given a warning, and And also show cause notice was issued. Why I'm making all these references before your lordship is for this reason, that certain material facts were disclosed before the Lok Adalat. My submission before your lordships is that the matters which were disclosed before the Lok Adalat has been taken into consideration and an order has been passed. That is confidentiality of the matters which has been disclosed in the Lok Adalat, section 18 of the National Legal Services Authority Lok Adalat regulations, where it says that confidential matters which were discussed during the Lok Adalat proceedings cannot take place into
They
the.
made the submissions before the court, before the tribunal.
Yes, your lordship.
The submission made by respondent number 2 that this is what they're going to do.
Yes, your lordship. But
They
it,
make a submission before the tribunal will have
yes,
to
your
accept
lordship.
that.
There are two contentions which was raised by me.
Hmm.
There is a loan which was pending,
Hmm.
and the discussions which were made before the local. If your lordships may kindly peruse the whatever which conspired in the
For
court,
respondent number 2,
respondent number 2. Your lordships may kindly peruse
you are
page,
the one who made a submission.
page
that
number
you
60,
pay 50%.
page number 61, your lordships.
Hmm.
Page number 61.
Yes.
Reconciliation exercise done on this date. After long discussion, R1 advocate contended that loan raised by R1 is taken over by the petitioner. Then R1 is ready to release gift deed in grandmother's name. R2 will continue paying loan on his part. So now the petition has been taken to now the petitioner. That means the present petitioner who was respondent as to undertake that he shall pay the loan taken over the loan from R1 for finalization and reconciliation. See, the matter was not finalized. It was kept pending for finalization and reconciliation. Since there were several issues which were raised, such as bank loan was there. I raised that there is a bank loan. All the original documents have been submitted to the bank, and he is paying the loan regularly. So thereby, it was the matter was adjourned for finalization of the reconciliation. It was not decided. Yes, as your lordship said that it was the submission made.
Hmm.
During the Lok Adalat, a submission was made, but
Only during local, not
Yes.
before the tribunal.
before the tribunal, Lok Adalat was held, and not before when the case on the meritorious or the proceedings. It was during the Lok Adalat proceedings. During the Lok Adalat proceedings.
No, even before that, there was discussions.
Discussion is
inside
not
was,
during the final argument. This is during the local adalat. That has to be confidential.
What has happened in this case? Will ಅಂತ ಹೇಳಿ ಕರ್ಕೊಂಡು ಹೋಗಿ second respondent they have created
That is a
gift.
fact. That's the merits of the matter. That's
The
different.
merits of the matter.
But here, the tribunal has considered this submission during local adalat to arrive at as a submission during final argument. That's not proper.
No, even before that, before tribunal, it was agreed. That's why it was referred to the Lok Adalat. ಅಲ್ಲೇನಾಯ್ತು
Agreed the question of local adalat and question of again agreeing in before the local adalat for finalization would not arise, Mr. Counsel.
that's right.
That cannot be.
But what has happened, both of them agreed. Second respondent,
Where is the joint memo filed to that effect?
no, joint memo has not been.
Then where is the question of agreement?
Agreement is not there. Agreement is not there.
Then they will say tomorrow that my grandmother agreed to give up the entire property ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
No, ಇಲ್ಲ ಅದರಲ್ಲಿ
Oral submissions cannot be
what was
accepted.
agreed between them orally before tribunal 50 ನಮ್ಮ ಅಜ್ಜಿ
We'll
50%
set-
ಕೊಟ್ರೆ ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ನಾವು ಲೋನ್ ರೈಸ್ ಮಾಡಿದೀವಿ.
We'll
But
set
loan
this
in fact
We'll set aside this order, remand it for fresh considered by another assistant commissioner other than this person. You argue on merits there. ನೀವು will
no,
ಒಂದೊಂದ್ಸತಿ
I file my objections.
ಅದಕ್ಕೆ ನೀವು ಸೆಟಲ್ಮೆಂಟ್
No.
ಅಂತ ಹೇಳಿದಾಗ ನೀವ್ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ನಮ್ಮ ಮುಂದೆ ಹೇಳ್ಬೇಡಿ ಅಂತ
ಸ್ವಾಮಿ ಅಲ್ಲ there are some other documents. I will file those documents kindly.
File whatever.
Permit me to file my objections.
But we'll set it aside because they have gone, he's gone only on
Date
that
may be
way.
fixed. I'll file my objections
Where?
here ಈಗ
For
ಅಲ್ಲ
what
there are
purpose?
some other ಇದು
You file it before the assistant commissioner.
no kindly go through paragraph 3 of the first para 1 of the judgment in the same paragraph same 27 para 27 from 6 lines, last 6 lines.
He has given the facts, but the finding is on the basis of a submission made in Lok Adalat.
ಅಲ್ಲ,
That
even
cannot
otherwise,
be.
ಅದಲ್ಲದೆ ಇದ್ರುನು there is clear admission. ಕರ್ಕೊಂಡೋಗಿ ಇವ್ರಿಗೆ ಯಾರೋ ಇನ್ನೊಬ್ಬ ಬೆನಿಫಿಷಿಯರಿಗೆ ಏನ್ ಮಾಡಿಸ್ಕೊಳ್ತಾ ಇದಾರೆ ಅಂತಾನೆ
Order
ಗೊತ್ತಿಲ್ಲ.
is 50% loan takeover, not about that.
ಅಲ್ಲ, ಅದು ಮದರ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಿಯರಿಂಗ್ agreed to pay 50% of loan. That is agreed between the parties. Based on that agreement, it was passed. Lok Adalat ಮುಂದೆನಲ್ಲ, already it was agreed before.
That is not been considered by the AC. Show us the
That's what I'm.
Show us the consideration. Show
the
the consideration. Nothing has been considered.
ಸುಮ್ಮನೆ ಹೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಏನಿಲ್ಲ. And AG accepts notice for respond number 1. You 3. So and so accepts notice for respond number 3. Respond number 2. Respond number 3 is other brother and
One
sister.
submission business. Date may be fixed because 2023 ಒಳಗೆ ಫೈಲ್ ಮಾಡಿರೋದು ಇದು. On the one product start is other, they have been dragging the proceedings.
Fix
Because
the date.
that lady has to, their intention is that grandmother has to die. ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಅದು.
Respond number 3 and 4 is dispensed.
ಆಮೇಲೆ ಮೀನ್ವೈಲ್ ದಯವಿಟ್ಟು ಒಂದೇ ಮನೆ ಒಳಗಿದ್ದಾರೆ, ಅಜ್ಜಿ ತುಂಬಾ ತೊಂದರೆ ಕೊಡ್ತಾರೆ ಅವರು. ಏನಂದ್ರೆ ಅಡಿಗೆ ಮಾಡ್ಕೊಳ್ಳೋದು ಫಸ್ಟ್ ಫ್ಲೋರ್
ಆಯ್ತು, ನೀವು objection ಹಾಕಿ. Accepts notice for respond number 2, issue notice to respond number 3 and 4, returnable by 17th August.
ವಿತ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇಟ್ ಮೇ ಬಿ.
That is what we are going to
ನಾನು
say.
ಹೇಳೋದು ನನ್ನ ರಿಕ್ವೆಸ್ಟ್, ಒಂದೇ ಮನೆ ಒಳಗಿದ್ದಾರೆ, ಅಜ್ಜಿಗೆ ತೊಂದರೆ ಕೊಡೋದು ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
ಅದನ್ನೆಲ್ಲ ರೇಸ್ ಮಾಡಿ ನಾವು ಮಾಡಕ್ಕಾಗತ್ತಾ ಇಲ್ಲಿ?
ಅಲ್ಲ, ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ
3 and 4 ನೋಟಿಸ್ ತಗೊಂತೀರಾ?
3 and 4 ಗೆ ಇಲ್ಲ, ನಮಗಿಲ್ಲ. 3 and 4 ಗೆ ನಾನು ಇದಾಗ್ತಾ ಇಲ್ಲ.
ಮತ್ತೆ ನೋಟಿಸ್
4 has filed a petition earlier. That petition came to be dismissed on 1726. 4.
Will you accept notice for 3 and 4?
ಇಲ್ಲ.
Then we'll have to issue notice before we pass.
They are sailing with them.
No, your lordships,
4
as far as
ಮದರ್ ಮತ್ತೆ ಇವರು ಸೇರ್ಕೊಂಡು ಇದು
Issue
ಮಾಡ್ತಾರೆ.
notice to respond number 3 and 4 returned by 7. The operation of the order dated 16/6/26 passed by respond number 1, Assistant Commissioner, Bangalore North Division, Bangalore, in MSC number 01 of 2024 at Annexure A is stayed till the next date of hearing, considering that the entire order is based on the submission made during the conduct of the Lok Adalat for the purpose of settlement. Both the petitioner and respondent number 1 to 4, 2 to 4 are restrained from any manner dealing with alienating, changing character of the property, subject property till the next date of hearing.
Achha.
Process fee and copies to be furnished by end of day 14th July, failing which the interim order will stand automatically vacated.
Achha.
Serial number 12, Prasanna Deshpande.
But the elections, my lord, to the board of the fourth respondent society, my lord, was held in the year 2023. It expired in the last March. My lord, no fresh elections are held. My lord, the office bearers are continuing in the office, so doing financial transactions also. I gave a complaint, my lord, to the deputy registrar. He doesn't consider, they are going on, my lord. The entire body, my lord, term is over.
And AGA accepts notice for respond number 1 and 2. Issue notice to respond number 3 and 4, returnable by 17th August.
But I have sought for an interim order. Financial transaction, they are about to award a big contract, my lord. That's why they are about to award a big contract, my lord. Some financial transactions, my lord. I have produced this stone laying.
You cannot use a mandamus for such an order.
Not mandamus and with the, as an interim order, my lord, or a consequential order. Mandamus is
Ungranted.
there, my lord, they, third party interests will be created, they will award contracts, financial transactions. What is a big society, my lord, after 3 months now, they are continuing in the office, they will not hold their, let them carry on the day-to-day administration. I am not for, my lord, asking them, my lord, to restrain.
Society, not a cooperative society. Yes, next.
It is not cooperative society.
I think it's not a cooperative society. Act will not apply. It's, if you have any dispute about all those things, you'll have to go as a civil suit, not before this.
Not, in fact, it is covered by your lordship's decision after the.
For inquiry under 25, not for anything else.
Allah, this inquiry includes this, that's what, my lord, it is not separate, it is part of inquiry.
We have held in that even the registrar cannot give interim directions. this court cannot do that. Next.
13, Mohammed Tahir. General Feroz.
Hearing for petition.
And AG accepts notice for respond, relist on 22nd.
22nd, please, Lord.
14, Lata S. Shetty.
Post before a bench of which SGRJ is not a party.
My lord, my difficulty is that the RT appeal
When
is
you
that-
moved also, we told we can't take it up.
some protection,
Only
my
for
lord,
the
because
list.
the matter is today and he is kept by the matter, my lord.
Not before us. We can't take it up.
A date may be fixed, my lord.
Post before a
Above
bench of which SGRJ is not a party as expeditiously as possible.
Serial number 15, Rajendra S.
I appear for the petitioner, my lords.
Yes.
In this, my lords, the constitutional validity of the value policy of respondent authority has been challenged. Now, my lords,
Constitutional validity of?
respondent authority, value policy, my lords. Now, my lords, I'll just place a few facts and certain developments have
There's
taken
no
place.
such validity which you have challenged. You only asked for mandamus.
No, my lords, if your lordship may kindly see, my lords, certain developments have taken place. I'll just place it before your lordship.
Yes.
Now, my lords, the respondent authority had acquired the
They're
front.
appearing in 15.
15, yes, my lords.
There's nothing which you have challenged. Yes, really.
My lords, the respondent authority had acquired the front portion of my property for formation of a metro station. Now, my lords, while doing so, what had happened is they had disconnected the electricity, water and sewerage connection and the access to my building. So when I gave representation, they stated that, my lord, we had to enter into a value policy with them, wherein certain terms and conditions were laid out, the challenge of which is the subject matter of this writ petition. Now, on 25/3/2025, my lords, the respondent council made a submission stating that, my lord, if a fresh representation would be given, they would consider it and they would accommodate us. Now, my lords, I had given a representation. My lords, based on this representation, my lords, that restored.
There now.
Yes.
Pass over.
Serial number 16, Vinay N.
For the respond number 3, my lords.
Respondents have to file their statement of objections.
My lords,
Who
we have
is
not
not
received
ordered
a
on
copy
respond
of,
number
along
two?
with the.
Who is respond number 2? Chief Controller of Explosives.
Yes.
Girish,
My lords, we have not received the copy, my lords, along with the documents.
you are appearing for whom?
Respond number 3, my lords.
3.
Yes.
Who appears for respond number 1? Mr. Girish?
State.
Girish Kodgi. CCNU, Union of India. Shri Girisha Kodgi, who has appeared for respond number 1, is also directed to accept notice for respond number 2. Counsel for respond number 3 submit that a copy of the petition is not
We'll
been
serve it
furnished.
today.
Counsel for the petitioner undertakes to furnish the same 2 sets of the petition along with annexes by end of day 15th July. Relist on 30th July.
Net order may be extended. Interim order may be extended.
Interim order idea. Interim order earlier granted is extended till next date of hearing. Relist on 13th August.
17, yes, Sudarshan.
My lords, for the petitioners, my lords. The other side's been informed, my lords, asking for a short adjournment, my lords.
What is this? Is this freezing of the account or what?
Please, my lords, please. The arguing counsel is not well, my lords. Kindly, any date in the next
Is it
week.
outside of Karnataka?
Yes, sir.
Please, my lords.
Then there's a help desk. Could you petition? Thursday, there's a help desk which has been established. You go there, they'll try and
Outside
solve it.
Karnataka. Outside Karnataka. Portion of
Outside.
it is outside Karnataka. Rajasthan and Tamil Nadu.
Then go there. So ICICI respond number 6. These are all from outside. So many of them. Yes. Help desk so and so on Thursday. Thursday at CID headquarters, Carlton Towers. No, Carlton House.
Please, my lords.
From 11 to 4, take all the papers. They'll try and coordinate with all those other police stations.
Please, my lords.
Serial number 18,
About this matter, sorry, serial number 17 belongs to a batch of other matters as well. Suppose I don't, serial number 17 was brought a batch of matters which were there. I don't know, this has now been detagged without an order.
They'll try and sort it out.
Please.
Whatever is not sorted out, we'll deal with.
18, Bharati V.
Yes, madam. Yes, everything is in Bhopal, madam. We have told you.
Lordship, give me just 2 days time, Your Lordship. I'm filing 2 IAs along with the written arguments. By Wednesday, I'm almost in the verge of completing it. By Wednesday, Your Lordship, I'll file and Your Lordship may pass an order.
And counsel for the petitioner seeks for a week's time, relist on 23rd
Lordship,
August.
I will be in Jabalpur next week. Your Lordship, on Wednesdays.
You are going to Jabalpur, you can go to Bhopal also and you can file it in Jabalpur only. Relist. When are you back?
Lordship, Wednesday, I will file, Your Lordship. If you can post it for Wednesday. I want to file 2 IAs, Your Lordship, along with the written arguments.
So when are you back? Those IAs will have to be considered.
So I will file it on Wednesday, Your Lordship. May post the matter for Wednesday, 15th of July.
When are
2
you going
days.
to be back, madam?
Back, Lordship. Maybe like 3 weeks, Your Lordship.
3 weeks later. Relist on 17th August.
Lordship, in that case, I'm writing my CA exam, intermediate exam. Can it be posted for September? If not this Wednesday, then you post it after September. I'm writing my CA intermediate
We'll have to
exam.
hear you on the application after you file.
Lordship.
So September you want. At the request of counsel for the petitioner, relist on 8th September.
Lordship, 12th the exams are waiting over.
Tell us the date, no?
After post 15th any day.
Post 15th September. Relist
Grateful.
on 28th September.
Lordship, so grateful.
19. Mohammed Talib.
Petitioner Lord.
Yes.
In this matter, I'm
Here for the respondent number 2 and 3.
Yes.
I accept notice. Let them serve a copy of the.
Lordship. I've served through WhatsApp and intimated through
Don't
to
make
phone call, Your
issue on
Lordship.
copies, sort out among counsel.
Sir, even, my lords, even otherwise, from the website information, I see the prayer may become
This is the-
infructuous because they've sought to conduct the event today and yesterday.
Yes. But we listed the matter. They can give us alternate date and
In
you
fact,
don't
Your
consider everything and try and make it infructuous is not proper.
My lord, even otherwise, there's a Coco championship that is going on in the
So
ground.
when is the date available?
After 22nd, let them give us a fresh representation, we will consider.
22nd they can do or 23rd?
22nd ಗೆ ಮುಗಿಯುತ್ತೆ, any date after 22nd, looking at the calendar in the office.
But tell
of
us the date.
I will seek.
Don't make them,
Your
as
Lordship,
Mr. Batra was saying, FIFA is going on football, bada. Tell us the date, they will give a representation.
please, Your Lordship, it may be passed over, I will.
Pass over.
Please, Lordship.
B group matters, serial number 20. Ajit
20, my lord, I require 2 weeks to file my objections. I require 2 weeks, my lord, to file my objections. Serial number 20.
Objections. And AJ seeks for and is granted 2 weeks. 20.1 could.
Same, similar matters.
My lords, I appear in serial number 20 for respondent number 2 and 3 and respondent number 2. That is a port officer, please, my lords.
On number
I seek
1,
time,
Bharat Kumar V for respond number 2 and 3.
please.
Both the learned AG and Shri Bharat Kumar seek for and are granted 2 weeks time to file the respective statement of objection. Objections, if any, by 6th August, relist on 11th August, interim order earlier granted is extended till next date of hearing.
So,
Obliged.
21. Yochana S. Babu.
So, Mr. Lushka Babu.
We are for the respondent number 1 in this case, my lord.
Yes, madam.
Time, my lords. There's some difficulty for the arguing counsel to appear today, my lords.
At the request of, any objections, madam?
No, my lord, it may be date may be fixed, my lord.
The request of counsel for the petitioner relist on 13th August.
Please.
Much obliged.
Please.
My lords, the interim order may be extended, my lords.
Interim order earlier granted is extended till next date.
Much obliged, my lords.
22. Sumana Naganan.
Would I appear for the petitioner? The point lies in a narrow compass plot.
Just one moment, Mr.
Contesting respondents.
Just
have
one
filed
moment.
their
There seems
statement.
to be this one about the appearances. HCGP for R1 to R4.
Lord, state is represented, my lord, by 1, 2, 3, and 4.
Karnataka State Blood Transfusion Council, you will appear?
No. I appear for respondent number 2 and 3.
Multiple names are there.
Please.
For 2 and 3, my lord, a separate council has entered appearance.
So 4, the state will appear.
4 is state only. 1 and 4.
Yes, sir.
4 you will appear.
Yes, sir.
Registry is directed to correct the appearance of the councils as learned AGA for respond number 1 and 4. Sri Sridhar Hegde as that appearing for respond number 2 and 3. Sri H. Shanti Bhushan and DSGA as that appearing for respond number 5. Against whom is the relief, Mr. Naganan? Respond number 5, Beka?
5, oh, my lord, they are the National AIDS Control Organization, just in case they have to say something, but the contesting respondents have filed, my lord.
Where is Mr. Shanti Bhushan?
In fact, on the last occasion, he did not ask for time for counter also. But
Well, if we have to hear him,
what is challenged is an
he'll
act.
be in all the courts. So if you could request him, he'll come. We'll take it up in the afternoon. Please, so you are ready, Alva?
I read it. I have filed detailed statement of objection. Or
Also.
it may kindly be taken up on next week, my lord. Any date maybe.
It's listed, let us finish it.
Please, 2:30, my lord.
Yes.
Please.
Serial number 23, VP Ravishankar.
Petitioner. Respond number 2. Who appears for respond number 1? Hanuman Nagar Cooperative Bank.
This is a cooperative bank.
What is
Petitioner
this matter
qualifies
about?
in an auction.
Should it not go before the cooperative societies register?
My
roster?
lord, the action is under surface. The issue is this, my
It
lord.
is under surface.
Surface.
Then it will go before the surface roster.
The issue is this, my lord.
It is not before us. Surface roster is different. The matter, Lord Counsel for the petitioner submit that the above matter arises out of an action taken under Surface Act. Registry direct place the matter before the appropriate bench.
Interim order BA.
Interim order earlier granted is extended.
I'm grateful. That's it.
Serial number 24, urgent 25. Leela P. Devadiga.
Lordship, I appear for petitioner.
Yes, madam.
This is the matter wherein your lordship, I am the owner of the land, Paradina land. Thereafter, I sought permission to cut the trees. I have cut it and transported to the government depot where it's been sold. And your lordship, similar circum now. The issue is that whether I am entitled for the tree value or not.
The full value or not?
Yes, your lordship. Your lordship, I have produced the document at page number 135.
This is Paradina land.
Yes, your lordship.
135.
Yes, your lordship.
Yes. 135 is an order.
135.
Order in writ petition.
Yes, your lordship. Annexure K.
Ah.
Annexure K, my lord. Your lordship is holding 30472. There are two matters. Writ petition number 30472. Because serial number 45.
30472.
Yes.
Yes.
Annexure K, your lordship.
Ah, that is order in 52337.
Yes, your lordship. In
Yes.
that, your lordship may kindly see the observation. Your lordship, your lordship may recollect there is an amendment to the Land Revenue Act.
Yes.
Clause 20, section 2 of subclause 20. And your lordship held that after the amendment, your lordship, the owner of the land will become the owner of the, they'll become full occupant. Therefore,
Yes.
the state does not have the right over the trees. That is at page number 144. In that two issues were raised, your lordship. One is that whether the subsequent to the
What is the
amendment.
nature of land in that?
Your lordship, Paradina.
Claims that all his lands are Paradina lands.
Yes, your
Yes.
So the first question, your lordship, whether the subsequent to the amendment to this subsection 20 of section 2, whether the state would have any right, title or interest in trees grown on Jamma Bane land or Bane land requiring payment of any amounts to the state. And insofar as that observation is available at page number 141, your lordship.
Yes.
The 7 clause 2. Then your lordship, 7.4, the aspect of ownership of land and the trees grown thereon has been dealt with in detail in WP number so and so and other connected matters. This is the matter wherein your lordship they have challenged the amendment. Subsequent to the amendment to subsection 20 of section 2 of the Karnataka Land Revenue Act, it is the holder of the said Bane land or Jamma land who would become an occupant with full ownership rights. In the present case, the permission having been granted so and so date, the trees having been cut thereafter and transported to the timber depot, and thereafter it's been sold, and an auction having been held on so and so, which is subsequent to the amendment to the subsection 20 of section 2 of the Karnataka Land Revenue Act. The said amendment having come into force on so and so, even holder of the land is an occupant of the said land having full ownership. Thus, in view of the matter, whether the age of the trees was 34 years or greater or lesser than 34 years is of no relevance, since from the date on which the amendment came into force, the holder of the land is full owner and state would not have any title interest in either the land or the trees grown on the said land. Albeit, if any permission is required to cut any particular protected variety of trees, the owner would have to secure such requisite permission. That apart, there is no other manner of right, title, interest that the government can claim as regards the said land or the trees grown on said land. I answered point number 1 by holding that subsequent to the amendment to subsection 20 of section 2 of Karnataka Land Revenue Act, the holder of the land would become full occupant. The state would not have any right, title, interest in the land or the trees, and therefore they cannot claim any amount on the trees filed in the said land, Your Lordship. In this case, Your Lordship is concerned, they refused to pay the amount because out of 80 lakh, Your Lordship, we have deducted 50% and balance 50% they withheld on the ground that, Your Lordship, we are not the owner of the trees. Your Lordship, may kindly see the
Page number?
endorsement.
Page number?
Yes, Your Lordship. Annexure, H, my lord, page number 127 onwards. The relevant portion is available at page number 130.
130.
Yes, Your Lordship.
Yes.
ಅದರಂತೆ ಶ್ರೀಮತಿ ಉಮಾದೇವಿ ನಂಬಿಯಾರ್ ಚೆನ್ನಯ್ಯನಕೋಟೆ ಗ್ರಾಮ ವಿರಾಜಪೇಟೆ ತಾಲೂಕು ಇವರಿಗೆ ಸೇರಿ ಅನ್ರೆಡೀಮ್ ಸಾಗು ಸೋ ಅಂಡ್ ಸೋ ಜಾಗದಿಂದ ಬೀಟೆ ಮತ್ತು ವಿವಿಧ ಜಾತಿಯ ಮರಗಳಿಗೆ ಮಾರಾಟ ಮೌಲ್ಯ 100% ಇಲಾಖೆಗೆ ಉಸ್ತುವಾರಿ ವೆಚ್ಚದ ಬಾಬ್ತು 10% ಕಡಿತಗೊಳಿಸಿ ಒಟ್ಟು ಉಳಿದ 90% ಭಾಗದಲ್ಲಿ 50%ರಂತೆ ಅಂದರೆ 45 ಮೊಬಲಗನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಉಲ್ಲೇಖ 8ರ ಆದೇಶದ ರೀತಿಯ ಅರ್ಜಿದಾರರಿಗೆ 45% ಸೋ ಅಂಡ್ ಸೋ ರೂಪೀಸ್ ಗಳನ್ನು ಪಾವತಿಸಲಾಗಿದ್ದು ಉಳಿಕೆ 40% ಮೊಬಲಗು ಸರ್ಕಾರದ ಮೊಬಲಗಾಗಿದ್ದು 45% ಮೊಬಲಗನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಉಲ್ಲೇಖ 8ರ
not Paradina, this is unredeemed Sagu.
No, but Your Lordship, may kindly see, even if it is unredeemed, Your Lordship, it is a Bani land. It's a Bani land, Your Lordship.
We'll
It's
have
a Bani
to
land.
consider that, whether it
Yes,
is
Your
so.
Lordship.
Because what
But-
judgment you are relying on is Paradina.
Yes, Your Lordship.
So unredeemed Sagu being equivalent to Paradina Enge, how will that be?
Your Lordship, that is because they rely upon a Jamabandi extract.
The Coorg Land Revenue Act. Land Revenue Regulations.
That is.
Ilva.
ನಾನು ತಂದಿಲ್ಲ ಇವತ್ತು. I have the book.
That will be in the KLR,
Yes, Your Lordship.
not here.
We have the
I make
compilation.
one
We
submission.
have the compilation.
I don't have this file, my lord, but if my lords may kindly see serial number 47, same party has preferred. The relief sought are also similar.
No,
Serial
that-
number
The
47. my lord.
classification
No,
of
that
land. Paradina, Jamabane, we have dealt
Please, my
with
lord,
it.
please, my lord.
Now this is unredeemed Sagu. So unredeemed Sagu, yav classification barate, will they become the owner post the amendment to subsection 2 of section 20? And how is
Yeah,
the classification of the land tenure made under the Coorg land
Please.
regulations? We'll have to look into that. So you get ready and address your
Yes,
arguments
yes,
on that.
yes, I have, because I forgot to get the book, my lord. There is a Coorg land revenue book, regulations book, Your Lordship. In that, there is a reference to that. But it, yes.
Coorg Land Regulations Act, what is Sagu, what is
But even they say that it's been Paradina.
not Rawaidli Sagu.
Yes,
This
I do
is
understand.
different. So
Now, in their
we'll have to give it.
communication,
State has filed one writ appeal, my lord, that is admitted against the judgment.
Yavdu?
that, Your Lordship,
It's
against
in
the
serial number
judgment-
47, my lord, your lordship's judgment is there.
Huh.
Against that, my lord, my instructions,
You filed an
subject to
appeal.
correction, my lord, I will
Lordship,
submit.
appeal is pending. I am appearing that.
Next,
in that matter.
in serial number 47, my
We'll
lord,
connect both of these.
please, my lord, please,
Same petitioner, connect both of these and you let us know what it is.
please, my
No,
lord.
that serial number 45, Your Lordship, that's Paradina
Yes,
land.
sir.
There is no dispute.
Paradina.
This is only Sagu. Therefore, Your Lordship,
You have challenged the judgment on Paradina land.
Please, my lord.
no, Your Lordship, they have challenged the order, which is I read it now,
Hmm.
135. They have challenged before the division bench. That matter is pending for consider. There is no stay. I have the copy of it.
My lord,
It's been at least listed.
Lordships fix a
It's being
date, I
listed.
will prepare for the matter.
Your lordship, it is being listed, there is no stay.
ಮತ್ತೆ
I'll
Delay is
ascertain
coming.
everything.
I
my
have
lord.
the
It may be
copy.
listed on a
Ascertain.
DM.
25, connect
And
with
45.
47,
Please.
40, yes, well, 40.
connect with 47. Relist on 11th, 6th August.
Please.
I request for shorter date, your lordship.
Actually, ಏನ್ appeal ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡ್ಕೊಂಡು.
This is pertaining to Paradin land.
47.
Please.
47, yes.
47 Paradina we have dealt with.
Please, my lord.
We
Your
have
lordships have
with
dealt
Gamma
with it.
Bane, Paradina.
Please, my lord.
In this 25, it is relating to unredeemed
Redeemed.
Sagu.
Please.
That we have not dealt with
Please.
unless it's been dealt with in any other matter. So that we'll have to, you can
Lordship
make your
may
submission
kindly-
as regards unredeemed Sagu.
Understood.
ಏನ್ ಬೇಕು?
Let them serve a copy of this writ petition. We
out.
don't have. ಇಲ್ಲ.
ಅವ್ರ ಹತ್ರ ಇಲ್ವಂತೆ papers, ಇನ್ನೊಂದ್ set ಕೊಡಿ. ಅಷ್ಟು, you have cut so many trees, one more set of papers you give. Relist on 6th.
8th of August, my lord. 8th of August.
8th is Saturday, 6th
Please,
August.
your lordship. Great.
26, Ravindra V. Reddy.
Lordship, the
Last
last
year for
question.
respond number 1, Munish.
Well,
Who is
I
the
was told
contesting?
Srinivas might appear.
Report had to be submitted.
Yes, yes, that's I have. Only just.
Where are Mr. Srinivas and Munish?
The report starts at page number 6. I'll take my lords to the other two documents in a minute.
This is at STP.
That's right.
Yes. Page 6.
Page 6, my lords, the inspection was conducted.
Hmm.
That's at the outside, it is at the basement. No hesitating from that. CFE Kodavaga, that is consent for establishment Kodavaga, they had proposed, my lords may see point number 3. They had told that it would be at the northeast side of the project, middle of the northeast side of the project. Now, my lords, when the CFO was being in between, my lords, BBMP gave an approval plan, OC was given. Then, my lords, when the CFO was being given, it was on the 5th point, southeast corner, second basement towards the southern side of the project side at the present. Now, my lords, the next page, if my lords may turn, point number 7.
Yes.
The occupancy certificate was given by BBMP, which is enclosed to this report, my lords, on 3/4/2021. Now, my lords, CFO was given to them on 7/6/2022. Now, we had gone ahead and we went to measure the noise level, my lords. The noise level was within the range.
How can there be STP in the basement?
Please, my lords, that's the, and my lords, I may request my lords to see the next
No, no, no.
pages.
What they are
That's the
saying, before the
photographs.
completion of
Let him
construction.
make his submission.
Please.
That's, I am not even defending for a moment that it should have been there. So I just want
Is
to.
it permissible in the basement or
Yes,
no?
my lords. So I'll just take my lords. So page number 8 is a photograph, my lords, for consideration.
Yes.
And the next page, my lords, is the noise monitoring calculation, which we have done as per the noise rules of 2000.
Yes.
So, my lords, what had happened is, even my learned friend had produced at Annexure C an OM, my lords, of 1st March 2021, saying that there should be no STP in the basement.
Yes.
That's that OM, my lords, got withdrawn in the first document. That is on 30th April 2022, much before the CFO was given. Where is this? Where is the second document? There was, after that, my lords, there was no such conditions as to where it can be installed. However, in 2025, my lords,
Where is the withdrawal? In
that's the
this,
first document itself,
yes, the first document we are reading.
30th April 2022.
Where does it say that STPs can be established in a
It
basement?
does not say that. What they say is that my lords may see the office memorandum references. Board office memorandum on STP wide letter number so and so dated 1/3/2021.
Yes.
The subject is withdrawing of the guidelines for design and location of sewage treatment plant. Now with this effect, my lords may see the second page at the last quadrant order. Based on the above office memorandum issued with respect to STPs with reference to 4 is hereby withdrawn with immediate effect.
So the entire memorandum has been withdrawn.
Yes, my lords. That memorandum, my friend has produced it at page 58, annexure C. There was a restriction. There's no difficulty in accepting that there was a restriction as on 2021. But my lords, on 2022, what I just showed to my lords, they withdrew it.
This is dated 1st March 21. 1st March 21 has been withdrawn.
Yes, my lords. Now, my lords, what has happened is the violation goes to the root of the matter is the building sanction plan itself. Now, as per the sanction plan, they were supposed to put it in a different location, but my lords, they have obtained the occupancy certificate, after which there's no inspection done by
Yes,
anybody.
you are also responsible for
Please, my lords, that's what I'm.
You knew that the plan sanction indicated somewhere else. How do you give a CFE and
That's
CFO
what
for
happens
this?
is that that's now my instructions are that after this withdrawal of this STP, they had the builders, my lords, had gone ahead to say that, my lords, we have space constraint and we are putting it here. So they went ahead, my lords, shown, and all the compliance. What we went on to see is if the STP, all the compliance which the STP should be having.
So
with
you
regard
don't
to-
look at the plan sanction.
My lords, it's very difficult to say we didn't look at it. My lords may I won't say bro. I'm sorry, but I cannot
It
say
is
I've not
clearly
looked
there
at it.
as to where it is to be and you ignore it. How can
There
that?
there is a lapse. It's by far, my lords, the only situation we have ever encountered of a basement being there. Of all our records which we.
Anyway, this subject to challenge to be made. How can you have a STP with the methane gas and all the gases coming there, with the vehicles being parked?
That's it. It's in the second basement.
There are no vehicles being parked.
That so far as this particular location is there, I'm given to understand whether it's based on the photographs also. There's no action or there's no parking or there's no human movement around it.
It has to be open to air.
They have provided ducts. That's what in my report. I'm.
Mr. Mahesh.
I understand. Right.
If there is one spark, the entire building is at risk. All those columns, if 2-3 columns go, then Leaning Tower of Pisa.
Nothing so far as the ducts, my lords, in terms of ventilation, that has been provided as per the inspection report. Now, the smell factor, my lords, is something which have to be addressed to. That, my lords, they have said.
Who is the sanctioning authority? BBMP. Who is appearing for BBMP? Respond number 2. Mr. Monish Kumar.
I'm appearing on behalf of you. I'm appearing on behalf. He's in out of station.
Out of station.
Please.
How did you issue a OC with this violation?
Let me stay. I don't have any instruction. Senior is.
Don't have instruction because everybody has violated.
No, his son admission is went to Kolkata.
Kolkata. When is he back?
Thursday. Tomorrow you will back. Thursday. Kindly have this meeting. Thursday.
A report has been filed. a memo has been filed enclosing certain documents. The submission of Shri Mahesh Chaudhary, learned counsel for respondent number 1, is that though wide the office memorandum dated 1/3/21, there was a restriction on setting up of a STP in basement. The same was withdrawn on 30th April 2022, and post such withdrawal, there is no restriction for establishing a STP in the basement. The issue would, however, be as to whether the STP has been set up as per the sanction plan or not. In the present matter, the sanction plan reflects the location of the STP to be at a different location than the basement, despite which both a consent for establishment and consent for operation has been issued by the KSPCB. And despite such violation, the occupancy certificate has been issued by the respondent number 2 BBMP. They would have to, the concerned would have to explain the same. Released on 20th July.
That's one more document methods which after which methods recently, that is 16 June 2025, we came up with the guidelines methods. There we have told methods it should not be located at the basement. But now they've made an exception by saying in case of unavoidable circumstances, inevitable conditions, if it is to be provided in the basement, then proper
Coming to
ventilation.
the builder lobby on that. And be doing. You are. Who is respondent number 4? You are the builder. You want to put everybody at risk. And this is how you are discharging your duties.
Earlier,
It is unfortunate.
Your Lordship,
I-
earlier respondent one have filed the report, which is clearly saying that, which is exceeding the noise of residential area.
Noise is one small portion,
That is
Mr.
one.
Council.
No, apart from the location.
Noise you can bear.
Please,
If there's an explosion with a bigger noise,
please,
what will you do? We are worried more about that.
please.
It's a STP.
As
The
engine
gases-
gets old, usually
Gases are a concern.
All the gases will be out there and it goes into a basement. The entire basement will be flooded with that gas. It can create
Sorry.
so many issues.
We will have to come up with some solution. It's along, the
have
builder
to.
has to come up with.
Only removal of it, that's all. Establish one where it was supposed to be established and remove this. Can't put the entire community at risk.
In fact, no, that's not to blame the petitioner. The sale deeds of the petitioners, after they've got the CFO, the sale deeds are
Lord.
executed after. I'm not blaming.
they are the stepping
But
in
I'm-
the
I'm
shoes
Agreement
of the
of sale were
respondent
much
for my lord.
earlier.
I'm only saying that no, I was seeing the records.
The agreement of sale is much
Respondent
earlier.
one is,
They will see a OC being
Coming
issued
with the
by you.
respondent 4. They are
No, I am
stepping in the
not, I'm
shoes
not
of the
blaming the
respondent
petitioner.
4, my
I'm just
lord.
They'll see a CFE, CFO issued by you, OC issued by the BBMP, they'll accept it.
That's true. We should have seen that. That's when the question, what my laws posed to me, I asked them, did you see?
Ask them how it will be sorted out, otherwise they are in trouble. Whoever is,
I'll see if we can
Can't put-
provide for some solution along with the builder.
can't put people's lives at risk like this. List on 20th.
Ideally, my lords, it should be relocated as my lords have indicated. That they should be in a position to come up. And
That
tell
is what
how-
they'll have to do.
More than objections, my lords, they will have to resolve the issue by.
Now, their objection is you have given a CFE, CFO, there's nothing. That is what their objection will come.
They are protecting
Their
the interest
objection
of
will come
the
as OC has been given,
respondent
therefore
4,
they
my
are not
lord.
responsible.
Builder.
It should not have been done.
They'll blame it on you, you will blame it on them.
Let's see, instead of that, my lords, we'll try to ask my regional officer to
Sort it
look
out
for
as
an
to how it is
alternative
to be
place
done.
if they can do it.
Serial number 27, urgent, 28. Manjunath KV.
Point number 3, my lord, which is senior citizen. My lord, it's a matter under the Senior Citizen Act, my lord. My lord, the petitioner is the grandson of the respondent 3, my lord.
Yes.
Respondent number 3 had 3 daughters, my lord. When the petitioner was 1 year old, my lord, his father passes away, my lord. From that time, around 95, my lord, he along with his mother have been living with the grandparents, my lord, paternal grandparents, my lord.
Hmm.
My lord, and what happens, my
What
lord,
was the age when the gift deed was executed?
my lord, 3 years ago, my lord. My lord, a few facts, my lord.
Hmm.
My lord, what happens, my lord? All his life he has been with the grandparents, my lord, and in the 2007 there was a family partition of some landed property, my lord. All the other two daughters have got their share in the property, my lord. Then what happens is the ancestral home, my lord, small house, my lord. It's not a big house also, my lord. In 2015, they have a family meeting, and the grandson is advised by that time the grandfather also was alive, my lord. He says you demolish this house and build a house. I, with some taking loans and all, I built a house, my lord. My lord, she was had no problem with my grandmother or anything, my lord. My grandfather dies in the year 20. Gift is in the year 2022, my lord. Grandfather dies in the year 24, my lord. 24 al sat mele, she, because of the family tradition, my lord, she has to stay in some other house. She goes to the daughter's house, my lord. From then, problem starts, my lord. I am taking care of I'm ready to take care of my grandmother, my lord. I'm taking care of her also, my lord. She goes to stay with the daughter's house, my lord. They file a suit for partition also, the one of the daughters for the house, my lord. There they don't get an interim order, my lord. Then this is filed, my lord. It's a small house, my lord. I have taken loans. I have built the house. It was in the family meeting that I was advised to demolish and build the house, my lord. He's also a taxi driver, my lord. He's not some very rich person, my lord.
We'll refer it to mediation.
Yes,
Has
my
it
lord.
been referred to mediation?
We are paying 7,000 rupees, my lord. Anything like that, my lord.
Can I bring it to your lordship's notice the conduct of the grandson, my lord, who played fraud, my lord, with the grandmother, because as he said, my daughter died. Therefore, I had with my grandson with me to look after him. What he did is, my lord, when I was looking after him, my property, I built the house and I borrowed the loan under the scheme, my lord, granted by the Rajiv Gandhi Housing Scheme. After I building the house, your lordship, yes, 2016. So lordship could see the photograph also.
1,20,000.
Are you agreeable for mediation? Because first, in all the
we'll see, my lord.
maximum number of matters now coming up are senior citizens.
Yes. Let it, my
Some
lord.
right, some
We are
wrong.
paying something monthly,
Mediation,
my lord.
I have no objection at all, your lordship. Now what has happened, your lordship? I
Alright.
built the house. I am the owner of the house. I was thrown out by
No,
my
no.
grandson.
No, my
I am nowhere. Therefore, my lord, subject to allowing me to be inside the house, your lordship. And
Let her come.
mediation can be
My lord, let her
referred.
come and say, my lord, we have no problem.
Let her not come. It's
My
not
lord.
his-
We'll record a statement.
Yes, my lord. I will. Let her
Yes,
come.
your
and-
lordship.
Record a statement.
Yes, your
We are ready to take
But
care
we
of her.
cannot stop.
We will take care of her. That is not a
And conduct, mainly conduct, see
No,
the
nothing-
conduct, your lord. And further direction is also required, your lordship. What has happened, your lordship? After the house has been built, your lordship, after the interim order granted by the Honorable Court- by the Assistant Commissioner, he has borrowed loan on 10 lakhs rupees, your lordship, to 25 lakhs rupees, your lordship. And further creating encumbrance, your lordship. That is also be not there, your lordship. 35 lakhs rupees he
If
has
you want
borrowed.
to argue the matter here,
No, no, my lord. I am not saying, my lord. I am only till the mediation is over. He may do anything, my lord. He may sell the property also.
that we will observe.
That's
I
why, my
can't
lord, I
sell
am
my-
only
That we will
requesting.
observe.
I am only requesting. Allow the respondent to stay by.
Both the council submit that if the matter is referred to mediation, there's a possibility of a amicable settlement being arrived at. In that view of the matter, the director, Karnataka Mediation Center, is directed to appoint a suitable mediator to try and mediate the dispute between the parties. Since the order is passed in the presence of both the councils, the party shall appear before the director, Karnataka Mediation Center, without requirement of any notice at 2:30 p.m. Both of them are from Bangalore? Yes. 2:30 p.m. on 20th July 2026.
Yes, sir.
The submission of the learned counsel for the petitioner is that, yes, the petitioner has no objection for respondent number 3 to reside in the subject premises.
Yes, sir.
And that he will take care of
Yes,
her
ma'am.
interest. He is placed on record. In that view of the matter, respondent number 3 would be free to reside in the said, in the subject property. The petitioner and respondent number 3 are restrained from any manner alienating, dealing with, encumbering or changing the character of the property, subject property till the next date of hearing. relist on 10th August to ascertain the progress in mediation. If the mediation is going on successfully, the file need not be sent back to the
Petitioners are refrained from alienating.
petitioner and respond number
We are
3.
not doing, I consulted the house for my sake.
Both of you are restrained from
1,20,000
alienating.
ಯಾವ ಮನೆ ಕಟ್ಟಕ್ಕಾಗುತ್ತೆ ಸರ್?
They are on equal footing.
Please, Your Lord.
Grandmother, grandson, see if it can sort.
Like grandmother ಅಂತ love and affection ತೋರ್ಸುದಕ್ಕೆನ I was thrown out.
No,
ಆಗ್ಲಿಲ್ಲ
that
ಅಂದ್ರೆ
is a
ಇಲ್ಲಿ
wrong
ಬನ್ನಿ,
submission.
ಇನ್ನೇನ್
I had
ಮಾಡೋದು?
not thrown out.
Merit ಮೇಲೆ ತಾವು ಕೇಳಿದ್ರೆ ಕಾಸ್ಟ್
ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅದು.
Demonstrate before this.
That is not right.
ಅದು ಗೊತ್ತಿಲ್ಲ ಇನ್ನು.
ಇಲ್ಲ, what is saying is not right.
See what happens. If
Yes,
it doesn't happen,
Yes,
we are always there.
Yes, Your Lord. Yes, grateful.
Serial number 29, Krishnamurthy N.
Wait for tomorrow, my lord. I'll wait for tomorrow.
My lord, I have filed a retirement memo in this case. Kindly, my name may be removed.
You have filed retirement memo for whom?
For petition.
Petitioner, Krishnamurthy N.
Yes, sir.
ನೀವು ಯಾರಿಗೆ?
Petitioner, Vardharaju.
ಯಾರು ಹೆಸರೇನು?
Vardharaju.
Vardharaj. Submitted that retirement memo has been filed on by Mr. Krishnamurthy N, who is appearing for the petitioner. Shri Vardharaju so and so submit that he would be appearing for the petitioner. In that view of the matter, retirement memo is accepted. Shri Krishnamurthy N is discharged from the matter. Registry is direct print the name of so and so as that appearing for. Vardharaju petitioner ಹೆಸರಪ್ಪ.
Petition.
ನಿಮ್ಮ
Muniraju.
lawyer ಹೆಸರೇನು?
Muniraju.
ಏನು?
Muniraju MN.
M. ಬರ್ದ್ಕೊಡಿ. Correct spelling ಬರ್ದ್ಕೊಡಿ. Shri Muniraju seeks for and is granted 2 weeks time, relist on 10th August.
My lord, report is filed, my lord.
Report, ಏನ್ report?
The petitioner did not visit is not given a complaint to the police station, my lord. After registering FIR against him, he failed to.
ಕೊಡಿ, petition ಕೊಡಿ. Report has been filed. The memo along with the report has been filed by the land AG. The same is taken on record.
Copy, sir.
Relist on 10th August. Copy ಕೊಟ್ಬಿಡಿ.
Serial number 30, Arjan, 31, Jagdisha KG.
Challenges to the banking ombudsman's order, my lords. The husband borrowed a loan for construction of a house.
Yes.
He is left behind the widow and 3 minor children. Lords, the kind of ailments which he had suffered as a result of which he expired, insurance company takes a stand that it is not covered in the express clauses of the ailments covered in this policy. This is a policy taken for the purposes of the loan only, my lords, as a matter of requirement for the loan.
Before you came, they moved the memo.
Yes.
This is for restraining possession notice. We told them that this can't come before us.
No,
This is under Surface Act possession
But
notice.
but the main prayer is only ombudsman, my lords. The main prayer, if your lords were to see, it's only challenging the ombudsman order. If your lords were to eventually allow this writ petition, my lord, there will be no liability.
Now 18, so at page 18.
Please.
If you come to on 39531.
That's the interim prayer, my lords. That's what is sought for is an interim prayer.
Discharge the outstanding loan amount of so and so, direct complete file, award interim, then restrain from taking action in terms of the possession notice.
That's only interim prayer, my lords. If your lords were
Can't
to see
grant you
page
interim.
17.
You are here for interim relief only. We can't
No,
grant you that.
Of course, my lords, I understand, my lords. I'm not here for the interim relief. If your lords were to consider my matter on merits, my lords, this loan liability itself will
Consider.
not arise.
And the other matter which is there cannot be clubbed to this. This has to go to that
Lords,
court.
what happened after your lordships have passed an order, probably the registry, my lords, because if matters are before 2 courts, it will, that circular is there which says it will come before the senior judge. That's how the matter is placed. We had actually moved the memo before that court.
Did he?
only, both will.
So you club both of
He
them.
appear for the bank, my lord, he appears for the
I appear
insurance.
for the insurance company. I've been directed. Now the copies are served. My lord, on going to the averments, this is a contractual liability. The repudiation has to be, you have to question it before the appropriate
Whatever
forum.
it is, are you
Their
ready?
main apprehension is against.
Are
the
you
bank.
ready for argument?
No, today I have received, now, just now,
So when will you get ready?
2 weeks, because that.
Not 2 weeks, there's urgency in that.
Once, this honorable court may not have a appropriate jurisdiction. They have to, that repudiation, they have to challenge before the consumer court.
Whether we have jurisdiction or not, you have to argue that, for which you are taking 2 weeks' time. Argue in 2 days' time.
Next week, ನೋಡ್ತೀನಿ ಅದು paper.
Then you don't take action until then.
ಯಾರೋ ಬೇರೆ advocate appear ಆಗಿದ್ದಾರೆ ಇವತ್ತು.
You can't have both.
I
You
appear for
can't
the bank.
look at Ms. Lingaraju, I am
My lord,
nothing.
I have no qualms, my lord, if the insurance, this thing is directed to pay. Ultimately, my lord, I am the bank, I am only interested in my dues. If the writ petition, my lord, gets allowed, I do not have any qualms, my lord, whether she pays or he pays. My lord, but my lord, insurance ombudsman clearly states the insurance policy, my lord, covers only 50% of the this thing insured amount. The learned senior advocate submitted that it absolves the entire liability.
No, no.
But that all of you have to
Covers
argue.
fully. Those things will
You
argue.
can't be throwing tidbits like this. If you are ready now, we'll take it now.
I do not have the copy in 31.1, my lord.
Kodi pa copy kodi.
I'll get.
But then don't take any action.
What's,
Because then it will be rendered infructuous. What is the point?
only as a humanitarian, 3 minor children, my lords, and a
Let them
widow.
not precipitate on them.
We don't know whether Mr. Ravishankar will succeed or
We have
not.
initiated
But
afresh,
the
my lord, the process.
petition should not become infructuous. So you want to address tomorrow, day after
Let it be,
tomorrow?
I mean, let it be decided finally, my lord, because of that.
Correct. Sri Lingaraju Learned Counsel appearing for the insurance company. 6 fund is granted. ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ
ನನಗೇನು
ನನಗೆ ಪೇಪರ್ಸ್ ಕೊಟ್ಟು ಅದು ಹಿಂದೆ
6 fund is granted a week's time
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನೋ ಆಗಿದೆ.
to get ready and address his arguments. The submission of Sri D.R. Ravishankar, Learned Senior Counsel appearing for the petitioner, is that if the insurance claim is paid, there won't be any dues to be paid to the second respondent bank. In that view of the matter, considering that the insurance company has sought for time, the respondent number 2 bank is restrained from taking any coercive steps against the petitioner till the next date of hearing. Relist on 23rd, 23rd July at 2:30 p.m.
Please, my lords.
All the councils, respective councils are directed to file their respective synopsis of dates and events, list of authorities along with authorities after exchanging the same with each other in advance.
List of dates, synopsis, and the
We will
judgments
direct
give
it.
a copy.
The whole thing.
Great.
32, Sirajuddin Ahmad.
Yeah. The petitioners, my lords, have completed 25 years, my lords, of incarceration. Earlier, this honorable court, by the order, my lords, has
Judgment, show us the judgment.
passed.
I would ask you to place on record the judgment convicting the petitioner.
My
Where is
lords,
that
it is
judgment?
not available. I tried, my lords, it is not available. It is.
How can it not be available, Mr.
My lords,
Rajade?
the online, because this conviction is given by the court in the prison premises, my lords. I have tried much, my lords. There was a court 34th additional in the prison premises on the second
This has
floor.
not been uploaded.
No, my lords. It is not been uploaded in the website. Only one order is uploaded for 4 lines, my lord. That's all.
You place it on record.
That's and my lords, it is life
No,
conviction.
we'll also verify that. There's no hurry for this. The counsel for the petitioner submit that the order of conviction and sentence, judgment of conviction and order of sentence has not been uploaded on the
Uploaded
website.
in SC number
And as such is
500.
unable to produce the same. Learned AG is directed to place on record the judgment of conviction and order of sentence. The registrar computers is also directed to look into the matter and submit a report as to whether the judgments which have been passed in the court sitting in Parapna Agrara, as regards the judgments passed by the court sitting in Parapna Agrara, whether those judgments have been uploaded onto the CIS and available for viewing and downloading on the website of the concerned district court. Released on yav kodtira?
Next week.
Released on 21st July.
Serial number 33, Raghavendra K.
The petitioner in this case, my lords. Yes. My lords, in this case, my lords, the government has appointed one advocate as a SPP to conduct a criminal case trial, my lords. By annexure D, page number 29, my lords. My lords, after that he has conducted a trial, my lords, the case came to be convicted against the accused persons, my lords. As per annexure E, my lords. After that, my lords, they have preferred a criminal appeal number 438 of 19 as per annexure F, my lords, page number 94. Before the honorable court, my lords, that came to be allowed, and the matter has been remitted back to the trial court, my lords, for fresh consideration regarding some another connected matter has been registered, counter case has been registered. For that reason, that came to be allowed and remitted back to the trial court, my lords.
Yes.
After that, my lords, the case went up to the apex court, my lords. So your lordship may kindly come to annexure J, my lords. The apex court was page number 118, my lords, 118.
118. Yes.
In some modifications, my lords, the same order passed by this honorable court has been upheld by the apex court, my lords.
So
remanded order has been confirmed, my lords. My lords, after that, my lords, straight away the government has cancelled the appointment of the SPP, my lords, wide annexure A, my lords, page number 11, my lords. Because once the matter has been remitted, my lords, the same SPP has to be conduct the trial. That is what my respectful submission before this honorable court, my lords. Page number 11, annexure A, my lords. Last occasion, the government advocates told that, my lords, in the connected matter, the very same person who has appointed as SPP, my lords, is appearing for the accused person in the connected matter, my lords. For that reason, they have cancelled. That is not criteria for the cancel, because he is appearing for same persons in that case, my lords. Who are the complainant in the present case, my lords.
Now this is an order of 24 to 22. The SPP is appearing for whom?
For the complainant, my lords, in SC number 100.
Cannot appear.
In the another connected matter.
Against the state.
Please, my lords, if that is so, my lords, I am ready to take back my wakalat in another matter, my lords. I may be permitted to continue in the present matter, which I have.
Once you appeared, you can't be doing that. This court has held in Shiva their judgment. Has held that you can't be the SPP cannot appear for the complainant and also for the state.
Yes.
As a prosecutor.
Then I am ready to take back my wakalat in another case, my lords.
Once you appeared, you appeared.
No, my lords. Previously, my lords, that because the matter
you appeared, it cannot change.
No, my lords.
Just by taking the wakalat.
In that case, my lords, no trial has been conducted in that connected matter, my lords.
See, the wording used are the prosecutor has to prosecute, not persecute. If you remember it right, that is the exact words which have been used. So if you appeared for the complainant in a matter, you cannot appear for the state on behalf of that complainant for the purpose of prosecution.
I will not appear here. I will not appear as for accused in that connected matter.
Even you are the prosecutor.
Yes. I am the prosecutor, my special public prosecutor, SPP. Because, my lords, he has conducted the trial in SC number 100/2014, my lords.
What is your interest, Mr. Counsel? To be appearing as a prosecutor?
No, I am not a prosecutor. I am for the complainant. Myself appointed as SPP of one advocate in the.
That shows that interested in that particular prosecutor.
No, my lords, he has conducted the trial, my lords. That came to be convicted, my lords.
But
only for technical reason that matter has been remanded from the honorable court, my lords. Only. Even your lordship may kindly come to the. My lords, your lordship may kindly come to the order passed by the apex court, my lords.
When you engage him for your personal matters, it gives rise to a different context.
No, what my
it becomes suspicious.
No, your lordship, I may be permitted to read the order passed by the apex court.
Matters.
No, that's what. No, my lords. In this case, the government appointed one advocate as a SPP, my lords. He has conducted the trial that came to be concluded. My lords, once the matter has been remanded back to the trial court, my lords, the person who has conducted the trial previously, my lords, he has to again conduct the same, my lords. That is what my respectful submission, my lords.
Yes, but he has appeared for you in your personal matters.
That's what I am. In the connected matter only, my lords. Counter case only, my lords. which this court has been remanded back to conduct.
Cannot appear like that.
That's what I am ready to take back my.
It doesn't change the situation. Once he has appeared, he has appeared. It can't change.
No, in that case, my lords, in the another CC matter. CC matter, I am telling my lords. Your lordship may kindly come to that CC number 339.
Any matter, if he has appeared for you personally, in your personal matter, if he has appeared, he cannot appear as a, he cannot be appointed as a SPP. There's a conflict of interest. That's what this court has said.
In the present facts and circumstances of the case, my lords, first case has been concluded the trial before.
It doesn't make any difference, Mr. Counsel. What does the Shiva be another judgment? ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲ ಅಲ್ಲ ನಮ್ದು ಹೈಕೋರ್ಟ್.
I'll give it.
Read those judgments or list code here. The learned AGA submits that the special public prosecutor services have been terminated in the present matter since he had appeared for the
one request, my lords.
For the private complaint in a private matter, and as such there's a conflict of interest.
One submission. I may permitted to withdraw the writ petition, my lords. Otherwise, I will withdraw the writ petition, my lords. If that is so, because I was not aware of that judgment regarding
judgments. Not bada judgments.
That's what.
Petitioner is before this court seeking for the following. After arguing for some time, learned counsel for the petitioner seeks permission to withdraw the above petition. Petition is dismissed as withdrawn.
Much obliged.
Serial number 36.
Mr. Arvi.
Hanmantappa B. Harvigowda. MG Shivanna filed NOC.
Yes, Mr. Shivanna.
ಮಹಾಸ್ವಾಮಿ, ನನ್ನ ಜಮೀನಿನ ಪಶ್ಚಿಮ ಭಾಗದಲ್ಲಿ ಬಿಸಿ ಕಾಲುವೆ ಇದೆ. ಅದು 8 ಕಾಲು ಅಡಿ ಅಗಲ, 600 ಅಡಿ ಉದ್ದ ಇದೆ. ಅದು ಬುಗುನಹಳ್ಳಿ ಕೆರೆಯಿಂದ ಮೊದಲು ನೀರಾಯ್ತಾ ಇತ್ತು. 1996ರಲ್ಲಿ ಬುಗುನಹಳ್ಳಿ ಕೆರೆ ನೀರು ತುಮಕೂರುಗೆ ಕುಡಿಯೋ ನೀರಿಗೆ ಅಕ್ವೈರ್ ಆದ್ಮೇಲೆ ಹೇಮಾವತಿ ಅದನ್ನ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂತು. ಪೂರ್ತಿ ಬುಗುನಹಳ್ಳಿ ಕೆರೆ ಯಾವ್ದಿತ್ತು ಅಷ್ಟನ್ನು ಪೂರ್ತಿ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂತು. ಆ ಅಚ್ಚುಕಟ್ಟಲ್ಲಿ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಾದ್ಮೇಲೆ ಈ BC ಕಾಲುವೆ ಪೂರ್ತಿ ಹೇಮಾವತಿ ಕಂಟ್ರೋಲಿಗೆ ಬಂತು ಸ್ವಾಮಿ. ಅದು ಹೇಮಾವತಿ ಕಂಟ್ರೋಲಿಗೆ ಬಂದಾದ್ಮೇಲೆ ಇದು ಕರ್ನಾಟಕ ನೀರಾವರಿ ಆಕ್ಟ್ 1965 ಕೆಳಗಡೆ ಬಂತು ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಅಡಾಪ್ಟ್ ಆಗುತ್ತೆ ಅದು. The petitioner further submit that under section 20A of the Karnataka Irrigation Act 1965, any user of a filed channel shall be bound, repair and maintain such channel in good condition so as to facilities the follow of
ಯಾವುದು provision ನೀವು ಹೇಳಿದ section
20A
20A of
ಕರ್ನಾಟಕ ನೀರಾವರಿ ಆಕ್ಟ್.
Karnataka Irrigation.
Make one submission. I have not received the copy, my lord.
Copy.
Oh, last date of hearing ಅಲ್ಲಿ take notice.
Last time you were not present.
ಹೌದು.
ಕಾಪಿ ಕೊಡಿ.
ಸ್ವಲ್ಪ ಇದಾಗಿ
ಆಯ್ತು ಕಾಪಿ ಕೊಡಿ, ಅವ್ರು ನೋಡ್ಕೊಂಡು ಹೇಳ್ತಾರೆ ಏನು ಅಂತ. What they are asking basically, certiorari right to quash Annexure G and a mandamus for protection of the BC canal. So status of BC canal you will have to let us know.
ಹೌದು ಸರ್. 20A 24 ಎರಡು
Rule 23.
ಆಗುತ್ತೆ ಸರ್ ನನಗೆ.
ಆಯ್ತು ಕಾಪಿ ಕೊಡಿ. ಯಾವ ಕೊಡ್ತೀರಾ? ಯಾವ ಕೊಡ್ತೀರಾ ಅವ್ರ ಕಾಪಿ?
One week or 2 week.
Counsel for the petitioner undertakes to furnish two sets, ಎರಡು set ಕೊಡಿ.
ಆಗ್ಬೋದು sir.
Two sets of the petition along with annexures on the counsel for respond number 1 and 2 by end of day 20th July. Counsel for respond number 1 and 2 seeks for and is granted 10 days time thereafter to obtain instruction, make a submission. Released on 6th August 2026. Is learned counsel for respond number 1 and 2 is directed to place on record the status of BC Canal and whether it is in good state of repair. If not, what are the actions proposed to be taken to bring it into good state of repair? Please.
Serial number 37 urgent, 38.
One ನಿಮಿಷ ಅಲ್ಲಿ. Shri M.G. Shivanna has entered appearance for petitioner. Registry Direct delete name of Shri Hanumantappa Harvi as that appearing for the petitioner. 38.
38, I appear for the petitioner.
Natraj.
The respondents
So
are
Natraj?
to file statement of objections.
They filed.
No.
Pass over.
Serial number 39 urgent, serial number 40. Manoj SN.
But serial
Outside
number
state?
38, serial number 38, man, could it be on any next week, my lord?
If it goes to August.
First,
Petitioner in serial number 40,
Outside state.
outside state.
You go to the same this one.
Because
Help desk.
I may press for interim order, Manoj. I have received a 2,000 rupees, Manoj. Petitioner is a practicing advocate. He has received 2,000 rupees.
They have to ascertain the facts. Let them ascertain the facts. You go and place those documents. Let the bank also place the documents. That is why this interim arrangement we have worked out on 16th.
Serial number 41.
Your Lordships, they have to file the objections, Your Lordship.
My lord, in this, my preliminary instructions are that there is a DRAT appeal that is filed and some amount has been recovered and paid in the DRAT appeal. Now the appeal is.
Carrot, Your Lordships.
DRAT. Why DRAT, why will it come before us?
Calculated the amount.
Carrot.
Carrot, Your
Carrot.
Lordships. The amount was 7 crore 26 lakhs 15,763. That was the recovery amount that has been deposited, Your Lordship. Despite that, there is attachment which is subsisting now. 11 apartments. Out of that, 5 have been released. It's not practically released, but virtually. Just in papers, Your Lordship. The special tahsildar is not released yet, even despite the orders of this honorable court. The 3 judgments, Your Lordship.
Now, my lord, there's a letter that was written by Carrot to the session.
In which matter, you have not made the person who got the order a party.
Your Lordships.
In which matter was the order passed?
I'm also party in that, Your Lordships. That is in.
Page number?
That's page number 282, Your Lordships.
282.
So in the third part, yes, yes, Your Lordship.
282.
No, these are the other apartments, Your Lordships. 5 have been released. That is A7.
You are aggrieved by
A3, A4.
the Special Deputy Commissioner continuing the attachment.
Yes, Your Lordships.
The attachment has been ordered in terms of the execution proceedings.
Yes, Your Lordships.
Recovery certificate issued by the RERA.
Yes, Your Lordships.
There should be a complaint in which an order has been passed.
Right, Your Lordships.
So in those matters, who is the complainant?
The complainants are different parties, Your Lordships.
So you'll have to make them parties here.
No, Lordships, that is with respect to the other complainants. That has been set aside by the Honorable High Court, Your Lordships, by division bench. In one.
Which has been set aside?
Your Lordship, page number 9, the same, 239, Your Lordships.
239.
Bill number 27, 2023.
Hmm.
Here, Your Lordship, the recovery amount is 14 crore 18 lakh 78,649 rupees.
Hmm.
This was set aside because this was miscalculated, incorrectly calculated. Page number 240.
So what happened after the remand?
After this, Your Lordship, we approached the Carrot. We have deposited as per the directions of this honorable court. And the deposit has been made.
What has happened after the remand? Remand happened in 2024.
Yes, Your Lordships.
What happened to those?
Pending in Carrot, Your Lordships.
And this is an order passed as regards all those people that you made a party.
This is with respect to the recovery amount alone.
That is respond number 2 to 12.
Yes.
You have not made them a party here.
Your Lordships, that is with respect to recovery amount, Your Lordships. See, the recovery amount was with respect to uh, the apartments, not apartments, the complainants.
Mr. Counsel, basic thing is, if a recovery certificate has been issued on a proceedings initiated by them,
Yes.
now you want the recovery certificate to be set aside.
No, Your Lordship, my point is the recovery amount which was calculated by the special Tahsildar was 14 crores. That was set aside by this honorable court. Meaning that
You may have a good case, we're not
Your
on that. But you have not made them parties to these proceedings.
Your Lordships, that is because they are, we have deposited the amount. The disputed amount is 7 crores, Your Lordships.
Who is going to say that? It is for them to say that.
We can, Your Lordship.
They'll come and say, no, no, you are not deposited.
See, that is disputed. Whatever was disputed, we have deposited that.
That is what you are
We'll
saying.
give it an affidavit, Your Lordships.
Make them parties. A peril of the cause title indicates that the persons who had approached the RERA and in whose matter the orders had been passed by RERA and subsequently recovery certificates had been issued under section 41 have not been made parties to these proceedings. Counsel for the petitioner is granted 10 days time to array them as parties to these proceedings. Relist on 23rd July.
Serial number 42 urgent, 43 Chaitanya SG.
Petitioner is Martin. Regards to the deed writers login.
Deed writers. Yes.
Because
We will file the statement, but apart from that, my lord, their only right under 80B is a license to draft a document, my lord. Now, my lord, by virtue of the login, they do not get any special power. The only thing is, my lord, they are trying to monopolize that. Now, my lord, the entire Kaveri 2 platform.
Do they have a right to log in? Do they have a right to present the documents?
Everybody, they have, my lord. Anybody can direct.
Is it on record that they have a
That-
right?
that-
You want a right to present your document?
it's not just the right, my lord.
Huh.
The right is already prescribed under 80B.
Hmm.
Any person, only 3 categories of people can actually draft a deed for the payment. That is one, deed writers, advocates, and legal practitioners.
Hmm.
Now the statute provides them.
I can't draft it for myself.
Self can be
Self,
done.
yes.
Self can be done. But my lord, the only problem is there is also a definition of a tout which has been prescribed under this.
Definition of?
Tout.
Tout?
Yes, my lord. Tout is a
Why
person.
where is the definition of?
Under 80D.
What is section 80B?
It is part 13A, my lord, of touts in there.
18B is of deed writer.
$80B.
Also, part 13A, my lord.
Of the Registration Act.
Yes. Yes.
80B
Yes, yes.
doesn't have any part 13.
Deed writers to hold licenses.
Of the next part 13A and may I pass?
That is the Karnataka amendment.
Yes.
Yes.
Now, my lord, these touts are the people who are seen in the presence of the sub-registrar's
No
office.
person other than advocate or other legal professional for payment right deeds unless he holds a license granted. Where's tout here?
Next, Ganesh.
That is West Bengal,
West Bengal.
not Karnataka.
Not Karnataka. Karnataka Jilla. Lord, what my lord said in one sentence is precisely the answer to the petition.
That is West Bengal amendment. Karnataka amendment doesn't have tout.
Yes, my lord, but the definition of the tout is that.
That is West Bengal.
Listen, just for a second, my lord, yes, indulgence. Touts are the people who are seen in the presence of the sub-registrar's office and who do not have any licenses to be there. And such people are discouraged from engaging in such activity. Now, my lord, in electronic space, when we come to paperless registration, now, my lord, if universally it is opened, then, my lord, what happens is that every cyber center, every Xerox center, there may be people who will be doing this same work of registering, drafting these documents, who do not have any accountability. Now, my lord, out of 31 states and union territories in our country, in fact, a project has been initiated by the Department of Land Resources, Ministry of Rural Development, Government of India. Under this project, about 31 states and union territories have already been included. And in all the registration processes, there is a drop down in the portal, my lords, where it says citizen, deed writer, and an advocate. Now, a deed writer will enter his credentials in the form of licenses, and the advocate will enter his enrollment number. And citizen, whoever wants to register the document for himself, is also given the opportunity to do that. Now, but no person should be allowed to draft a deed for another person, and such person should not be entertained, is all our case. So therefore, when almost all the states are following, it's not a special thing that we are asking. It is just that one drop down, my lords, one login credential, it gives some accountability to the document, my lord. And my lords, if I see, I have attached a sample sale deed, my lord, paperless registered
Page?
sale deed. Page number 31, my lord.
Hmm.
This
Is the
manual.
paperless registration system manual.
No, page number 16, photocopy I have.
16.
Yes. This is the sample paperless registered document.
Hmm.
This document, my lord, does not contain signatures of any parties on the pages at all, except in the last page. This doesn't contain any drafted by column, who drafted it.
See, the e-signature will always be on only one.
But my lord, when a contract has to have an offer and acceptance.
E-signature only offers only one signature. Even our judgments which are uploaded has only one signature,
So-
e-signature on the facing page.
I understand.
It is not there on every page.
I totally understand. If it is uploaded on the website, and if the user is accessing only the website, then I understand. But when this document is printed out, and if it is submitted to the court, there is no signatures of the parties at all. And there is no accountability also
E-signature
as to who drafted it.
E-signature is per document, not per page.
But that's, I totally understand. My only concern is there is no accountability as to who is drafting. And when there is a specific provision which says only deed writers and advocates are supposed to draft a document for a payment. Now, sir, it is just a simple one login is that all that we are seeking.
My lord, one humble submission from the petitioners in serial number 43.1, my lord.
Yes.
My lord, I may be permitted to place on record the memo, my lord.
Section 69.
My lord, time and again, my lord, this honorable court has reminded me about my functions and my roles, my lord. My lord, if I may kindly take your lordships to page number 7, my lord.
Me under deed writer.
Please, my lord. Please, my lord. My lord, time and again, this court has reminded me that.
Just one.
Please, my lord. Please, my lord.
Yes, could you do? Yes.
My lord, time and again, my lord, this honorable high court has reminded me of my roles, my duties, and my functions, my lord. My lord, and the judgment that I've produced before this court, my lord. My lord, this judgment has gone through as to who I am, my lord, and also reminded me as to that I have certain responsibilities, my lord. My lord, if I may kindly take to page number 7, my lord, paragraph number 9, if I may be permitted, my lord. Aadhaar card of Yalamanchali Jitan Kumar is appended to be statement of, their photographs in the Aadhaar card and the general power of attorney executed completely match even on cursory look. The photograph in the agreement of sale is completely different even on the prima facie look. Therefore, the petitioner, the deed writer, ought to have looked into the documents produced before him, as the statute enjoys a duty to be performed by him, my lord.
Yes.
Also, my lord, if I may kindly take to page number 11, my lord, paragraph number 12. Deed writers must be aware that they are functioning on grant of a license under the rules and certain duty cast upon them, my lord. My lord, this is one of the judgment that I've produced, my lord. There are plethora of judgment that has been passed by this honorable court, reminding me and cautioning me of the precautions that I'm supposed to take and the duties that I'm supposed to look into this vital process that is that has been taking place, my lord. Now, my lord, in such a important process that the citizens go through, my lord, registration, all that I'm seeking, my lord, law has given me the recognition, my lord. Now, when the law itself has given me recognition, one login portal is what I am seeking before the government, my lord, by virtue of my representations, my lord. Now, what would happen if I have the login portal, my lord, that I'll be held accountable if if something goes wrong, my lord. Even today, my lord, when trial takes place, my lord, the deed writers are called upon during the evidence stage, my lord. Now, when I do not have the login portal, how will the tracing out goes on, and how will I be brought before the court, my lord? This is one humble submission, my lord. My lord, also further, my lord, if I do not have, now the problem that I'm facing, my lord, now all that the parties get is OTP, my lord. It's not necessary that my photo is taken, neither my signature is taken before the sub register. All that I'm supposed to give is one OTP, my lord. I can stay anywhere, my lord. All that I need to tell them is my OTP. My presence, whether I'm present before the sub registers, it's not recorded.
No, you don't need to be present. You can sit here and
My lord, now the OTP, my lord, suppose if I am the attesting witness, my lord, I need not go to the sub register, my lord. Instead, somebody in my name, my lord, some other process might happen in my name, taking my phone, the OTP can be given and telling that I am the attesting witness, when I am not involved in the process at all, my lord. Third, my lord, when I am given such a important process, my lord, I face penal provisions, my lord. I have punishments if I do not go through the process properly, my lord. When I am having all such important role, my lord, when I do not have login, my lord, my entire existence, though I'm having recognition under statute, government is not giving me, my lord. Therefore, my lord, the only prayer that I'm seeking before my lordship is to give me a login access, my lord. In fact, my
put
lord,
your
the
petition,
BWSSB portal, my lord, also has the login process for the plumbers, my lord. My lord, even the BWSSB portal has a login portal for plumbers, my lord. The erstwhile BBMP, the present GBA, my lord. Even if I have to get a building plan approval, my lord, the engineers have the login portal, my lord. If that is the case, my lord, why is the Department of Stamps and Registration not giving me the login access? Is my question before the government, my lord.
So Jafar, as per 80B,
Yes,
out and all is not part of Karnataka amendment. 80B, it is only a advocate or other legal practitioner
Yes, ma'am.
shall for payment write deeds unless he holds a license granted in accordance with rule under section 69. Now, if you make it open as it is now, how do you verify whether he has a license or not?
No, my lord. Now there are three things, my lord. A person gets a document drafted. Now the ATB gives them license. For a legal practitioner, of course, my lord, by virtue of his degree and his practice, he has knowledge of the law. Now, my lord, what my learned friend was arguing, that if something goes wrong in the document, he is called to give the evidence. Now, my lord, he is not the author of the document. Your lordship may kindly see, he is never an author of the
He may
document.
not be an author.
Yes, my lord. But then he is a technical person who has the knowledge to draft a document. Now, my lord, that we are empowering them. Now,
See,
by virtue of this,
we get a lot of these contentions,
Yes, my lord.
saying it was drafted without my knowledge.
Yes, my lord.
Then we are,
We will, yes, my
in
lord.
the senior citizen matters, we are
Yes,
taking
yes, my lord.
action.
Yes, my lord.
Now, if a deed writer or whoever has drafted it, has drafted it at the instruction of one of the parties and not at the instruction of the other parties,
Yes, my lord.
then we can haul up the deed writer
Very well, my lord.
or the legal practitioner,
Yes, sir.
whoever it is.
Yes, my lord.
Now, to ascertain whether this document has been drafted by a legal practitioner or the deed writer or a person having a license
Yes, my
to
lord.
do so, how do you verify that?
My lord, what happens is, what they are talking is now about the paperless thing. My learned friend, judgment also that is produced in the same matter, my lord. There, what they have said factually, the deed writer has admitted that some advocate came and gave me a document. I just affixed my signature because I had a license. Now, my lord, technically he himself has done a wrong by not verifying the
Correct.
document.
Now,
Now, my lord,
if somebody were to present it,
yes,
that is what we are asking.
yes, my lord.
Suppose today a document is presented from here.
Yes, ma'am.
Now you have no restriction. The document is between X and Y.
Yes, ma'am.
Now A can present it as per what you
Yes,
have now. A, who has nothing to do with being a party, nor is he a draftsman of the document.
Yes, ma'am.
He can present it for registration. Now, how is, if A says, I only presented it,
Yes, ma'am.
who is the person who has drafted it?
Now, my lord, every document that is drafted, my lord, if your lordship is also aware, the first question my lord posed here, that itself has answered their question. Why I cannot draft my own document?
Yes.
Now, my lord, what has happened is in Kaveri portal, what my learned friend is telling, they have come before this court only with an intention to monopolize their authority.
Not
No, my lord, see,
monopolize, it won't be
what happens is-
monopolizing.
My lord,
It
if your
is-
lordship will kindly see, a deed writer is only empowered to, other than an advocate and legal practitioner, shall for payment, write deeds unless he holds a license granted in accordance with his rules. So, my lord, we have empowered him only to write a deed. Now,
Correct.
my lord, now this presentation of document is a ministerial act. My lord, tomorrow, assumingly I draft a document, my client says, sir, I will draft, I will upload it myself. Now the government has made it very simple.
No problem.
Yes, my lord.
If the person who is uploading the document is a party to that document, there's no problem.
Yes, my lord.
Other than that, who can upload it?
Anybody, my lord, any
That is the
public, my lord,
problem.
any public, my lord, any public can upload the document. And what happens is, my lord, they have to give their credentials. The credentials are linked to the Aadhaar now. Like an OTP does not go to any random person. It goes to the
No
person whose
problem
name is
about it.
there.
That's why we are saying.
Yes, my lord.
The parties are X and Y,
Yes, my lord.
drafted by Z,
Yes, my lord.
but presented by A, who has nothing to do with it.
No, my lord. A might be from the same office, my lord. Now, my lord,
Which office?
my lord, it might be the deed writer's office. It might be the advocate's office.
That is why it should be clear.
No, that I will. So what I'm telling you,
It
my
should
lord,
be
now,
clear
now
as
in the
to-
Kaveri portal, my
And
lord,
also you should see, there's no problem about the self-drafting, self-filing,
Yes,
everything. In fact, you should take an attestation there that it's been self-drafted.
yes, my lord. Yes, my lord.
There should be a column,
Yes, my lord.
because otherwise another issue comes up, registrar told me, that is why I added this clause.
My lord, drafted by the last in the end of the document. My lord. Last sheet is where the fact.
You again,
End of the
National
document.
in the
generic
petition
document
filed by
registration.
Mr. Chaitanya, what he has produced as one of the registered document, there is nothing about drafting by anybody. Either self-drafting illa, lawyer illa, deed writer illa, nothing is there.
Well, that sample, my lord, I do not know what is the source from where my learned friend has obtained it, because if it is a registered document, if it is a format, my lord,
Insofar as what Mr. Chaitanya has filed, he has challenged Annexure A,
yes, my lord.
which
No,
won't
I also, I
which
totally
won't be
agree.
maintainable.
I totally agree.
And none of the other reliefs he has sought for. Insofar as what Ms. Aishwarya has filed, there's a mandamus which she has asked for
Consider
on
the
various
reference.
aspects. And one to consider, two directions.
Direction.
The first one is to consider,
Consider, my lord.
but we are more in favor also of the direction at number 2,
Two,
3,
4
4 also.
to give them the login.
Because that is when you know who is the person who has presented it.
My lord, the
Other
person-
than the,
No, my lord.
My lord, in fact,
Not on this aspect. my lord. Let me tell the procedure. Your lordship is also aware. Now, my lord. Now the Kaveri 2 portal, what is paperless, my learned friend says is, paperless is only to the extent of ancillary documents. Now, my lord, there's a document that is been drafted by me. assuming it's a sale deed as on this day. Who all is involved in a sale deed? There's a vendor, there's a purchaser. Now, my lord, at this juncture, now they want to overcome all this issue, and they want to go paperless with all other documents where they could have tampered. Now, my lord, the document will say
They
whatever.
don't have any problem with you doing it.
Yes.
They don't have any problem with you doing paperless. They're also happy with it. They'll sit at home and present it. They don't need to come to your office. They're no problem. See, if we extrapolate it a little, we permit in e-filing for the court, the lawyer files it or party in person files it. If anybody else were to file it, then Ms. Aishwarya will file in your matter.
Yes. No, my lord.
Mr. Ramesh will file in Ms. Chaitanya's matter.
Yes.
There has to be some.
Yes, my lord. I will answer. My answer is, my lord, here. Paperless does not mean that they don't have to go to the sub-registrar. They'll have to go to the sub-registrar office at one point of time. Now, my lord, what used to happen was before, there's a valuation, steps, valuation, then confirmation. Now, my lord, everything is in the portal. What happens is, my lord, they upload their document. If the portal accepts the document, first of all, if the valuation is correct and all the document. Now, my lord, certain fields, we have made it autofill. Now, my lord, so that this is where the paperless matters. Now, what happens is now the e-Swatu or the Bhumi is linked with the Kaveri portal. Now, what happens is, my lord, certain autofills are there which are imported from that website.
There's no problem about that.
No, correct, my lord. Now, what happens is, my lord, now the documents is accepted for registration. Approval is pending. It's online again. The officer, they don't have to go to the office. The officer there, all those documents, he will. My lord, let me come. I got it, my lord.
But there's no point in getting into all those things.
Correct. Allah, we are at a very thin line, my lord. The only thing is here, my lord, they have come before this court only to monopolize their trade. Now, my lord, there's
I
nothing
don't think
public friendly.
that would be the right way of
I will also get the technical information as to what the reason.
That may not be a right way of looking at it, because some prejudice or some bias cannot come in the way there.
Yes, sir.
If your officers have that bias, that's a different thing. If you're giving them a login, they'll log in as a document writer. That does not take away the person who is presenting it to draft himself and present it. Self is not taken away.
Self is
the
not
lawyer
taken
is not taken away.
Not taken away.
Then
No,
only people who can do it is self or the lawyer or the deed writer, as per
80B.
80B.
Yes, my lord.
Only those people.
Yes, my lord.
Nobody else.
How are their rights being affected?
Where is their this one that they have drafted it? That they are the deed writer.
Have to sign on the document.
Where is it in the e-copy?
My lord, that I will clarify, my lord. That regarding the e-file, what my learned friend.
E-copy, it should be there.
Physically, before scanning, maybe this document as a sample, my friend might have downloaded it. But after the completion, now whether I want to check whether the document, what my learned friend has logically ended into a registration. Now, my lord, the drafting will become only on the
Registration number, everything is there, Mr. Jaffer. It has ended in everything. If there's a draftsman, whether it's a deed writer or a lawyer or self-drafted, that should be there. And their signature should be there. Because otherwise what will happen, I don't know why they have come here. Actually, they should not have come. They could upload it and they would not have been responsible.
Yes. That is the.
No, my lord, that is not.
They are actually coming and creating problems for themselves.
My lord, with due respect to the lawyers who are appearing, that is not the intent. I will file it.
Well, I'll just pass out only the screenshots of the website, national generic document.
Lawyer's name will be there. It will be the deed writer. It will be self, whatever.
We will place it.
When will you place it?
A week's time, my lord, because this matter might be.
That AGA seeks for and is granted a week's time finally to file a statement of objections. Objections, if any, by 20th, relist on 23rd at 2:30 p.m.
The sample may show on the.
File everything, give it to.
Yes.
44, Ramesh N.K.
That is appearance for the respondent passports authority. Criminal cases.
Judgment.
Objections filed.
Only thing is, now, judgment says it is not necessary for the purpose of renewal. But your lordships of the view, that
when you are going out, you have to produce that permission.
I do understand what your lordship has said. I did file an application. But last March, I have filed the application. Applications are not being disposed. That you can make a grievance. That your lordship. Observe, my lord,
Sorry.
the board concerned. Annexure A, F1, my lord. With the application.
Petitioner is
That's a
before.
statement of objection filed. There are three criminal cases. One contempt is also pending. And one,
In all
all were
that, he'll have
suppressed.
to,
No,
No, I filed it, everything.
in all that, he'll have to get permission.
I filed it.
yes. Page number 11, the details are there, my lords. Three cases filed by some other complainant himself.
He has actually given you 4 cases.
Yes, I have given 4 cases. One is before
ಇನ್ನು
the
ಒಂದು extra ಇದೆ. Petitioner is before this court seeking for the following leaves. The application filed by the petitioner for renewal of his passport was not considered. Instead, a communication at Annexure C dated 21st January 2024 was issued stating that there are criminal proceedings which are pending, and as such, permission to travel was sought to be secured and placed on record for the purpose of processing the applications. It is in view of is challenging said endorsement, firstly issued on 15/5/26, 21/6/24 at Annexure C, and the subsequent communication dated 15/5/26 at Annexure E, that the petitioner is before this court. The petitioner, who is a resident, who claims to be a resident of Kodichikkanhalli, Bengaluru, submit that there are 4 petitioner, actually Ramesh, learned counsel for the petitioner, submit that there are 4 criminal proceedings which are pending against the petitioner, namely CC number 15923 of 2017 on the file of the 3rd additional CJM Bengaluru for offences under section 406, 420, 120B, read with 34. Wherein a charge sheet has been laid and the matter is pending trial. Criminal CCC number 5 of 2018 filed before this court regarding criminal contempt, which is also pending trial. LGC number 42 of 2016 pending on the file of the land grabbing court Bengaluru, which has been stayed by this court in WP number 22328 of 2023. Proceeding in CC number 15923 of 2017. Like para 4 is only a.
It's only a bail granted, that's all, no?
Not a 4th proceeding.
Yes, sir.
The submission of Shri Ramesh is that the petitioner has 2 daughters. The elder daughter is in Australia and the younger one is in Canada. And it's for that reason the petitioner intends to visit them once in a while. And as such, a passport is required to be renewed to afford him an opportunity of travel, which is a fundamental right under Article 21 of the Constitution of India. Shri M.N. Kumar Leonard, CGSC, appearing for respondent number 1 to 3, would however submit that without permission to travel in those criminal proceedings, the petitioner cannot be permitted to travel. And it's for that reason that the said permission was requested to be placed on record for the purpose of processing the application. Heard so-and-so, various papers. It is tried law that permission to travel abroad is not a prerequisite for the purpose of consideration of application for renewal of the passport. The permission to travel is required when the petitioner, when the concerned person, in this case, the petitioner, were to travel abroad, and those orders would have to be placed on record either before the FRRO or before the concerned immigration officer. For the purpose of safeguarding the interest of the state, this court normally directs the issuance of a short validity passport, which would put the immigration authorities on notice to secure a copy of the said order to travel abroad so as to permit the traveler to so travel.
It's a case of renewal, my lord. Really?
Renewal adreno ashte. When proceedings are pending. Earlier, people would not go out of the country. Now everybody is going out of the country.
Judgment, my lord, that issue is not adverted to.
Next, para. In that view of the matter, this court is of the considered opinion that the petition cannot be deprived of the renewal of the passport. As such, this court passes the following order. The submission of Shri Ramesh, however, is that since the proceedings in LGC number 42 of 2016 have been stayed by this court in WP number 22328 of 23, that court would not be in a position to take up the application for grant of permission to travel. The stay which has been granted,
Annexure R1, my lord, page 22.
the stay which has been granted is as regard the further criminal proceedings in the matter. The present application seeking for travel abroad would be an incidental matter, which in the considered opinion of this court, the land grabbing court could consider and pass necessary orders, if so deemed fit, permitting the petitioner to travel abroad. ಒಂದರಲ್ಲೇ ಅಲ್ಲ ಅಷ್ಟೇ ಇರೋದು.
ಅಲ್ಲ ಇನ್ನೊಂದು ಸ್ಟೇ ಇರೋದು.
Only in one matter there is.
ಹಾಕಿದ್ದೀನಿ ಅದು ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Only in LGC there is a stay order.
Yes.
The other matter there is no stay order.
There is no stay.
In that view of the matter, this court passes the following order. Writ petition is partly allowed.
So other matters I filed the application. They are not taking it.
Correct. But because of stay, that is the only.
No, not that. Not that case. In a criminal case also I have filed. Now the criminal case.
They want a general direction.
Yes, yes.
Writ petition is partly allowed. Respond number 2 is directed to reissue.
Sir, issue only, there's no concept of reissue now, only issue only. All these things.
A passport for the petitioner, albeit a short validity passport for a period of 1 year.
In terms of OMRs, I have produced annexure R8.
That has been dealt by the Supreme Court. Don't again go back there.
All right, Maharaj. And one more submission, Maharaj. Since there was a criminal case pending under section 62F, it was sought for explanation since he had suppressed. On that ground, it was not that he has not produced the permission, Maharaj. That submission will be corrected as that, Maharaj.
He has suppressed it in the application.
Application itself. Police verification report came, then one of his complainant, he filed a complaint against us in the office. Page number 11 may be seen, Maharaj. Yes.
11. Your objection.
Yes, page number 8, man. Page number 8, it was suppression. We said that Madiwala police have reported adverse remarks pending so-and-so case. We sought explanation. Page number 8, Maharaj. And set no objections.
Yes.
Then
You
page
did not
number
bring it to
11.
notice. You have brought it to
No.
notice of this court, not the passport authorities.
No, page number 11. Somebody filed a complaint to the passport authority against him. Page number 11.
Same complainant who has filed all these
Yes,
cases.
same complainant. He is after me.
He is relative for partition and everything.
Yes.
Maybe it could be so. That's how it has come. It was refused on the ground of section
Albeit
62
for a
F.
short validity for a period of 1 year. Needless to say, the petitioner would have to produce the permission for travel granted by the respective criminal courts at the time of his travel, either to the FRRO or to the immigration officer, so as to permit him to travel. The respective criminal courts seized of the criminal proceeding against the petitioner are directed to process the application filed by the petitioner for travel abroad and pass necessary orders as expeditiously as possible.
My submission will be corrected as we of section 62 F. It was refused, not on the.
It was refused on the ground that the petitioner had suppressed the pendency of criminal proceedings.
Yes, yes. Obliged.
May I make a submission, my lords? At serial number 45, the next matter, my lords, is due to be called.
Yes.
I request for a short accommodation. The counsel on record, my lords, who is arguing, has undergone a surgery.
Have you informed the respondent?
My lords, the respondent is, my lords, the aged.
Lord, in fact, there is.
He's undergone
there is
surgery.
In 45.1, the issue was the accused therein, not the petitioner, is an advocate by profession.
but the enforcement director has has summoned him for his role not as an advocate, but because of his involvement in certain businesses with the main accused. There was an interim stay granted against the summons because the matter was pending before the Honorable Supreme Court. And the interim order very clearly said till the Supreme Court decides. Now on 31st October 2025, that decision is made. So therefore, the interim order is not operating now. So we
I'll
had
have to
sought for
take instructions because
we had filed an application.
or it's the main.
If the order itself is saying that until Supreme Court decides,
But we don't want to face any confusion, which is why we have filed an application formally to make that observation.
I'll file my
If a short
objections.
accommodation is required, can be granted.
I'll file my objections.
when will
to
he
that.
come back?
Next week, 10 days, my lords, because he's undergone a back. He's
Council has undergone a surgery.
back surgery.
He is saying I will file my objection file ಮಾಡಿದ್ದಾರೆ.
He doesn't know anything because the
Council wants some time, that can be given, but later date be fixed. We have some.
in all matters dates are fixed, Mr. Kamath. In which matter don't we give you date?
Yes, I am great.
Let counsel for the petitioner submit that the arguing counsel has undergone a surgery. He seeks fund is granted.
2 weeks, my lords.
2 weeks time.
Please.
Released on 30th July,
Yes, but can it be 27th?
27 July,
28th, my lords.
28th is fine.
28 July.
Obliged.
One matter, my lord.
Yes.
Serial number 51, my lord. I'm for the petitioner.
Interim order earlier granted. 51.
I'm for the petitioner, my lord. This is not for an adjournment. The problem is my project is stuck, my lord, and there is some strict timeline.
So what is your
My lord,
submission?
it may be taken up
In
What
seriatim.
in list 2, my lord.
In seriatim it will be taken up. Yes.
Your Lordship, I'm challenging the police notice, Your Lordship. Last occasion, Your Lordship has granted interim order which was issued by the other police station, Your Lordship. With the same accused, they are again coming to my gold company, Your Lordship. Tomorrow, Your Lordships.
ಸಂಜೀವ್ ಇರ್ಬೇಕು ನೋಡೇ ಬಿಡ್ತೀವಿ ಮತ್ತೊಂದು ನೆನಪಿರಲ್ಲ ಇವಾಗ ಹಂಗ ಯಾಕೋ ಹಂಗ ಆಗ್ಬಿಟ್ಟಿದೆ ಈ ನಡುವೆ ಏನು ನೆನಪಿರಲ್ಲ ಮತ್ತೊಂದು ಅದಕ್ಕೆ ಯಾವ್ದು ನೆನಪಿರಲ್ಲ ಅಂತವನ್ನ ಇಲ್ಲಿ ಹಾಕೊಂಡ್ಬಿಡ್ತೀವಿ
ಅಲ್ಲ ಈಗ ಮಧ್ಯಾಹ್ನ
ಟೂರಿಸಂ ಪರವಾಗಿಲ್ಲ ನೆನಪಿದೆ ನನಗೆ ಬಿ ಎಲ್ ಸಂಜೀವ್ ಇವರೊಬ್ರು ಇದ್ದಾರೆ ಗೀತಾದೇವಿ ಹೇಳಿ ಹೌದು ಹೌದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಕಾಯ್ಬೇಕಷ್ಟೇ ನೀವೇ ತಗೊಂಡೋಗಿ ಕೊಡ್ಬೇಕು ಬ್ರಾಂಚಿಗೆ ಓಕೆ ಇದೊಂದು ಅವ್ರಿಗೆ ಬರ್ಕೊಟ್ಟು ನಾಳೆಗೆ ಅಂತ ಬರ್ಕೊಟ್ಟು ಇಲ್ಲಿ ಬರ್ತಿದ್ಯಾ ಇವತ್ತಿದ್ಯಾ ಬರುತ್ತೆ ಅದೇನ್ ಗೊತ್ತಾ ಪೇಪರ್ ಎಲ್ಲ ಸ್ಕ್ಯಾನ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಸ್ಕ್ಯಾನಿಂಗ್ ಹೋಗಿದಾವೆ ಕೆಲವೆಲ್ಲ ಯಾವ್ದು ಸಿಗುತ್ತೆ ಅದ್ ಹಾಕ್ತಾರೆ ನಿಮ್ದು ಸ್ಕ್ಯಾನ್ ಆಗಿದ್ರೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹೇಳಿ ಮೆಮೊ ಇದೆ ಹಾಕೊಡಿ ಅಂತ ಯಾವತ್ ಕೊಟ್ಟಿದ್ರಿ ನಿಮ್ ಜೊತೆ ಯಾರಾದ್ರು ಬಂದವ್ರ ಅಲ್ಲಿ ಬುಕ್ ಇದೆ ತಗೊಂಡು ಚೆಕ್ ಮಾಡ್ಲಿ ಮೆಮೊ ಕೊಟ್ಟಿದ್ರೆ ಒಂದು ಇಟ್ಕೊಳಲ್ಲ ನಾವೆಲ್ಲ ಕಳ್ಸಿರ್ತೀವಿ ಅದ್ ನೋಡಿ ಫಸ್ಟ್ ಅವ್ರ ಹಂಗೆ ಹೇಳೋದು ದಿನ ಇಷ್ಟು ಮೆಮೊ ಬರ್ತವೆ 200 ಮೆಮೊ ಬರುತ್ತೆ ಎಲ್ಲ ಕಳಿಸ್ತೀವಿ ನಾವ್ ಯಾವ್ದು ಇಟ್ಕೊಳಲ್ಲ ಆಯ್ತು ಹಂಗೆ ಮಾಡಿ ಅವ್ರು ಮೆಮೊ ಕೊಟ್ಟಿದ್ರೆ ಬಂದೇ ಬರುತ್ತೆ ಅದೇ ಇರ್ಲಿ ಅವೆಲ್ಲ ಈಗ ನೋಡಿದ್ರು ನೆನಪಿರಲ್ಲ ಮೆಮೊ ಕೊಟ್ಟಿದ್ರೆ ಬ್ರಾಂಚ್ ಹೋಗಿರುತ್ತೆ ಅವ್ರು ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅಡ್ವೊಕೇಟ್ ನ ಬಂದು ನೋಡ್ಕೊಳಕ್ ಹೇಳಿ ಕೊಟ್ಟಿರೋ ಮೆಮೊ ಅಷ್ಟು ಕಳ್ಸಿರ್ತೀವಿ ನಾವು
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 21 ಆಲ್ರೆಡಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ
ಇಲ್ಲೇ ತೋರಿಸ್ತಾರಲ್ಲ 96 ಇದೇನೇನಾ ಈ 96 ಡೈರೆಕ್ಷನ್ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ರಿಜಿಸ್ಟರ್ ಕಂಪ್ಯೂಟರ್ಸ್ ಹಾಕಿದ್ದಾರೆ ನೀವು ಹಾಕಿದ್ದೀರಾ ಡೇಟ್ ಗೊತ್ತಾ ಅಲ್ಲ ಅದು ಡೇಟ್ ಗೊತ್ತಾ ಅದ್ರ ಜೊತೆ ಸೇರಿಸ್ಬೇಕು ಅಂದ್ರೆ ಅದು ಗೊತ್ತಾ ಫೈಲ್ ಆಗಿ ಇವತ್ತು ಹೊಸದ ಸರಿ ಕೇಸ್ ಕರ್ದಾಗ ಕೊಡ್ತೀನಿ ಇದೊಂದು ಪೇಪರ್ಸ್ ಕೊಡ್ತೀನಿ ಬಿಡಿ
Serial number 57.
ಅದು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀವಿ ಮ್ಯಾಮ್ ರೆಸ್ಪಾನ್ಸ್ 6 to 8 ಇವತ್ತು.
ಇವತ್ತಾ
ಹಾ ಮ್ಯಾಮ್.
ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೇಸ್ ಕರೆದಾಗ ಅಷ್ಟೇ. ಪೇಪರ್ ಇವತ್ತಿಂದ
ಅದಕ್ಕೆ
ಇವತ್ತು ಎಂಟ್ರಿ ಆದ್ಮೇಲೆ ಬರೋದು ನಮ್ಗೆ.
ಹೌದಾ? ಅದಕ್ಕೆ ಕೇಳೋಣ.
ಕೇಸ್ ಕರೆಯೋಷ್ಟ್ರಲ್ಲಿ ಬಂದ್ರೆ ಓಕೆ, ಇಲ್ಲಾಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಕೇಸ್ ಕರೆದಾಗ ಮಾಡಿ.
ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ 2 ಫಸ್ಟ್.
ಲಿಸ್ಟ್
ಥ್ಯಾಂಕ್ ಯು. ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ 2 ಕರೀತಾರಾ ಮ್ಯಾಮ್?
ಹಾ
ಮ್ಯಾಮ್
ಪಾರ್ಟ್ಲಿ ಅಲ್ಲ
ಆಫ್ಟರ್ನೂನ್ ಸೆಷನ್ ಲಿಸ್ಟ್ 2 ಮ್ಯಾಮ್ ಫಸ್ಟ್. ಲಿಸ್ಟ್ 1
ಅದಾದ್ಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಇವತ್ತೇನು ಧಾರವಾಡ ಎಲ್ಲ ಇಲ್ಲ ನಾಗರಾಜ್?
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಕರೀತಾರೆ? ಪಾಸ್ ಓವರ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಕರೀತಾರೆ?
ಬಂದ ತಕ್ಷಣ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅದಾದ್ಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್.
ಹೌದಾ?
ಹುಡುಗಿ ಇಲ್ವಾ ಅವಳು ಪಲ್ಲವಿ? ಪಲ್ಲವಿ ಇದ್ರೆ ಆಗ್ಬಿಡುತ್ತೆ ಕೆಲ್ಸ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ವೇನೋ ಅನ್ಸುತ್ತೆ. ರೀಕಾಲಲ್ಲಿ ಹೋಗಿ ನೀವೇ ಟ್ರೈ ಮಾಡೋದಿದ್ರೆ ನೋಡಿ. ಹ್ಮ್ ಹಾ ಹಾ ಇನ್ನೊಂದ್ಸತಿ ಮಧ್ಯಾಹ್ನ ಕೇಳಿ.
ಮ್ಯಾಮ್ ಮೆಮೊ SPP ಅವ್ರ ಹತ್ರ ಇದೆ ಅಂತೆ, ತಗೊಂಡ್ ಬಂದಿದೆ, ಅದೆಲ್ಲ ಸೇರಿಸ್ಬಿಡ್ತೀನಿ ಮ್ಯಾಮ್. ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಸಾರಿ ಮ್ಯಾಮ್.
ಹೋಗೋಣಮ್ಮ. ಇಲ್ಲ ನಾಗರಾಜ್ ಇವತ್ತು ಧಾರವಾಡ ಏನೂ ಇಲ್ಲ. ಡೈರೆಕ್ಟ್ ಬೆಂಗಳೂರು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಒಂದ್ ಸಾಕು, ಇನ್ನೊಂದು ಮಿಕ್ಕಿದ್ದು. ಸರಿ ಇಡಿ ಖಾಲಿ ಆಯ್ತು. ನೋಡೋಣ, ಹೇಳಿದೀನಿ ಇದು ತಿರ್ಗಾ ಯಾರೋ ಯಾರೋ ತಗೋತಾರೆ, ಲಾಕ್ಲರ್ಕೆ ತಗೋತಾರೆ ಫೋನ್ನ. ಅಲ್ಲ ನಾಗರಾಜ್ಗೆ ಹೇಳ್ತಾ ಇದೀನಿ, ಯಾರೋ ಲಾಕ್ಲರ್ಕು ಇವರೇ ತಗೋತಾರೆ ಫೋನ್ನ. ಅದಕ್ಕೆ ನೀನ್ ಅಲ್ಲಿ ಕೊಡಪ್ಪ, ನೀನ್ ಹೇಳಿದ್ದು ಇದುವರೆಗೂ ಕಳಿಸಿದ್ವಿ, ಬೆಳಗ್ಗೆ 3 ಸತಿ ಹೇಳಿದೀನಿ. ಯಾರಿದಾರೆ ಕೊಡಿ, ಬೇರೆಯವ್ರು ನಿಮ್ಮನ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾರಿದಾರೆ ಕೊಡಿ ಅಂತಂದೆ. ರಮೇಶ್ ಕೊಟ್ರು, ಬೆಳಗ್ಗೆಯಿಂದ ಹೇಳ್ತಾ ಇದೀನಿ ನೋಡಪ್ಪ ಕಳ್ಸಿಲ್ಲ ಕಳ್ಸಿ, ರೆಡಿ ಇದೆ ಫೈಲು ರೆಡಿ ಇದೆ ಅಂತ. ರೆಡಿ ಇರೋದೆಲ್ಲ ನನಗ್ ಬೇಕು ಅಂದಿದ್ದೀನಿ. ನೀವು ಹೋಗಕ್ ಹೋಗ್ಬೇಡಿ, ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಫೈಲ್. ಕೇಸ್ ಕರೆದಾಗ ಹಂಗೆ ಹೇಳ್ತೀನಿ ನಾನು. ಸುಮ್ನೆ ದೊಡ್ಡ ದೊಡ್ಡ ಬಂಡ್ಲಿ ಯಾಕೆ ಹೊಡ್ತೀರಾ? Serial number 1, P. Shailaja, party in person.
Yes, CCTV footage.
Lord, can I request for a pass over? My colleagues handling this matter.
Pass over.
Serial number 2, K. Ravindranath, connected matter.
So Ravindranath. Pass over.
Serial number 3, G. Suresh.
For the petitioner in this case, senior suffering from illness, short adjournment.
This-
Maybe 15th.
You want to file any objections or you are ready?
I'm ready, my lords.
Ready.
There was some page number difference was there, so.
Last time, previous.
ಇವತ್ತು ಅಜ್ಜನ್ ಆದ್ರೆ ಲೇಟ್ ಆಗುತ್ತೆ ನೀವು ಲಿಸ್ಟ್ ಆದಾಗ you should be able to take it up. The request of counsel for the petitioner released on 6th August.
15th, 20th, this month, 20th.
20th, there are already 126 matters.
6th.
Every day of that month, that week till the end of this month, there are 100 matters.
One submission, Lordship, if it can be taken up early because the trial is getting delayed.
Every day there's 100 matters.
I leave it to you.
So, if we list it, it may or may not reach. That is why.
These two only, Lordship.
Oh, this is no petitioner. Okay. List on 23rd at 2:30 p.m.
This one, Lordship.
23rd.
Please, please.
22nd, 22nd one.
22nd, there are too many matters.
22nd.
23rd, there are a little lesser. 23rd or 24th?
Both date is better.
24th ಕಷ್ಟ ಆಗುತ್ತೆ.
20,
28th or 29th?
28.
Please.
28.
28.
Finally, my lords.
Yes,
Serial number 4, K. Ram Singh.
Application filed for the 227 was dismissed in the lower court now. 482. This is 376 promise to marry against accused number 1, Lord. These two petitioners are wife and son of accused number 1.
Yes.
I produced the copy of
Accused 2 and 3.
These 2 and 3, Lord.
You are for the complaint.
That's not 2 minutes.
Ready?
I will file objection statement.
Objections in 482.
It's a serious offense committed against me, my lord.
Offense against accused number 1 is promise to marry. 53 days into delay in filing complaint. The allegation against this
promise to marry, you continue against the person who promised.
Please.
Why the mother
and son, Lord.
No, the major allegation is that they have threatened me to vacate the locality itself, my lord. They came near the house and threatened to go out of the area, my lord.
Incident took place on 24/7, Lord.
Against them.
Like she files the complaint on 59/2000 after the lapse of 53 days, Lord.
in all these matters, there is a delay because expectation of marriage is still there.
Allegation accused number 1, Lord. The wife and son, Lord, who is a graduate, pursuing further post graduation. For the allegation against complaint is in page number 30.
Who is accused number 1?
Is the husband of the accused number 2.
He is the one husband and
He is the husband of accused number.
Yes, my lord.
He is already married.
No, she is also married. This is third marriage.
And then you promise to marry.
It is the case of the prosecution. It is the case of the prosecution, Lord.
Respondent seeks to and is granted.
2 weeks.
Lord, so far the accused number 2, 3 is concerned, Lord.
Objections, if any, by 29th, relist on 4th August.
Lord, allegation against 2 and 3 is the wife and son, Lord. Unnecessarily, they have been implicated in this. She has also got married. This is third marriage. She wanted to marry him.
Let him file his objections.
Serial number 5.
Date in? Date in?
Short accommodation.
Request of counsel for the petitioner released on 4th July, August.
Please.
Serial number 6.
Next week, 23rd.
4th August, please. Next.
Please.
Krishna S. Vyas.
Appearing for the petitioner, my lord, sir. Lord, sir, this is a case in which, my lord, sir,
Notice is
petitioner.
not gone. They not made process, payment of process fee.
Yes, the government has taken the notice, my lords, in
What
the,
about for respond number 2?
I will do the needful, my lords, sir. In the intergram, my lords, sir, so far as all these matters are concerned, my lords, sir, they arise out of the same transaction, my lords, sir. That is, there is an allegation as against the petitioner that she has involved in manipulating the marks cards which are issued to the parties. However, my lords, the department themselves have agreed before the authorities that the marks cards have been issued by the department. There is no manipulation, my lord. The one part of it. Second part of it is that she was not in the tabulation process at all of the marks cards.
You can appear for respond number 2. Serial number 6. Disciplinary authority.
It is the
operation
government, my
maintenance,
lords.
BESCOM is there.
BESCOM, my lord.
You will appear.
No, no, there's a council, my lord.
Council is there.
Who will appear for BESCOM?
Sumana Naganand.
Ms.
Chandrachud
Sumana
had
Nagan.
been given notices, my lords, in other matters. She Chandrachud had been given notices.
H.
For
Chandrachud.
BESCOM.
H. Chandrachud appears for BESCOM also.
Yes, please, my lords.
H. Chandrachud is directed to accept notice for respond number 2. 6.1, same for respond number 2. IA 3 of 26 is allowed. 6.2, Sri H. Chandrachud is directed to accept notice for respond number 2, and there would be no requirement to make payment of any process fee in respect to respond number 2. 6.3, H. Chandrachud for respond number 3. IA 1 of 26 is allowed. IA 2 of 26 is allowed.
Lord, 6.1, my lords, that the government is the complainant there. Joint Director of Department of Employment and Training.
Who is the second respondent, Mr. Counsel? 6.1.
6.1.
6.1 could you?
Second respondent is the government, my lords, there.
Joint Director, Director of Industrial Training and Employment.
And 6.2 also a government, my lords.
And AGA accepts notice. 6.1, and AGA accepts notice.
6.2 also government, my lords.
ಒಂದು ನಿಮಿಷ ಇರ್ರಿ ಒಂದೊಂದು ಮಾಡಕ್ ಬಿಡಿ.
I'm sorry, my lords.
Why are you in such a hurry?
Yes, my lords. I'm sorry, I will plead apology.
That SPP accepts notice for respond number 1. That AGA accepts notice for respond number 2. 6.2 could you? A for respond number 1. SPP for respond number 1, AGA for respond number 2. 6.3. Yeah, AGA na? AGA for respond number, illa idu BESCOM idu.
BESCOM is 6.3, my lords.
6.3. H. Chandrachud for respond number 2. IA 1 and IA 2 allowed. Serve counsel for the petitioner to serve 2 sets of the petition along with annexures on the aforesaid counsels. Released on 4th August.
My lords, in the intergram, my only prayer is this, my lords, sir. All the 4 transactions arise out of the same
Yes,
cases
we have
arise
not
out of-
granted you relief in the earlier one because you are in charge of the entire thing. We'll hear them and then consider it.
No, I'm only asking for this, my lords, sir, that let the matters be connected and let them not precipitate until the matters are connected, my lords, because only one proceedings would be entertainable.
How many more are there?
There are already 4 matters, my lords, only 4 matters. sir.
Only
But
4
at
matters,
different
we'll
corners.
consider it on 4th. We'll consider it on 4th.
Yes, please. Much obliged.
Serial number 7.
If there are any more matters, you give us those numbers, we'll connect it.
7.
Mr. Latif.
Split up case, my lord. The petitioner, co-accused has been acquitted by the trial court, my lords. And further, my lords, A7, as far as A7 is concerned, my lords, kindly peruse page number 95. This honorable court has considered the same as quashed the proceedings, my lords.
You are A1.
Please, my lords. Accused number 3 and 6 has been acquitted, my lord. From the.
This is coming up for the first time.
Please, my lords.
Yes.
My lord, yes, we'll take
Receive.
notice, my lord.
My lords, notice has been issued, my lords, in the
Notice
last hearing.
agide.
Agide, sorry.
Yes, my lord. This petitioner is
All
main
the
accused, my lord, accused number 1. He is, my lord, having 31 other cases apart from this, my lord. He is habitual offender. Therefore,
As
And
far as
SCGP
this-
6 fund is granted 2 weeks time, released on 4th August.
My lords, at least stay may be granted, my lord. My lords, all the witnesses
But
stand.
31 cases is what he is saying. In the
Have
face
to-
of 31 cases, do you want us to?
Let
grant you a
them,
stay?
let them furnish that.
yes, I have
They'll
having
furnish
details.
it.
Please,
He's making a submission with responsibility only.
please. Date.
4th August. Serial number 8. Varun J. Patil, connected.
Professor Kumar, yes.
May I please? Here for the.
So now these are the only two matters which are pending.
Please.
Yes, please.
What is questioned in this writ petition is the exercise of power under section 27 capital A
Yes.
by appointing an administrator. After that, 3 orders have subsequently issued extending the term
Yes.
on different grounds. Why it is extended is on different grounds. Now, before coming to that aspect of the matter, I want to state one fact, namely on 13/1/2026, the inquiry was completed and the report was presented. And in the report, may I request the court to kindly take my statement of objections.
13/1/26 inquiry was completed.
Inquiry report is presented. Kindly permit me to show from the list of dates.
Yes, please. List of dates, you have filed a separate list of dates?
Yeah, 32,600.
When did you-
Objections are filed.
When did you file that?
This was filed on 1/8/7.
8/7. Lydia. Yes, please. Statement of objections.
Yes.
The list of dates in the statement of objections?
Filed by respondent number 5.
Yes.
Yes. Kindly come to page number, I've given the chronological order as how various steps are taken and inquiry was ordered. Various writ petitions that were presented are also referred to. Kindly come to page 5.
5.
Page 5.
Yes.
14/1/2026. With a covering letter dated 14/1, the 13/1 report was presented to the government. This is an inquiry under section 25. That inquiry has been completed. And permit me to show from item 26 in the list of dates. The state government has also placed it before the court. I'll refer to it in a minute. Surcharge proceedings are initiated against the petitioner and other office bearers of the society to recover a sum of 7,42,88,000.
Have you placed that on record?
Yes, a statement of objections is there.
Page number?
By the government. State has filed it. Since it is already there, I didn't.
State objection of the
In the state subjection dated 19/6.
19/6.
So this report of 13/1.
19/6/26.
Yes, 19/6/26. The learned advocate general also argued on the
Yes.
basis.
19/6.
Yes, kindly come to page 7. Page 7 of the statement of objections. before the Deputy Registrar of Cooperative Societies, Kannada Sahitya Parishatu is the petitioner, and the petitioner is the first respondent and 3 other office bearers of the society.
President, Secretary and Treasurer.
Yes.
Vice President is not there.
Kindly come to page 22.
Yes.
The entire entire petition sets out the criminal liability and the civil liability of the petitioner in misappropriating or misapplying or violating the rules and regulations or causing loss to the Kannada Sahitya Parishad.
Yes.
It is reinforced by the audit reports. Kindly come to page 22. I will not trouble the court with the body of the.
Yes.
There is a tabular statement in respect of the 5 charges that are proved against the petitioner and other office bearers. A sum of rupees 7 crores 42 lakhs 88,000 is to be recovered. So that is the proceeding which is now pending consideration. It is yet to be finalized. The proceedings are on. Now, what is very important to take note of is the inquiry report is not challenged by the petitioner at any point.
Not been challenged.
Not challenged.
Of 13-1-26 is not
Yes.
challenged. By petitioner, secretary and treasurer, all 3.
No, none of them has
None of
challenged.
them.
None of them has challenged.
Yes.
As could be seen from the list of dates, on 23/1 at item 24, notice was served on the petitioner that such an inquiry report has come. What have you got to say? On 24/1.
Yes.
Yeah. Serial number 24 in the list of dates at page 5. My statement.
To all 3 it was issued or only to the petitioner?
Sorry?
To all 3 or only to the petitioner?
I think it is to all the 3.
Yes.
So petitioner was notified.
To dates is as if it is only to the petitioner and then everything is only to the petitioner.
I owe a duty to the court. I should have reported that it is taken against others. So I don't have the copy. I'll place it before. Be that as it may, he has responded to it. He has responded to it, and he demanded a personal inquiry. He submitted an elaborate statement. Then he demanded a personal inquiry, personal hearing. That was also given. Several adjournments were given, and finally, now an order has been passed on 8/6. On 10/6. That order is placed, by which he has been placed under suspension. Kindly take the order of suspension. I want to just show the conduct of the petitioner. Page 23 is the order of suspension, where the charges leveled against him are set out in detail, and the findings of the inquiry officer is also recorded. And then what is the finding of the administrator on after the inquiry on the basis of the notice issued to him is also. Out of 17 charges leveled against him, 15 related to, 7 related to financial misappropriation or financial wrong handling, serious misconduct. relating to it. I'll not trouble the court with all the details. Just permit me to show chart number 6 at page 25.
Yes.
At page 25. ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಕಟ್ಟಡ ನಿರ್ಮಾಣದಲ್ಲಿ ಆಗಿರುವ ಅವ್ಯವಹಾರದ ಬಗ್ಗೆ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯವರು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ಎಲ್ಲ ಕಾಮಗಾರಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸಲ್ಲಿಸಿರುವ ವರದಿಯಂತೆ 3,76,73,000 ಎಟ್ಸೆಟ್ರಾ ಗಳ ಕಾಮಗಾರಿಗಳನ್ನು ನಾನ್ ಶೆಡ್ಯೂಲ್ ರೇಟ್ ನಲ್ಲಿ 44 ಲಕ್ಷ ಎಟ್ಸೆಟ್ರಾ KTPP ನಿಯಮ ಉಲ್ಲಂಘಿಸಿ ಕಾಮಗಾರಿಗಳ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದು ಹಾಗೂ ಕಾಮಗಾರಿಗಳಲ್ಲಿ ಅಳತೆ ವ್ಯತ್ಯಾಸದ 65 ಲಕ್ಷ ರೂಪಾಯಿನ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಿರುವುದು ಸಾಬೀತುಗೊಂಡಿರುತ್ತದೆ. This is established. This is proved. Then, very important. This is a huge amount of mishandling, 3,76 lakhs. Then come to indictment number 8, ವಿಚಾರಣಾಂಶ 8. This is directly against the petitioner only. What has he done? ಶ್ರೀ ರವೀಂದ್ರ ಕುಲಕರ್ಣಿ ಅವರು ಹಾವೇರಿಯಲ್ಲಿ ನಡೆದ 86ನೇ ಅಖಿಲ ಭಾರತ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಸಮ್ಮೇಳನಕ್ಕೆ ವಿದೇಶದಿಂದ ಅವರ ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ಆಗಮಿಸಿದ್ದು, ಕೈಂಡ್ಲಿ ಮಾರ್ಕೆಟ್ಸ್, ಅವರ ಸ್ವಂತ ಖರ್ಚಿನಲ್ಲಿ ಆಗಮಿಸಿದ್ದು ಅವರ ಹೆಸರಿನಲ್ಲಿ 2,57,530 ರೂಪಾಯಿಗಳ ಬಿಲ್ ತೋರಿಸಿ ಹಣ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿರುವುದು. So what he has done is, he has made a false claim as if Ravindra Kulkarni had sought purchase of tickets, though Ravindra Kulkarni had come because he felt honored that there is an invitation from Kannada Sahitya Parishad. So he came on his own, spending money. And the petitioner is accused of making a false claim in Ravindra Kulkarni's name and collecting this amount of 2 lakhs. And then second charge in the same this thing. ಮಂಡ್ಯದಲ್ಲಿ ನಡೆದ 87ನೇ ಅಖಿಲ ಭಾರತ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಸಮ್ಮೇಳನಕ್ಕೆ ಸಮ್ಮೇಳನದ ಆಹ್ವಾನ ಪತ್ರಿಕೆ ಮುದ್ರಣ ಮತ್ತು ಸನ್ಮಾನಿತರಿಗೆ ಸನ್ಮಾನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸಾಮಗ್ರಿಗಳ ಖರೀದಿಯಲ್ಲಿ ಒಟ್ಟು 86,57,000 ರೂಪಾಯಿ ಹಣ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿದ್ದೀರಿ. This is also established. There are 2 charges in item 8, indictment 8, and both of them are proved. And kindly come to one more. I'll just show one more this thing. I'll not trouble the court with the other allegations, very serious allegations. ವಿಚಾರಣಾಂಶ 14.
Yes.
ಬಹರೈನ್ ಕನ್ನಡ ಭವನದ ಉದ್ಘಾಟನಾ ಸಮಾರಂಭದಲ್ಲಿ ಒಂದು ಇವೆಂಟು, ಅಮೆರಿಕದ 12ನೇ ವಿಶ್ವ ಅಕ್ಕ ಸಮ್ಮೇಳನದ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು ಭಾಗವಹಿಸಲು 2ನೇ ಇವೆಂಟು, ವಿಮಾನ ಟಿಕೆಟ್ ಮತ್ತು ವಸತಿ ವ್ಯವಸ್ಥೆ ಇವೆರಡರ ವೆಚ್ಚವನ್ನು ಸದರಿ ಸಂಘದವರೇ ಭರಿಸಿದ್ದರೂ ಸಹ ಪರಿಷತ್ತಿನಿಂದ ವಿಮಾನ ಟಿಕೆಟ್ ಮತ್ತು ವಸತಿ ವ್ಯವಸ್ಥೆ ಇವೆರಡರ ವೆಚ್ಚವನ್ನು ಪಡೆದಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. 2 distinct charges, they are proved that he has made a false claim, though the organizers had provided the hospitality and the tickets on both the occasions. And the third one, next charge in the same item, 2022-23, 24-25 ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು ವಿದೇಶಿ ಪ್ರವಾಸಕ್ಕಾಗಿ ಸರ್ಕಾರದ ಅನುಮತಿಯನ್ನೂ ಪಡೆಯದೆ ಕ್ರಿಯಾ ಯೋಜನೆ ಹಾಗೂ ಉದ್ದೇಶಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಒಟ್ಟು ಮೊತ್ತ 26,70,000 ರೂಪಾಯಿಗಳನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. This was a grant made to the Parishad for very specified projects. Now that fund he has diverted for his own personal aggrandizement.
For foreign travel.
Yes. So like this, 15 charges are proved out of 70. Now the short question before the court is, should such a man should be reinstated as president at a time when surcharge proceedings are pending and action has been taken on the report and even before it is adjudicated. That is one preliminary objection I have for the, though the report is not the subject matter of the writ petition. I request the court
Because
to
the
kindly
report
take
is subject
judicial note
matter,
of.
not the suspension is
No.
subject matter.
I take the court to.
Challenge?
6086 suspension is
In
challenged.
the other matter. Yes.
So that is the preliminary objection. Second objection, this is a preliminary objection. Kindly permit me to show from the scheme of the act under section 27 capital A.
Yes, please.
Notwithstanding anything contained in this act, where any society on account of pendency of litigation or otherwise has not held or is unable to hold the general body meeting, that is established. General body meeting has not been held.
No, but this is on account of pendency of litigation. Otherwise.
Litigation, etc. Then kindly come to clause C, where
When
on
was
a
the
report,
last meeting held?
Sorry?
When was the last annual general meeting held?
Last annual general body meeting.
The Advocate General was only insisting on clause
No,
C.
in fact, that was
You are
itself,
insisting on clause
that was a subject matter of another writ petition. And he obtained an interim order. He was permitted to go ahead with the general body meeting, but the general body meeting was not held. I think my learned friend.
General body meeting was not held, Your Lordship. Permission was sought from this honorable court to conduct the general body meeting. Then one particular place was fixed and general body meeting could not be held over there. It was shifted to another place, Your Lordships. By then this litigation started and the writ petitions were filed.
When was the last?
Last year, Your Lordship, 2024.
24.
25 was supposed to be held, Your
So you are
Lordships.
pressing into service clause A also.
Yes.
Because the Advocate
General
General
body
only
meeting
pressed
has
into
not been held.
clause C.
Yeah. Clause C also is there.
Clause C.
Clause C was invoked, but the fact of the matter is, notwithstanding the protection given by this honorable court in an earlier writ petition to hold the general body, he did not hold the general body.
Yes.
So now that position stands, it is not a disputed fact.
Last AGM was 2024.
Yes. No AGM has been held for the current year, as a result of which 27A, the ground available, though I very respectfully submit, this is not a ground taken in the order which is challenged, but this honorable court can take judicial note of this fact.
Whatever is there in the order only. Because even the Advocate General only pressed into service 1C, not 1A. Only first time you are taking up 1A.
I respectfully submit that this is also a fact which can be taken judicial note of. I leave it there. I will not press. Then C is pressed and an order is made. What is the order made? Appoint an administrator for such society for such period not exceeding 6 months. Now that order is made. Now this was made in September last year. It has been extended from time to time. 4 times it has been extended. And
Fourth order was 1/7/26.
Yes.
For purpose of holding elections.
Yes. Under the scheme of the act, the only provision which deals with this, the only provision which deals with a situation after appointment of the administrator is that clause 3, on the appointment of the administrator under clause 1 and during the period of such appointment, the governing body of the society shall cease to exercise any powers and perform and discharge the functions and duties, etc. So that has happened from September 2025.
Yes.
Till now, that is the position. Now what next? Under the scheme of the Act, kindly come to clause 4. The administrator shall, before the expiry of the period of this appointment, take necessary action to convene the general body meeting of the society and hold elections for the constitution of the governing body. Now this step, the administrator has already initiated, that I have placed before the court, because returning officer has to be appointed, and that step the petitioner has already taken by a communication to the government, which I have placed before the court. Statement of objection to legal. In the connected matter, I placed that communication as annexure 2B.
6806.
After giving details chronologically of all the developments after the appointment of the administrator and not holding the general body, para 7 may kindly be perused. At page 15.
Yes.
ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ 2021 ಅಧ್ಯಕ್ಷನ ಚುನಾವಣೆಯಲ್ಲಿ ಸ್ಪರ್ಧಿಸಿ ಗೆದ್ದ ಕೇಂದ್ರ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು, ಜಿಲ್ಲಾ ಅಧ್ಯಕ್ಷರು, ಗಡಿನಾಡು ಘಟಕಗಳ ಅಧ್ಯಕ್ಷರನ್ನು ಒಳಗೊಂಡ ಕೇಂದ್ರ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ಅವಧಿಯು 24/11/2021 ಅಸ್ತಿತ್ವಕ್ಕೆ ಬಂದಿದ್ದು 23/11/2026 ಮುಕ್ತಾಯವಾಗುತ್ತಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ನಿಬಂಧನೆ 22 ಈ ಕೆಳಕಂಡಂತೆ ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ವಾಟ್ ಡಿಡ್ ದಿ ಬೈಲಾ ಸೇ? ದಿ ಬೈಲಾ ಸೇಸ್ ಕೇಂದ್ರ ಚುನಾವಣಾ ಅಧಿಕಾರಿಯನ್ನ ನೇಮಕಾತಿ. ಕೇಂದ್ರ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಪರಿಷತ್ತಿನ ಘಟಕಗಳ ಅಧ್ಯಕ್ಷರ ಅಧಿಕಾರಾವಧಿ ಕೊನೆಗೊಳ್ಳುವ 6 ತಿಂಗಳ ಮೊದಲೇ ಕೇಂದ್ರ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ಅನುಮೋದನೆಯೊಂದಿಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಆಯಾ ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆ ನಡೆಸಿಕೊಡಲು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಸೇವೆಯಲ್ಲಿರುವ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಹಿರಿಯ IAS ಅಧಿಕಾರಿಯೊಬ್ಬರನ್ನು ಮುಖ್ಯ ಚುನಾವಣಾಧಿಕಾರಿಯನ್ನಾಗಿ ನೇಮಕ ಮಾಡುವಂತೆ ಸರ್ಕಾರದ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ವಿನಂತಿಸಿಕೊಳ್ಳತಕ್ಕದ್ದು ಅನ್ಕೋಟ್ ಎಂದು ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿರುತ್ತದೆ. ನಿಬಂಧನೆಯ ಪ್ರತಿ ಎನ್ಕ್ಲೋಸ್ಡ್. ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಚುನಾವಣೆಯನ್ನು ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ನಿಬಂಧನೆಯಂತೆ ಚುನಾವಣಾ ದಿನಾಂಕ ನಿಗದಿಗೊಳಿಸಿ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಬೇಕು. ಚುನಾವಣೆ ನಡೆಯುವ 90 ದಿನಗಳ ಮೊದಲು ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಜಿಲ್ಲಾ ವಿಭಾಗಗಳಾಗಿ ವಿಂಗಡಿಸಿ ಕೇಂದ್ರ ಪರಿಷತ್ತಿನ ಕಚೇರಿಯಲ್ಲಿಯೂ ಜಿಲ್ಲಾ ಗಡಿನಾಡು ಘಟಕಗಳಲ್ಲಿಯೂ ಪ್ರಕಟಿಸಬೇಕು ಎಂದು ನಿಯಮವಿರುತ್ತದೆ. ಇಡೀ ವಿಶ್ವದಲ್ಲೇ ಅತಿ ಹೆಚ್ಚು ಆಜೀವ ಸದಸ್ಯರನ್ನು ಒಳಗೊಂಡ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತು ಮತ್ತು ಕನ್ನಡ ಸಾರಸ್ವತ ಲೋಕದ ಒಂದು ಪ್ರತಿಷ್ಠಿತ ಸಂಸ್ಥೆಯಾಗಿದ್ದು, ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಆಜೀವ ಸದಸ್ಯರುಗಳು 31 ಜಿಲ್ಲೆ, 6 ಗಡಿನಾಡು ಘಟಕ ಹಾಗೂ ವಿದೇಶಗಳಲ್ಲಿಯೂ ಸೇರಿದಂತೆ ಪ್ರಸ್ತುತ 4,05,000ಕ್ಕೂ ಅಧಿಕ ಹೆಚ್ಚು ಆಜೀವ ಸದಸ್ಯರಿರುವ ಸಾಹಿತ್ಯಿಕ ಸಾಂಸ್ಕೃತಿಕ ಸಂಸ್ಥೆಯಾಗಿದೆ. 31 ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಜಿಲ್ಲಾ ಅಧ್ಯಕ್ಷರು, 6 ಗಡಿನಾಡು ಘಟಕಗಳಲ್ಲಿ ಗಡಿನಾಡು ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಸದರಿ ಘಟಕಗಳಲ್ಲಿಯೂ ಕೇಂದ್ರ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷರನ್ನು ಚುನಾವಣೆ ಮೂಲಕ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತು ಅತಿ ಸೂಕ್ಷ್ಮ ಹಾಗೂ ತೀವ್ರ ಪೈಪೋಟಿಯಿಂದ ಕೂಡಿರುವ ಚುನಾವಣೆಯಾಗಿದ್ದು, ಅತ್ಯಂತ ಪಾರದರ್ಶಕತೆಯಿಂದ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಬೇಕಾಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ನೂತನ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಗೆ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಲು ಚುನಾವಣಾ ಅಧಿಕಾರಿಗಳನ್ನು ನೇಮಕ ಮಾಡಿ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಿಕೊಡಬೇಕೆಂದು ಕೋರಿದರು. This was sent to the government on 8/6, more than a month ago. And the government should state what action the government has taken on this. So it is in these circumstances, that is the only course open once an administrator takes charge.
That order is set aside.
Even
and
if the order
everything
is set
post-
aside, my very respectful submission is, the only course open is to direct an election to be held.
Your submission, you're putting it at higher level. That once an administrator is appointed, election is the natural consequence.
That is, no, once he takes charge, no, it is permissible for this honorable court to interject such an appointment and prevent him from taking charge.
Even if he has taken
That,
charge.
that did not happen. I very respectfully submit. That did not happen. Even then, this honorable court has made it clear that it is subject to the result of the writ petition. My plea before the court is, in these circumstances, this is not a fit case to exercise.
One thing about facts is different.
Yeah.
That this is not a fit case to exercise. That is one part of
on
it.
facts and in the scheme of the
But-
act. Now kindly imagine, I have also placed before the court the illustrious history of this society.
No, on
Page
a-
19
on a-
of my
on a
objection.
Point of law, if
I-
that
I-
point of law is
yes,
once an
I want to
administrator is
state the-
appointed and no interjection,
Now,
20.
the reason why I'm stating this is permitting him to come back to the office. Now, what should happen to the surcharge proceedings that are taking place
No,
again?
on facts is a different thing. We are not
Yeah.
on the facts of it.
Therefore-
Facts you have already argued.
Yeah.
Your other submission, Professor Kumar, is that once an administrator is appointed and he has taken charge, the natural consequences to have an
So
election.
here, that has been
Maybe a little
circumscribed
too
by the condition imposed in the interim order, that it is subject to the outcome. Therefore,
Even
I would not
otherwise.
stretch it further.
Even if the interim order did not have it,
Yeah.
if this court were to set aside the appointment of an administrator, it will revert to what it was earlier.
That should have been the necessary
Not that it
consequence.
will naturally progress to election.
Necessary
And
consequence.
has that been dealt with in any matter, any judgment on that, any issue?
No, this scheme of the act, I'm canvassing for the first time. I did not find any authority on the proposition. Once an administrator comes to the office and the governing body ceases to exist, the language is ceases to exist and function. Can it be revived after the disposal of the case in the event of the petitioner
That
succeeding?
argument were to be accepted, then that will be concentrating of too much of power in the state. Appoint an administrator, everything is done over. That would be
If
too
I may
high
say
a-
so with respect, now this aspect has come into consideration when the president's rule was imposed and the state governments were dissolved. Now, in India, it has never happened that a dissolved assembly was reinstated or the dismissed government was reinstated. It has never happened. But I should also bring it to in Pakistan, it has happened. Pakistan court did exercise judicial review power to restore the parliament to its office. Now that has happened in parliament, but in Pakistan, not in India. In India, it has never been. No, I just wanted to bring it on factual aspects. Kindly see 19, para 19
19
of my statement of objections.
in which matter?
The current one, 32,600.
32,600. Yes, please. Para 19.
Yes, page 19.
Page 19.
Page 19.
R51.
R51.
Yes.
The Parishad was established on 5/5/1915. From then onwards, kindly see the names of illustrious literary giants of Kannada who have held this office with great honor, dignity, and reputation. Not a single case where a president was subjected to surcharge proceedings for recovery or financial misconduct. It is that image of the Parishad that is in question. Most of them were Diwans. Kantaraj IRS was a Diwan. Kantirava Narsimraj Wadiyar was a prince. H.V. Nanjandaya himself was a Diwan. I find one judge, Nyayamurthy Lokur Narayan Rao,
Serial number?
serial number 11.
11.
I wonder he was related to the former Supreme Court Judge Justice Lokur. Masti Venkatesh Iyengar has written. So this is the, I have given the brief history also. Next page, page 20. I will not trouble the court. Court may kindly peruse the illustrious history of this. Just two paragraphs I will read at page 21. ಕರ್ನಾಟಕದ ಎಲ್ಲ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಪ್ಯಾರಾ 4 ಕರ್ನಾಟಕದ ಎಲ್ಲ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಪರಿಷತ್ತಿನ ಜಿಲ್ಲಾ ಘಟಕಗಳು, ತಾಲೂಕು ಘಟಕಗಳು, ಹೋಬಳಿ ಘಟಕಗಳು ಅಧಿಕೃತವಾಗಿ ಅಸ್ತಿತ್ವದಲ್ಲಿವೆ. ಸಾಹಿತ್ಯಿಕವಾಗಿ, ಸಾಂಸ್ಕೃತಿಕವಾಗಿ ನಾಡಿನಾದ್ಯಂತ ಚಟುವಟಿಕೆ ನಡೆಸುತ್ತಿವೆ. ಸಮ್ಮೇಳನ, ಗೋಷ್ಠಿ, ಸ್ಪರ್ಧೆ, ಉಪನ್ಯಾಸ, ವಸಂತ ಸಾಹಿತ್ಯೋತ್ಸವ, ಸಾಹಿತ್ಯ ರಚನಾ ತರಬೇತಿ ಶಿಬಿರಗಳು, ಪರಿಷತ್ತಿನ ಸ್ಥಾಪನಾ ದಿನಾಚರಣೆ, ಪ್ರತಿಭಾ ಪುರಸ್ಕಾರ, ರಾಜ್ಯೋತ್ಸವ ಇತ್ಯಾದಿ ಕಾರ್ಯಕ್ರಮಗಳು ನಿರಂತರವಾಗಿ ನಡೆಯುತ್ತಿವೆ. ಕೆಲವು ಜಿಲ್ಲೆಗಳಲ್ಲಿ ನಿವೇಶನಗಳಿವೆ. ಜಿಲ್ಲಾ ಸಾಹಿತ್ಯ ಭವನಗಳು ಅನೇಕ ಕಡೆ ನಿರ್ಮಾಣವಾಗಿವೆ, ನಿರ್ಮಾಣಗೊಳ್ಳುತ್ತಲಿವೆ. ಜಿಲ್ಲಾ ಘಟಕಗಳ ವತಿಯಿಂದಲೂ ಪುಸ್ತಕ ಪ್ರಕಟಣೆಯಾಗುತ್ತಿದೆ. ಪರಿಷತ್ತಿನ ಚಟುವಟಿಕೆ ಹೊರ ರಾಜ್ಯದಲ್ಲಿಯೂ ಹರಡಿದ್ದು, ವ್ಯವಸ್ಥಿತವಾಗಿ ಕನ್ನಡ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹಮ್ಮಿಕೊಳ್ಳಲು ಅಧಿಕೃತ ಗಡಿನಾಡದ ಘಟಕಗಳನ್ನು ರಚಿಸಲಾಗಿದೆ. ಮಹಾರಾಷ್ಟ್ರ, ಕೇರಳ, ತಮಿಳುನಾಡು, ತೆಲಂಗಾಣ ಮತ್ತು ಆಂಧ್ರ ಪ್ರದೇಶಗಳಲ್ಲಿ ಯಶಸ್ವಿಯಾಗಿ ಅವು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿವೆ. ದೆನ್ 70,000 ಪುಸ್ತಕಗಳನ್ನ ಪಬ್ಲಿಷ್ ಮಾಡಿರೋದು ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಬಂದಿದೆ. So achievements of the Parishad also is placed on record for consideration. So it is in these circumstances I fully adopt the arguments of the learned Advocate General on the validity of the order appointing the administrator and submit that the petition should be treated as having become infractious in the light of the administrator taking charge and discharging the duties, and thereafterwards the inquiry proving that the petitioner is guilty of 15 of the 17 charges that were leveled, 7 of which are financial irregularities. Yes, these submissions. So far as the other matter is concerned, that relates to the suspension order. There is a technical defect in on the main matter. I have filed the objections. Subsequently, my learned friend has made an application for
What had happened
amendment.
was, first they suspended me, then they withdrew the, first they removed me from membership. I challenged that, your lordships. I filed an IA and amendment. Then subsequently they withdrew that order and they suspended me. So my first IA of removal will become will not survive in view of the subsequent suspension, your lordships.
That's only the IA. The main matter is still there.
Please, please.
Yes.
On that, I could not file my objections to this. Last, there is a mistake on my part. I'm sorry.
Together,
I
will
owe-
you file your objection?
I owe an apology for that lapse. Give me a short time, I'll file the objection.
This was mentioned last time when the arguments were going on. That's how it got connected.
Please. My lords raised
Director,
a
Kannada and Cultural Department and also administrator. Then Karnataka Sahitya Parishad.
ಎರಡಕ್ಕೂನು
Recommended by its
The very validity of the.
Lordships, the
What
order
is
was
this
passed
array
by
of
the,
parties?
order was passed by the, I'll make the state government a party.
You made the same administrator twice a party.
The order is passed by the administrator, the removal order.
You only get
Department
it connected. Now it only delays the matter. After hearing so much, you got it connected.
Your Lordships, we were not, it had not reached your Lordships. And they said that it can be heard together.
So what do you want? 6086 to be taken or separated?
Leave it to this, your Lordships, sir. It can be taken separately because it relates to the administrator suspending the petitioner here.
If they make us a party, we'll file our statement.
All the councils submit that 6086 of 2026 may be delinked from the matter. Accepting their submission, 6086 of 26 is delinked.
And my
This
lord's
is-
query relating to 27A, my lords.
Yeah, just one minute. So 6086 is delinked. We'll have to list it on some date. Relist on 4th, 6th August, 6086. Yes, madam.
My lords raised a query that 27A would be a provision which will, it's uncontrolled. Once the state appoints administrator, that is the end of it. It's not so, my lords, because 27A in itself provides for checks and balance. That is the principles of natural justice.
Now, the submission made by Professor Kumar,
Yes, that, of course, my lords, Learned Senior made a submission that what would be the consequence? My lords posed a question that once an administrator is appointed, is it the end of it? The only examination under 226 would be, my lords, whether, and while compliance of 27A, whether the principles of natural justice, while we issue a notice to the society and society doesn't reply in time. That was the only limited.
so this aspect has not been dealt with by any other.
No, my lords, there are two judgments I'll place on record in which it is actually said I'll place that on record, my lord. I just got the head note, but I'll place the entire judgment. Where 27A, as long as principles of natural justice are complied, it's a valid.
You're producing it now?
I'll place it, my lords. I'm just asked them to get the copies. I'll just place it.
When will you give your reply? Varun?
Tomorrow, day after, I'll.
So tomorrow you place it, so we'll take it up.
I'll.
You'll have to file a convenience set.
Please, it's ready, your Lordships. Synopsis
This is
along with
too
the
many
annexures,
memos,
everything
too
is
many
ready. I've
filings.
served a copy also, your Lordships. I'll file it.
We'll restrict it only to that.
32600 synopsis is ready, your Lordships.
Heard Professor Ravi Varma Kumar, Learned Counsel, appearing for the administrator. Relist tomorrow for arguments of the Learned Advocate General as also the reply arguments of the petitioner.
Please.
Would it be on Thursday?
Tomorrow.
Today I got another matter listed at 2.
I'll file my compilation.
Thursday?
Please.
Please.
Thursday. Relist on Thursday is 16th. Yes.
Great.
Only 10 minutes, Alva.
Namdenill, I'll
Because
just
we
file
have
it and
another
close
parted
it.
matter on that
Please. We have argued only for that query,
day.
my
That
lords. I'll
judgment
place.
and you'll probably take around 10-15 minutes.
I've served the copy. I'll file it in the registry as a synopsis.
Great.
Further hearing, serial number 9. Mohammed Salim. Connected matter.
All removed.
For respondents, my lord.
I draw your lordship's attention, my lord, to WP 41233. But on 18.2, your lordships have not directed us to remove the optic fiber cable and put it underground. But on 15.4, we reported that it's been complied, my lord, and your lordship directed BBMP to verify.
Verify that.
4.6, my lord, again it had come up, my lord. If they point out that.
My lords, the inspection is still going on. We need 2
Still
more
going on.
weeks.
How long do you take?
Yes,
for
my
this?
lords, I have been instructed that we need 2 more week time.
What are you inspecting? The whole of Bangalore?
My lords, 2 weeks.
Have you started or haven't you started it? Not
No,
started?
my lords, it is in progress. I can assure you that it is in progress. That is the end time we have been told that it will be
When will
finished
you
within 2
complete
weeks. My lords, 2 weeks, after 2 weeks.
You are appearing for whom, Karthikeyan? You are also appearing for
BBMP, my lords.
407.
My lord, this is the matter that came to be heard, my lord, in part. The other matter has not been taken up yet. Of course, they were connected, but my lord, if this can be completed, because.
If that is done, then nothing will survive.
No, the other matter is on the demands that may, your lords, have to look on the demands.
Council for Respond number 1 in WP 41233 of 2018 submit that the inspection is in progress. It will be completed given 2 weeks' time. Released on 6th August, it's made clear that no further time would be granted. And this court makes it explicitly clear that this court expects the inspection to be completed by that time.
Great.
Serial number 10,
10 Malad, the
M. Halaswamy.
principal secretary is online. Malad.
Principal secretary is online. Where is the principal
Forest,
secretary?
Malad, your lordship had directed him to file an affidavit. Wants to make an explanation before Malad filing that affidavit. Right? He's on.
Why
He's
is that
present.
required?
I do. PRS here.
Yes, Mr. Srinivas.
My lord, if I'm permitted to kindly submit, my lord, noise pollution regulation and control rules 2000 provide for who will restrict the use of loudspeakers and public address systems in para 5, my lord. It clearly says a loudspeaker or a public address system shall not be used except after obtaining written permission from the authority. And it also clearly mentions what is authority. The central government or state government can notify this authority. Accordingly, my lord, 10/5/22, state government has already notified the authority, wherein in all police commissioner areas, it is headed by assistant commissioner. In other districts, it is headed by a DYSP, and only this authority has all the powers to provide a written permission from this designated authority to give license for any loudspeaker or sound producing system, my lord. And this authority can put any condition like stupid direction.
Now, Mr.
So-
Srinivas, we have an affidavit from the Home Department saying that Home Department, including all the police authorities, are implementing authority, and you are the policy agency. Now you are saying it goes back to the Home Department. We can't be going back and forth like this.
My submission, my lord. Here, the real issue is somebody is affected by the sound that is emanating from a loudspeaker. Now, like the department, environment department and government of India itself has already set what are the standards. These standards are for whole country. Now, whether who will regulate the complaints of these standards is with police department, my lord. Here in commissioner it is headed by ACP, and in other districts it is headed by the deputy superintendent of police, Tahshildar, and other will be there.
That is not why this was being considered. The issue was whether, like a speed governor, you could have also a governor in terms of the loudspeaker to restrict it to so and so decibels.
My lord, my submission again, my lord.
For that, the submission made by the Home Department is that you are the authority to do that.
My submission,
Now,
my
if
lord.
both of you say it is not me, it is the other, then we'll have to ask the chief secretary only.
My submission, my lord.
Decide who is the person responsible.
Condition, the authority that is headed by deputy superintendent of police or ACP can put any condition while giving the permission or by giving the license. They are free to put any conditions like that. They can put this, speed breaker or silencer, whatever it is. They can put, my lord. This is not a policy issue. What should be put or what should not be put. It is only operational issue that the authorities have full freedom to take, my lord.
We'll request the chief secretary's intervention. Srinivas, principal secretary, Forest, has appeared through video conferencing before this court. His submission is that it would be for the Home Department and all the concerned officers to impose such conditions as may be necessary, including the aspect of restricting the sound in the loudspeaker. For several hearings, the matter was adjourned for the Home Department to file its say in the matter. Subsequently, the Home Department had indicated that it is the Environment, Ecology and Forest Department which is the policy agency. Today, the Principal Secretary, Environment, Ecology and Forest Department submits that it is the Home Department which is the authority which can impose conditions. Both the submission of the Home Department and the Forest Department does not address the issue. In that view of the matter, this court is of the considered opinion that the intervention of the Chief Secretary, Government of Karnataka would be required. Hence, the Chief Secretary, Government of Karnataka is requested to look into the matter and make her submissions by next date of hearing. Released on 6th August, please, at 2:30 p.m. So whichever department, find out which department.
Please, this, get some clarity and make myself.
As morning it was submitted, football season is going on. That doesn't mean the file becomes a football. This has to end at some place, at some desk.
My lord, on 7/7/25, my lord, respond number 3, they had submitted that they have one device named as sound limiter, my lord. They said they will install it, my lord. After that,
they need somebody to say install. That's all. Who is going to install it? Pollution Control Board said, and that was another thing. Initially, the Pollution Control Board had indicated that it's the Home Department, then Home Department. So somewhere it has to stop. Yes.
Serial number 11.
The counsel for respond for the impeding applicant has filed his written submission. The same is taken on record, reserved. All of you, everybody is done.
Absolutely. That may kindly be looked at along with the compilation. In the compilation, I've given a list of dates for my lord's convenience.
Your compilation.
No, in that there's a list of dates also for my lord's convenience.
List of dates, we have some 10 list of dates in the matter.
Still, just before it was reserved, I had filed a list of dates to make my make it easy for my lords.
And heading of it is written submission. Anyway, now you have filed it. Whatever you have filed it, we'll look into it.
Serial number 12. Vidya Sagar.
I appear for 12.3 and 12.5 minutes.
I'm appearing for 12.10, my lord.
12.8, my lords. Yes.
12.1.
Needs 4 more weeks time, my lord. Cabinet full-fledged ಆಗಿಲ್ಲ, my lord.
ಇವತ್ತು we have to finish this ಅಲ್ಲ, ಅದಕ್ಕೆ we had posted all these matters.
Morning, just now I took the information from the office, the cabinet, my lord. In the 4 weeks.
They can't be waiting for such a long time.
ಬೆಳಗ್ಗೆ ಕೇಳಿದಾಗ by 1:30 I received information, my lord. Another 4 weeks.
Why don't you do it fast? Because all these have
Full-fledged-
been adjourned twice.
Full-fledged cabinet has to be.
Cabinet has to approve.
Cabinet.
But until then, can they operate?
My lords,
Interim
there is
order
an
is
interim order where my lords have placed certain directions under which we can operate.
Same. Then continue with that.
My lord, in 12.10 interim order is not there, my lord.
In which matter is the interim order?
12.10, my lord.
Bharat, in which matter is the interim order?
12.3 and 12.5.
The interim order granted in WP 27128 or 25 is extended to all the above matters. And AGA seeks for
12.11, your lordships. 12.8.
to all the matters. And AGA submit that the policy requires cabinet approval. He seeks for and is granted 4 weeks time to place the same on record. Released on 17th August.
Obliged.
Obliged, my lord.
Serial number 13. Maitri Krishna.
Lord, this is a case, my lord,
For respondent 6 to 9.
with respect to that.
Bengal authorities, my lord. Lord, I'm awaiting further instructions from the authorities.
With greatest respect, my lord.
How
Greatest
many times
respect.
do you want to
My
take?
lord,
1
just 2
year,
weeks,
my lord,
just
this
2 weeks
petitioner has
more,
been
my lord.
tortured.
Not fair.
And they've given a report, my lord.
We are taking it up at 2:30 after hearing, you come and say something, then again you take time.
No, my lord,
Can't be doing this.
Lord, we have strictly instructed them, my lord, to not to waste court's time, my lord, because
You're wasting everybody's time.
please, my lord, I understand, but thanks to change in certain situations, my lord, even my hands are tied.
We'll give you 1 week's time because of that.
Greatest respect.
That's all.
Please, my lord,
Nothing
please,
more.
my lord. My lord, 10 days.
One report
10
is,
days,
my lord, one submission may please be taken on record. They have already filed a report where there are 2 inquiries that they conducted by 2 different agencies of the state. That report is on record where they say that this person is a resident of West Bengal, is a citizen of this country. My lord, I am finding it very difficult, my lord, if my learned friend is trying to say that that report that they filed on the basis of an inquiry by two authorities of the state, that a different report is now going to be filed before this honorable court.
I'm not saying,
My lord,
I'm not saying.
if my citizenship, my lord, is dependent on the vagaries of who's in power in a particular state, that is extremely dangerous, my lord.
My lord, I'm not saying that, my lord. I only have instructions that the new authorities wants to overlook, rather review the document submitted before the court. Otherwise, I have no other instructions. I'm not saying that I would be filing a
Once a report is
contradictory
being
report or
filed-
something like that.
Once a report is being filed, can you change it?
My lord, authorities wants to review the documents that are already filed, my lord.
Do you
So,
have the power to review it?
rather relook into the documents that are
Do you have
filed.
the power to relook? Please examine that before you make any submissions. So then it will open another issue.
Please, my lord. I understand, my lord. I can't be blowing both hot and cold at once.
You
being
can
the
take a
state
stand in
authority.
another matter. In this matter, once you file the report, can you review it? In other matters, whatever,
One more submission was made, my lord, on the last date, that in regard to the election cards. I have now come to learn, my lord, this petitioner has gone through the entire grueling process of SIR, has cleared SIR, new election ID has been given to him, not just to him, to his entire family.
place it on record.
Please, my lord, in fact, let them also, this is the process that they conducted, my lord.
Lord, the last date of occasion, your lordship was pleased to direct the election commission to be impleted. Lord, I don't know whether it is impleted or not.
They are impleted, my lord, copies
And
have been
the
served on
counsel
them.
for the election commission is Mr. Sharath
for
Dodwad.
Respond number
He'll have
10.
to answer it.
Sharath for respond
Name
number
it
10.
is not shown.
Dodwad ಅಲ್ಲ?
Sharath Dodwad.
Dodwad appears. ಬರೀ ಶರತ್ ಅಂತಿದೆ.
I appear for R10, my lord, Election Commission of India.
Yes.
The copy has been served on Friday evening, my lord. We have communicated with the department. Department has sought time, around 2 weeks of time to.
10 days is what we are giving them. We'll give you
Yes,
that.
that apart, my lord, may make one submission. The Bureau of Immigration, my lord, have some, upon verifying the documents of the state government of the West Bengal, we found certain discrepancies, my lord. I will share it with my learned friend. Let them also, my lord, look into it.
Please file and argue. Let us finish the matter. It is just getting adjourned.
Lord,
You file whatever you want.
Lord, insofar as the report, my lord, they had filed, my lord, we have filed our counter, my lord. Only thing is, my lord, on 9/7, upon looking into the documents which was supplied by the state of West Bengal, my lord, we have found certain discrepancies, my lord, that I'll place it on record, my lord. I'll serve it to my friend also, my lord. He can place it.
Registry is directed to correct the appearance of counsel for respond number 10 as Mr. Sharath Dodwad.
Lord, so whatever copies may be served on me, my lord, it cannot be
I'll
only
serve it.
between them, my lord.
No, no, I'll serve it to my learned friend. I had only one copy. I'll serve it.
Counsel
Sir.
respond number 6 to 9 and respond number 10 seek for and are granted 10 days time finally to file the statement of objections.
Petitioner advocate.
Released on 23rd July 26 at 2:30 p.m. It's made clear that no further adjournment would be granted. Any and all filings.
Lord, the issue makes it very clear, my lord. If he's got the election voter ID card after intense SIR, my lord, probably the issue.
Nothing remains.
Nothing remains.
It is from Illeda. This, my lord.
ಕೊಡಿ ಅವ್ರಿಗೆ ನಮಗೂ ಕೊಡಲ್ಲ ಅವ್ರಿಗೂ
I'm
ಕೊಡಲ್ಲ.
only saying this, my lord, may please appreciate this. These are processes, my lord, that they are subjecting me to continuously.
Clifton, all of you are seeking time.
Not me, my lord.
No, not me, my lord.
I've been
You
ready,
are
my lord.
making submission without that coming before us. We can't make any observation on anything not before us.
Please, please, my lord.
You, whatever you want to file, you file. Whatever Mr. Shanti Bhushan has to file, whatever Mr. Dodwad has to file, everything file and address arguments.
Please, my lord.
That's all. List on 23rd.
Serial number 14, Vijay Kumar.
Yes.
Grateful, yes, my lord. I pay for the Lord. Insofar your lordship had directed, my lord, was the judgment in the judgment either
Order sheet.
Lord, in this the other matter, my lord, writ petition 20249. Your lordship had passed this order, my lord, para 6. Your lordship intend to pass the same order in this matter also, my lord. This is the document. Copy, yeah.
Yes.
But this was the order passed in the previous matter, my lord,
Yes.
paragraph 6.
Hmm.
May I just read it out, my lord?
Yes.
Please, my lord. Insofar as the interest of the respondent are concerned, the same can be safeguarded by directing them to issue a short validity passport. And since the short validity passport is issued, the immigration authorities would be on notice to seek further orders permitting the petitioner to travel by the court seized of the aforesaid matter. If at all the petitioners were to embark on any such travel outside the country, Lord, in view of the matter, the following order. Lord, order number the number 4. It is, however, made clear that the travel of the petitioner will, however, be subject to permission to travel abroad being granted in so and so, which shall be produced by the petitioner before the immigration authorities at the time. My lord, I am only concerned with this matter. My lord, in the present matter also, your lordship was about to pass the same order. My lord, the immigration authorities are here. My lord, the concerned officer is here. What, my lord, the what we are facing in the airport, my lord, there's something called as FTITTP, my lord. FTITTP. My lord, it says, my lord, Fast Track Immigration Trusted Traveler Program for Indians and OCI card holders. My lord, in this, any person who has got this FTITTP without verification by thumb impression, he can pass through immigration. This is what it is, my lord.
Yes.
There, my lord, in the airport, my lord, we don't have the Central Crime Record Bureau also, my lord, to verify with regard to the any other offences. Likewise, my lord, we also don't have the State Crime Record Bureau. So what we are facing is this, my lord, the immigration authorities, they will look only into the, my lord, the passport, whether passport is valid or not. That's it, my lord. In so far as this order is concerned, my lord, that is humanly
Then
impossible.
you'll
The
have
reason
to-
is this, my lord. If a person today, my lord, he obtains the order by this your lordship, my lord, without informing the trial court, he'll just live, my lord. This is what we have. Only in case of LOC is there, my lord.
Is what was pointed out. That is why we thought this could be one way of, if there's any other way, you give us the solution for
But
it.
the only
You
other
are the
way is,
authority.
Lord, only other way is this, my lord, with Lord, all that, my lord, your lordship may direct us to issue the passport as what is there in the apex court judgment, my lord, in Mahesh Kumar Agarwal. Then let him seek permission from the court and leave, my lord.
Correct. He will get the permission.
Please.
Your apprehension that you established, you voiced the other day,
Please.
was that once we issue the passport, they'll travel.
Please.
We'll not know whether they've got the permission or not. In another matter, that person had gone 6 months, 6 years
Please,
later, after warrant LOC, he was arrested, and that LOC has also been
Now,
challenged here.
the reason for making such a submission is this, my lord. Now, if your lordship could kindly take this, my lord, the Mahesh Kumar Agarwal judgment, my lord. This two things, my lord. Issuance of passport and permission to travel are two different things, my lord.
Yes.
In this case, my lord, para 22, page 33, my lord. It is important to keep distinct the position of a valid passport and the act of traveling abroad. A passport is a civil document that enables its holder to seek a visa and subject to other laws and orders to cross international borders. Whether a person who is on bail or facing trial may actually leave the country in a matter of criminal court, which can be granted without grant or withhold permission, impose condition, insist on undertaking or refuse to leave altogether. In the present case, both the criminal courts have done exactly that, to refuse renewal on the speculative apprehension that the appellant might misuse the passport is in effect to the second guess of the criminal court's assessment of the risk and assume for the passport authority a supervisory role which the statute does not envisage. Lord, all that, my lord, I'm saying is that, my lord, the Supreme Court said it's two distinctions, my lord. Otherwise, my lord, if your lordship is pleased to direct, Lord, let the trial court, my lord, direct us to issue the passport.
That cannot be done in view of the Supreme Court judgment.
Please. Therefore, two distinctions: the reissuance of passport and permission to travel. Lord, in any event, my lord, if your lordship pass the same order, my lord, in the immigration authorities, we would not have all these, my lord, crime bureau. records.
So was passed at your instance. So if you don't want that condition, we'll delete that condition.
Please, that is the reason, my lord. I'm
We'll
making
delete
my
that condition.
Please, my lord.
It will be only a issuance of a
The
passport.
reason is this, my lord. If a person is facing an UAPA trial or NIA trial or any other heinous offense trial, my lord, without the moment the order is placed before us, my lord, we are bound by law, by virtue of your lordship's order, we are bound to issue the passport. Lord, without informing the trial court, my lord, he would leave the shores of the nation. This is the reason is this, my lord. Therefore, Lord, let there be an order that let him take the permission of the concerned court.
That will always be there, Mr. Bhushan. That is always part of the order. That is what the Supreme Court also says. You wanted additional protection. That how do we know if he has got the order or not?
Lord, the order will be placed before the passport authorities.
No, it can't be an initial order. That is not what the Supreme Court says.
The moment, my
It
lord,
can't be a precursor to it.
Lord, the
You are
moment
making it a condition precedent.
Lord, the moment he applies for the passport, the police authorities would say, police verification would say there's a criminal case against him. Once the criminal case is against him, my lord, all that we would say is kindly get the permission to travel from the concerned court or get a permission to issue passport. Now, by virtue of this order, my lord, the apex court order, let there be an order only to issue passport, my lord. In this case, my lord, also the apex court had directed him to redeposit the passport before the concerned court after he gets the new passport. Lord, instead of doing all such exercise, my lord,
But the issue would be that obtaining permission cannot be a condition precedent for issuance of a passport.
that's true, my lord. Otherwise, your lordship may direct us to issue the passport. We will issue in the passport, subject to he redepositing back the passport to the concerned court.
That has been struck down by the Supreme Court. So
That is
also
what is
can't be.
written, my lord. 21, my lord. The legitimate purpose of section 6(2)(f) of the section and section 10(3)(e) is to ensure the person facing criminal proceedings remain amenable to the jurisdiction of the criminal court. The purpose is fully served in the present case by a condition imposed by the NIA court Ranchi and Delhi High Court, which requires appellant to seek prior permission and before and foreign travel, and in NIA case to redeposit the passport immediately before the renewal. To add these safeguards and identify denial of even a renewed passport with the both criminal courts have consciously permitted renewal would be disappropriate and unreasonable. Lord, therefore, my lord, in all the cases, my lord, my submission would be this, my lord. The lordship may direct us. Please, Lord, all that, my lord, if your lordship would direct us to issue the passport, he'll have to deposit back.
That is subject to that court imposing the condition, not for us to impose.
Therefore, my lord, your lordship may direct us to issue the passport upon the concerned person obtaining permission from the concerned.
That is what we are saying from that time. The third time we are telling you. You are making it a condition precedent which cannot be made. For issuance of passport, you want the permission to be a condition precedent.
No, my lord. That is
That
how.
cannot be.
If your lordship could kindly see, my lord, 6 to the GSR 570.
All that has been considered by the apex court. They make an application, you can give a short validity passport, that's it. You had an additional issue. You'll have to set up your own mechanism for it,
But
not
otherwise,
for
my lord,
us.
for issuance of passport, there's no travel permission required as per this also.
Correct.
We'll issue him the passport subject to redepositing before the concerned court.
That is
The moment what happens is, my lord, I cannot say the order of the apex court. I cannot comment on that. But the fact is this, my lord, the moment, my lord, we issue him a passport and say, you take the passport, seek permission from this court and go.
It's a very well reasoned order by the Supreme Court. You can't have any of this. Then you issue the passport, we will, production of that, we will delete that clause.
Lord, then, my lord, your lordship may direct us to issue the passport.
That's all.
To issue the passport based on the direction by the orders of the concerned court.
Again, you are coming back then. This is the fourth time you are coming back the same way. Once to Shanti Bhushan, that's it. You can't
But
make
all
that a
my lord,
condition.
I don't have anything against anyone. Lord, that only the safeguard of.
Your problem is administrative implementation. Administrative implementation, it's your lookout. How you administer it and how you verify if the order is there or not is left to you. You set up your system. The additional.
No, my lord, if we go by the judgment of the apex court, my lord, it says, my lord, let there be an order to issuance of the passport. This one, my lord, we will issue the, but subject to he should redeposit before.
That only that court can impose the condition, not us. When that court imposes.
Lord, that court will not, that court would not get this, my lord, with regard to, my
When
lord,
the police is opposing or whatever that application, that is to be brought to the notice, and whatever the conditions are there, that conditions can be imposed by that court.
now, my lord, for an instance, my lord, the concerned court will direct us to issue the passport. Lord, we will issue the passport. He would not approach the concerned court seeking permission to travel at all. The reason is this, my lord, there would be some conditions in the concern by the concerned court not to travel, not to leave the jurisdiction of the court.
We'll have it another day. Please examine it properly. It's an administrative issue at your end. If you come up with some solution, we'll make it part of the order.
Please.
But you cannot make the permission a condition precedent after Mahesh Kumar Agarwal's decision.
My lord, that's the reason, my lord, I told I cannot comment anything, but Lord, insofar as the petitioner is concerned, my lord, let him be,
Let him go.
Let him go.
In another matter, we'll see.
Please, my lord.
Yes, good.
I don't want to trouble my lord.
In that view of the matter, this court passes the following order. Writ petition allowed, a certiorari is issued. The objection dated 11/8/25 bearing number so and so, issued by respondent number 3 at Annexure D, is set aside. A mandamus is issued directing respondent number 3 to issue a short validity passport to the petitioner within a period of
3 days, my lord.
1 week from.
I've taken
date
time,
of-
my lord, therefore
1
I
week
don't
from the date of receipt of a copy of this order. The rest of what we have dictated will be the same.
Please.
Oblige.
Serial number 15. Rakshita DJ.
Petitioner in this last occasion learned.
Tender matter, madam. It's on the last date of hearing, para 2 minutes. In view of the rejoinder file, Leonard, the tender inviting authority would be filing an affidavit. Because there's been a change of the director, so she wants some more time, because it has to be.
When do you?
It's 1 week. I'll leave it to the court any day convenient.
When will you file? We don't want to
One
unnecessarily
week,
list it.
1 week.
At the request of Learned Additional Advocate General, relist on 29th July. Interim order earlier granted is extended till next.
Please.
Grateful. Serial number 16. Sagar BB.
78. It's 29, 230.
230.
Grateful.
69, my lords, I appear for the petition, my lords. Similar matter to serial number 12. It's a recreational club matter, my lords. There is no
16
interim
connect
order in
to-
this matter.
Connect to 12. The interim order. In which one? Interim order in WP number 27128 of 2025. The benefit of the interim order so and so is extended to so and so. Connect so and so. 17 is all same?
78.
17, same order. 18? 18 correct.
Shanta Kumar.
Protection matter, police protection matter, what
Hmm.
your lordship said.
Witness protection scheme. ಒಳಪಡುವುದಿಲ್ಲ. Witness protection ಬರಲ್ಲ.
Barala. He's accused in 3 cases, my lord. He's not witness in any of the cases. One more thing, my lord. In the last page, my lord, he's a photographs, photographs. Same. He's having a private gunman with arms.
The boss.
ಯಾರಿದ್ರಲ್ಲಿ?
You are calling yourself the boss.
That's, I don't know. I think they should always file it with some affidavit. At least if they had given me earlier, the boss seems to be someone else there.
With the permission.
This is your handle. Instagram handle, your name.
Let's, if your lordship, I don't have the page number. If your lordships have the first photo, your lordship, sir.
File a detailed objection and affidavit.
With the permission, my lord. Let me.
Let's, I'll submit on nimsha. This, my lords, are they saying that I have no threat to life? That's all is the question to be answered here.
You are an accused in 3 matters.
Only one matter. If they file it on affidavit and where there is, I produce the stay order.
In one case, there is a stay, my lord. One case acquittal. One case is pending before the Chikballapura police station, Nandigrama police.
File all of it. Why are you doing it in bits and pieces?
Please, my lord.
To say 3 matters and now come out saying one, my lords, if I am acquitted.
In detail, I have given, my lord.
File it on record.
Please, my lord.
As to what it is that you want to rely on. File everything.
Please, my lord.
Orally, you make something. You add
Everything
something
is in the
else.
report, my lord.
Doesn't help.
Everything I find in the detailed report, my lord. At page number.
Give him a copy of.
The copy is
And
fine.
AGA 6 fund is granted a week's time to file a
Lords,
statement.
may I just submit this?
Relist on 23rd.
Let's kindly have it tomorrow. Lords, last time your lordships gave them time till 1 week. Now they come out with this. From morning they could have supplied, at least we could have gone through. They don't seem to understand when the case is called, they just hand over something.
That is what we see everybody doing.
Lords, that's not the right approach, my lords. And when there is a threat,
Thankfully, they hand it over to us at that time.
no, my lords, when there is a threat to life, their own assessment says threat to life.
Third, you are having so many gunmen behind you.
Lords, that
That's
does
how
not.
many gunmen you are having.
My lords, let them, my lords, if they can file it on affidavit, somebody has to
That
be
is why we are
responsible
asking
to
them
file
to
it on
file it.
affidavit.
That's why we are asking them to
My
file.
lords, kindly have it on
Fair
Wednesday or Thursday.
Next.
Interim order, really. Lords, your lordships are posting it to, my lords,
23rd.
almost 10 days, my lords, your lordships are giving them 10 days time. At least have it, Lord, last 3 times it's come.
Relist on 20th. Then don't ask us whether it will reach or not.
Lords, 2:30, my lord. Today, ಅದು 2:30 ಬಂದಿರೋದು.
No.
Lords, 2:30 list at least, my lords.
Yes, Mr. Usman.
Because we have asked for an interim prayer also. Your lordship may kindly consider that at least.
Mr. Pranindra, it is not that you can walk around with police.
Lords, at least 2:30 on that day, my lords.
Yes, 2:30 only. Yes, ಅಂತ ಹೇಳಿದ್ರೇನು
ಅಲ್ಲ, ಅದು ಕೇಳಿಸಲ್ಲ. ಅದು ಮೆಲ್ಲಿಗೆ ಇರುತ್ತೆ.
Yes, Mr. Usman.
Yes, my lord. The business premises, my lord, they have locked it and they have taken.
Lordships may kindly peruse page 77.
Yes.
This is a complaint, my lord, lodged by one Syed Samir Dharwad, my lord. My lord, basically, my lord, Seragem, my lord, it is a Korean product, my lord. They deal with the body massages, my lord. The petitioners are the distributors of the said.
Yes.
My lord, based on this complaint, my lord, I'll file a memo later, my lord. If my lords may kindly, I've received instructions now, my lord. Based on the complaint, my lord, an FIR came to be lodged. I've received it now. Based on the complaint, my lord, an FIR came to be lodged, my lord.
318(3), cheating.
Please, my lord. And my lord, there was a search warrant issued, my lord, which is at page number 12. But what I wanted to point out was that, my lord, for a moment, may I trouble my lords to page 82 of the writ petition also, my lord.
There is a type to copy.
May I trouble my lords to kindly
18.
please page 82.
Page
82, my lord.
82.
Please,
That is the typed copy of the
complaint, my lord.
Yes.
Basically, what is the allegation made against the petitioners are that, my lord, false and prohibited curative claims. Under this, my lord, they say that it has been represented by the company staff and agent that the device is capable of curing and treatment inter alia all these diseases, my lord. Thereafter, my lord, they say in paragraph 4, my lord, administration of therapy by unqualified persons.
Yes.
And subsequently, my lord, they pray, my lord, in view of the foregoing facts and circumstances, it is most respectfully prayed that your good office may be pleased to initiate any immediate inquiry into the activities of the Sarajam Center and parent company. My lord, the petitioners are the distributors of the Sarajam product, my lord.
Yes, madam, but if that is so,
Please,
how
my
does the
lord.
police
And-
get a jurisdiction? It would be probably KPME or any of the authorities under that would get jurisdiction. How does police do all these things of seizing the material? It may be a business rival who has given the complaint. On that basis, you go and seize and block the whole thing. What gives you the power?
May I point out the prayer?
Everybody will come and ask prayers before you. What is your authority to do this?
No, my lord, my instructions are that, my lord, their distributorship itself is cancelled.
That is a civil
That is a different
dispute.
issue.
And, my lord, they are also seeking for the keys. That, my lord, it is with the owner. They are the.
You are always being doing this. Property to be handed over, lock to be broken, money to be handed over. Do you have the authority to do all these things? You don't have any authority to do this.
Please.
You'll have to tell them there's a civil dispute, go to the civil court. Why are you involving yourself in
Matter is under
this?
investigation. That is my.
Please unseal the whole thing and give it.
Your Lordship may kindly see the prayer in that complaint, my lord.
We have seen
My
that.
lord, may I
Complaint
point out
is-
one more, one submission, my lord. He claims to be a doctor, my lord.
Yes, madam.
He's-
What is your power under as a police authority?
Please.
You show us your power under the police. Yes. You can't involve yourself in any of these things. And you involve yourself only where it benefits you. They are getting so many petitions here for cognizable offenses where nothing is done. Even for 302, you don't register. And here for one 318, for some so-called distributorship having lapsed, you go seize the whole thing, seal the premises, take away the keys. Can't be doing this.
May I submit, my lord?
Yes.
Page 13 of the document which I have produced, my lord. I understand, my lord, the jurisdiction point.
Yes.
Page 13, my lord. This is the statement of the accused, my lord. In the last paragraph, he says, ನಾನು 10ನೇ ತರಗತಿ ವಿದ್ಯಾಭ್ಯಾಸವನ್ನು so and so ಶಾಲೆಯಲ್ಲಿ ಮುಕ್ತಾಯ ಮಾಡಿರುತ್ತೇನೆ. Now, if my lords may kindly see page 12, my lord. He signs on the search warrant as Dr. Saeed Khadir. Several allegations are there against him, my lord. Kindly see, my lord.
Yes, but under what provision are you taking action against this?
And now matter is seized before the ACMM court, my lord.
So I should not do any business if it is seized off by the CCB.
Under PF, my lord,
But I am
they
only a
can
distributor.
file an application for.
It's all been produced before the ACMM court. That you should bring
Yes.
it to our notice, page 15.
My lord, kindly see the complaint, my lord. What is the prayer made in the complaint?
Yes, that would have been sufficient if it had come to us
Lordship,
before.
may kindly see page 84. I will just make a submission, my lord. Page 84, my lord, see the prayer in the complaint.
For the
It
release,
has
my
been
lord, they can
filed by
file an
a person.
application.
My lord, this person, I think, my lord, set up by the competitors of the company, my lord.
Just because
Now
we said
kindly
it, you
see, initiate an prayer, my lord. In view of the foregoing facts and circumstances, it is most respectfully prayed that your good office may be pleased to initiate an immediate inquiry into the activities of Sarajam Center and the parent company. Verify the regulatory approval status of the device for the therapeutic claims being made. direct immediate cessation of all misleading advertisements, demonstration. My lord, police has no power to do all these things, my lord. If the complainant says that I have suffered a loss because of this, my lord, he has not made any such allegations. What is yes, here, my lord,
Mr. Usman,
this is the
Mr.
page,
Usman, please.
paragraph number 3, my lord.
Please,
Yes.
please. Okay.
Yes, yes.
You read the file, you know the file. We
No,
are
this,
with,
this was not given to me, and they have filed it before the court, they have not.
I
given
have,
to me.
sorry.
we are also looking through it now only. We are with you till now, but the warrant has been issued by the first ACGM. The matter is pending before the first ACGM. The whatever has been seized, the PF memo has been filed before the ACGM. So ACGM is seized of the matter.
Yes, I will file application, yes.
So file application
File
there.
application there. But permit me to do the business, my lord.
That also you'll have to file it there only.
No, my lord, that cannot be, my lord,
Because
because
the PF is-
that is, my lord, they are depriving me to do my avocation, my lord.
See,
Kindly see that, my lord, in this similar case, this honorable court has held, my lord, kindly, I have produced that order, my lord, at page
Page.
number 97, annexure F, my lord. This was passed by this honorable court, my lord. This attack has been made against me even from 2013, my lord. Here, this honorable court was pleased to, I have produced that order.
Yes, my lord.
This is also against the Sarajam, but at that time, my lord, it was, the action was taken by the district health and family welfare officer under KPME Act. Then, my lord, this honorable court, my lord, see, pending consideration of the matter, my lord, in page number 99. 7, pending consideration of the matter by respond number 2, he shall not prevent the petitioner from carrying on business of sale of the products by demonstrating the
Now it is the first
manner.
ACGM who is seized of the matter. There is a
Seized of-
court which is seized of the matter. Under 226, 227, we can't intervene in that.
My lord, the magistrate,
advise you what is
has
to
got
be
the
done.
power to release the seized material, my lord.
Hmm.
My lord, here, my lord, I have been prevented from doing business. My lord, I am not saying that investigation should not carry on.
Only
I am
by
not
way
saying
of
that.
seizure and by the key, by it being locked. So once you get back your premises, you can continue your business. That they haven't said no to.
This court, this honorable court has got
Once that
power
court
under
is seized of the
226,
matter.
my lord, because it's an infringement of my fundamental right, my lord, to do business.
The seizure is in pursuance of a warrant issued by a court.
Seizure, my lord, I'm not, yes, I will file an application as provided under the code, my lord. But now, my lord, the action they have taken is that preventing me from doing business.
Petitioner
That
is
cannot
before
be
this
done.
court seeking for the following leaves. The grievance initially of the petitioner was that the seizure of the goods of the petitioner and the locking of the premise of the petitioner was made by the police on their own without a FIR having been registered. It's in that background that respondents were called upon to obtain instruction as to on what basis such seizure and sealing of the premises has been effected. Today, the learned AGA has filed a memo along with certain documents, including a FIR in crime number 60 of 2026 registered under section 318 bracket 3 of the Bharatiya Nyaya Sanhita 2023. A submission is that the seizure has been made in terms of the warrant issued by the first ACJM Bengaluru in PS crime number 60 of 2026. And pursuant to the seizure, a PF memo has been drawn up and the said seized articles are now in the custody. Custodia legis, that is before the first ACJM Bengaluru. If that be so, it would be for the petitioner to approach the said court seeking for release of the said material which have been seized. There being a complaint which had been filed against the petitioner, it would always be available. There's a complaint in FIR number, crime number 60 of 26, which has already been registered. It is always available for the petitioner to take such appropriate remedies as are available under law.
Including the permission to do business also, my lord. Otherwise, yes.
We can't advise you what to do.
No, my lord, otherwise, my lord, that.
That is why we are only restricted.
Application will not be entertained, my lord, the scope of release of that is limited, my lord, there, before the magistrate.
Mr.
Under
Usman,
BNS, my lord,
please go outside, have coffee, think what is to be done and do that.
no, my lord,
Not, that won't help
no,
you.
give me the permission, permit me to make an
And make
application
such
for
application
opening
as
of
are
the
necessary
premises.
before the first ACMM. Reserving such liberty, petition stands disposed.
Obliged.
Macho.
Not there, you.
Petitioner, ma'am.
Yes, what is this?
Lord, this matter is to be referred for mediation. The last occasion matter came up.
Mediation could not take place.
Mediation could not take place, my lord.
Yes, it can go on. You want to go for mediation or arbitration?
The mediation.
And why did not you go last time?
ಇಲ್ಲ ಅದು ಫೈಲ್
ಬಂದಿರಲಿಲ್ಲ ಅದು ಮಿಡಿಯೇಷನ್ ಸೆಂಟರ್
ಫೈಲ್ ಬಂದಿರಲಿಲ್ಲ
ಫೈನ್ ಹೋಗಿರಲಿಲ್ಲ
they send it to the
arbitration center
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳ ಒಂದು ವಾರ ಬಿಟ್ಟು ಕಳಿಸ್ತೀವಿ ಅಂದ್ರೆ ನೀವು ಅರ್ಜೆಂಟ್ ಅಂತೀರ ಹಾಗೆಲ್ಲ ಅದೆಲ್ಲ ಫೈಲ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಫ್ರಮ್ ಹಿಯರ್ ಟು ದೇರ್
end of the month it could
now you lost
5 months
28th of this month itself will be
ಮತ್ತೆ problem
any date which is convenient.
Both the councils submit that the mediation proceedings could not take place before the Karnataka Mediation Center on account of the file not being received by the Karnataka Mediation Center. In that view of the matter, registry is direct forward the file forthwith to the Karnataka Mediation Center. Since the order is passed in the presence of both the councils, the party shall appear before the director, Karnataka Mediation Center, without requirement of any notice on 3rd August 2026 at 2:30 p.m.
Grateful, sir.
The rest of the order dated 12th December 2025 stays unaltered.
Great.
21.
Yes, Jagdish. CCMS criminal.
Yes, CCMS.
Effective.
We have started doing, but there are some issues which I have also taken up. I think the scanning was an issue within our office.
You'll have to scan and
that
put-
is one method. One more request on how to put it. That most of the copies which are given to our office neither has page number nor has a proper thing.
By whom?
By the bar.
No page numbers.
Most of the time, in fact, my lord, I asked them at least, they said they'll come back and give and create a ruckus in our office. That's also one of the issues.
You bring it to our notice when such kind of matter comes, then we can direct. Not as a omnibus.
Most of the time, my lord, we have noticed that
Everybody may not be doing that. Some may be.
not everybody, my lord. Most of the people. No,
can't paint everybody with the same brush. And
no page number I can understand. We will put page number. But the thing is, to put page number, we need a reference. What page number? Court has some page and we have some page and they have some page. So that is, my lord, this is what.
In those matters, you should bring it to a notice. They can't make that kind of this one. But now this is functional. Everything is happening.
Functional. And I had one more request for them. There is issue seems to be concerned about document being accessed. And I spoke to them and I said that create a watermark. Once you create a watermark, you know who has downloaded it.
You can always speak
that
to-
that they have agreed, my lord, that they have said that they will take it up.
They'll be ready to help you out.
Yes,
with
yes.
any
In
of
fact,
that.
they will. Yes, day before yesterday, I had that. Friday, I had that meeting. My lord. They have agreed that they will probably it's a one software installation to allow. Once that happens, my lord, even assuming that the one fear they had is that dissemination of documents to other people, some of the secret document, including the case diaries and other things. Once you have a watermark on those documents, that also could be taken care. Is what I've suggested them.
Watermark for what? We'll do one thing. You can give your suggestions in writing to Mr. Laburam. Mr. Laburam, you could look at all the suggestions that the SPP.
Yes, sir. Yes, my lord, I have heard it, and we have already discussed with the e-governance, sir, and they have promised that they will do it at that, yes.
Very good.
It solves the problem.
Because it is for your benefit. See,
Yes.
if all of you have it easier, then it becomes, everything will be available here in court and unnecessary adjournment will be avoided. provided.
Yes.
Learned SPP has filed a memo enclosing the letter dated 10/7/26 of the Office of the Inspector General of Police, Police Computer Wing. The same reads as under. Shri Laburam, Inspector General of Police, PCW, who is present before this court through video conferencing, submits that a request has been made for integration of WhatsApp-based notification functionality into CCMS criminal case module. As regards which, the Center for E-Governance has informed that the Office of the Directorate of Electronic Delivery of Citizen Services has been requested to implement the said service, and that the same is under progress. As regard the usage statistics, it is stated that total cases received from the SPP office as on 9/7/2026 is 306 matters. Total number of cases responded to by SHO is 214 matters, and number of cases pending with SHOs are 80. And in this regard, for better implementation, a state level dashboard is being developed through the Department of E-Governance, which is under progress. Insofar as e-prosecution application, it is stated that the total overall usage is 32.31% as on 6/7/26, and efforts are being made for it to be adopted across by all stakeholders. By when will we reach 100%, Mr. Abram?
Sir, we are following with the prosecution departments. It will take some time. 100%.
Approximately. Any training to be given, anything to be done?
From our side, everything is done to prosecution department. I'll again discuss with director of prosecution department and follow to achieve the maximum.
This court is of the considered opinion that 32.31% of overall usage is at a very low end, and it is required that the same be improved at the earliest. In this regard, both the Office of the SPP as also the Office of the Inspector General PCW are directed to come up with, to formulate a suitable plan so that the said application is used by all concerned, reaching up to 100% as early as possible.
Noted.
The SPP also has certain suggestions. He is at liberty to provide those suggestions to the
already communicated
AGP PCW for purpose of consideration and implementation. Released on 17th August to report further progress. Report of the registrar computers has also been placed, stating that despite several attempts being made to contact the e-prosecution application team, there is no response which has been received. The concerned NIC team is directed to assist the registrar computers in implementation of the e-prosecution software at the earliest.
Sir, may I add if I add, this is regarding dashboard for e-prosecution. We have prototype dashboard already we have proposed and sent to NIC, and from the Office of Registrar Computation also being followed with NIC. So we are waiting at the earliest if they prepare that dashboard and integrate with the e-prosecution. It will be helpful for us to monitor about the progress of e-prosecution at every level.
The submission of the Inspector General of Police that a draft dashboard has already been forwarded to the NIC. Is placed on record. The concerned at NIC are directed look into the same and make it operational as soon as possible. Thank you, Mr. Abraham.
Thank you, sir. Thank you.
Serial number 22, Sagar BB.
So Sagar,
Cooperative matter. Directions were there. Cooperative matter. Two societies having same name, directions
Same.
were issued in that regard. My lord.
disposed matter, right?
Please, my lord. Lord, letter is written to DRCS, my lord, to constitute a committee. They are seeking some time. My lord.
That AG has filed a memo enclosing the letter issued by the Undersecretary to Government Department Cooperation to the Register of Corp Societies, dated 3/7/26. She submits that a committee is in the process of being formulated to address the issues raised in the present matter. She seeks for and is granted 4 weeks' time to report
Please.
further progress. Released on 17th August.
Serial number 23, Chandan K. Connected matters.
End of the list in a review. End of the list. We'll just take the end of the list and then come.
230 mood matters.
Yes, madam. Post the matter before a bench of which SGRJ is not a party.
Serial number 2. Raunak
Sorry
Chatterjee.
for the petitioner, my lords. If possible, may the matter be passed over, my lords. I'm led by Mr. Manukul Karni. He's on his legs.
Once Mr. Raghavan starts, then you won't get time.
Then I'll take my chance, my lords, please.
Okay, pass over.
Shahbaz Hussain.
Yes, Shabas.
Your lordship.
Yes, madam. You are threatening them threatening demolition.
The lordships may kindly peruse page 42 of their application, my lord.
Where's your application, Shabas?
Lordship, I filed it in the morning and made sure it is tagged to the
Where is
file.
the Idea Bandidya?
Paragraph, page 42, paragraph 4, my lord.
42.
Please, my lord.
Yes.
Paragraph 4, my lord.
Hmm.
In the aforesaid backdrop and without expressing any conclusive opinion on the merits of the case, which is as kept open for consideration at the stage of final hearing, this court deems it appropriate to grant limited interim protection to safeguard the interest of the bona fide flat owners. Accordingly, it is directed that respondent number 3, Commissioner shall not decline to receive the periodic property tax payable in respect of subject property as and when it falls due. On the ground of absence of e-khata on the or on allied technical objection, the parties are further directed to maintain status quo
Yes.
as it exists as on today in respect of the nature, possession and enjoyment of the subject property. Now, my instructions are that, my lord, subsequent to that, they have constructed a compound wall, my lord. In that view, we have only just asked them to
Sorry,
stop, my
photos.
lord, that's all.
The first one.
The date is also forthcoming.
Who has constructed this, Mr. Shabas?
Your lordship, there was a compound wall. Even as on the date, there was a barbed fence.
Who is constructing this now?
This is petitioner association. They've replaced
Who
the.
are you constructing when there's a status quo order passed?
No, your lordship, we've replaced the existing wall.
With whose permission?
Your lordship, the stray dogs were coming into the.
With whose
fence.
permission?
We've not constructed anything new, your lordship. We've just.
With whose permission are you constructing this?
No, your lordship, we've only replaced the existing.
Please don't do these kind of things.
My apologies, your lordship. I would.
They think they're above the law, then they'll go demolish it. Don't come to us asking for any relief.
No, your lordship, we've not put up anything new. Existing set.
There was a status quo order passed.
Yes, yes.
What does status quo order mean?
Status as it existed on that day should be maintained.
Do your clients understand that?
Yes, Your lordship, our only understanding was we will not put up anything new. We only replaced.
We'll direct demolition of this right away.
Your
This
lordship,
is in violation.
we have not put up anything new, your lordship. Your lordship may,
You restricted to demolition of this, nothing else.
That's all.
It will be status quo as on the date of that order.
your lordship, one important thing. I filed an IA also, your lordship. They had come down and they threatened that they are going to evict all of us on the 15th. 15th is day after.
That we'll handle, but this also we'll handle.
Your lordship, only problem is this. There are children in the society. The stray dogs were coming into the, through the
Mr.
bar fence.
Moved an application before this court.
Your lordship, I'll move it now. My apologies, your
Move
lordship.
the
but-
application. First, we'll demolish this.
Your lordship,
Let that financial loss be suffered by your client.
your lordship.
You
may
cannot be doing
please
this. Once you
consider
file the
the IA.
application, we'll consider it on merits.
Very well, your lordship, but kindly appreciate your lordship. There have been some incidents also. And because of the
Could have
children,
Right royally placed it before the court.
I understand your lordship, but only our understanding was
On
we
that
not
basis,
put up
this
anything
order
new.
can be vacated that you have violated it.
No,
You want us to vacate the entire order?
not at all, my apologies, your lordship. Your lordship may,
Then DGA submits that it is only the construction of a compound wall which has been put up without authority and in violation of the order dated 23/4/26, which is now sought to be demolished by the respondents. She submits that the rest of the order passed by this court will be adhered to,
Please,
and there is no eviction and or demolition of the
please.
apartment complex which is
Please.
proposed to be taken by the respondent. The said submission answers the grievance of the petitioner. Relist on, when was the date?
Date was given.
Relist on 4/8.
only one submission, your lordship.
Interim order earlier granted is extended till next day.
Only one submission. Grateful, your lordship. Only one submission. Your lordship, the order that we've challenged in this IA, stay of the order that we are seeking, that order, your lordships have recorded that they'll not disturb our possession. May I only request your lordship that order may be stayed, otherwise they may, even if you show this order, they say that that order is not
They
stayed.
recorded the submission,
DCF order will,
May I?
recorded submission.
very well.
You are the person who is violating, not them.
No, but there is a written order, your lordship, in this.
Don't try to create this kind of a false, this one, please.
No, your lord, my apologies if I gave
Tell-
that sense.
Put your clients are on notice, warn
Yes.
them properly, advise them properly. That they should not be doing like this.
Obliged.
One of 26 is allowed. Mr.
Number 2, serial number 23.
Yes, Mr. Agul. Rest of the matters are unlikely to reach. Fast over ಅಲ್ಲ, agenda. Fast over ಅವ್ರು. ಅದೇ.
Let it be any date.
4th August.
Second. The serial number 2.
2nd is Sunday.
No, my serial number 2.
ಆಯ್ತು, ಅದು 4th August ಆಗಿದೆ.
Interim order 2.
Interim order.
Interim order 2.
Interim. ಯಾವ serial number ಏನಪ್ಪ ನಿಮ್ದು?
2.
Serial number 2 ಅಜ್ಜನ್ ಆಗಿಲ್ವಾ?
Password.
Serial number 2. 4th August at 2:30 PM. Interim order earlier granted is extended.
That.
What about that serial number 1?
It's on the serial.
ಹಾ, ಎಲ್ಲಿ?
22 may not it make.
22 ಅಲ್ಲ,
For the
serial number
respondent, for the respondent number 1, my lords, the government had to give the CCTV footage.
Yes. Where is Jafar? You are appearing in serial number 1?
Serial number 1, Jafar is appearing. Jafar is appearing.
I used to get instruction as to.
We'll see.
Pass over, that will take it up
Please,
after this.
230 move matter serial number 230 move matter serial number 28 of office.
That will be at 6 o'clock. If he finishes it by then.
I'm grateful, my lord.
Serial number 15 passed over.
ಯಾವ್ದಪ್ಪ 15? List 1. It will all be adjourned to some other date.
Serial number 22 is also password next week. Please, any
Date will
any
be-
date may be fixed.
ಕೊಡ್ತಾರೆ. Note.
Please,
Court officer will see the matters and
Serial number 53, my lords, interim order.
all interim orders will be extended.
Serial number 13, your lordship.
Hmm.
Serial number 13, your lordship. Because your lordship has directed to get the instruction to conduct the cultural program, your lordship. For that,
13 pass over, we'll take it up.
please, lordship.
Serial number 56, my lord.
yesterday also I made a mention. The Kole bus was 150 families are affected, my lord, and there's a threat of eviction, my lord.
Threat of eviction.
Yes, my lord. Because
Who is trying to evict you, madam?
1.56, my lord, serial number 56 of list 1.
Bescom is trying to evict you.
Yeah, my lord. We have several prayers. One is Hakkupatra Needbeko anta, one to encroachment and Nadibeko anta. Moornedu electricity, in fact, sewage is passing through their houses, my lord. So there are a number of parties there. There's some
56
urgency.
putting.
My lord, 1.22 acres in Anekal was allotted to them, my lord, by DC
You have
order.
not paid court fee, madam.
No, that's the office objection that's come up, my lord.
Yes.
There are sangha of several hundreds of Kole baswas, my lord. Literally, people who take the oxen around the city.
Yes, how many members do you have?
They do not know the number, my lord. That's why we have said that this community will be represented by this party, my lord, by this one sangha, my lord. That is
You are before this court asking for Akkupatra on behalf of your members.
Yes, my lord.
That's a private right, not a community right of the society.
No, it is, my lord, because it's a land allotted by the DC, my lord, and several communications are annexed where the DC has in fact given directions to remove encroachers from the property, to give them Hakkupatra, but agila idu. It's a simple mandamus, my lord, that I'm seeking.
No, who are the people?
There are 150 families in that particular.
So you know the names, they should be petitioners.
I can produce a list, my lord, because the thing is, they are extremely backward community, my lord. They in fact, Alamari.
Madam, get one wakalatama, make them a party and file it. This kind of relief cannot be given to a society. We'll have to dismiss it for that reason.
But till now, they have only been pursuing this case on that letterhead or
That counsel for the petitioner seeks for and is granted a week's time to array all the concerned members of the petitioner as party petitioners. Relist on when will you do it?
Next week, my lord. I'll do it before next
Date
week.
early yavattu anta.
Any time, my lord, of this, any time of convenience of this court. Any time.
Relist on 22nd July.
Grateful, my lord. Grateful.
Because I'm mentioning item 51, my lords. My lords, there is an interim order against me, my lords,
Hmm.
because of which, my lords, both the wind projects are stuck, my lords.
Yes, we can't take up the matter for
My lords,
hearing.
not today, my lords. Tomorrow, my lords, it can be taken up, my lords.
Tomorrow also it will be the same situation. It won't be able to reach.
Well, it's a joint request by both the parties.
Tomorrow we have 148 matters, day after we have 131 matters, 16th we have 131 matters, thereafter we have 172 matters. You choose the date, but don't insist on it reaching. If it reaches, we'll take it up. Yes, you give whatever date you want.
19th and 20th minutes, the senior has.
Yes, Kodi. Yes, Mr. Raghavan.
My lord, a show cause,
Yes.
a show cause notice that had been issued, my lord, under the Forest Act alleging that certain forest land had been encroached upon, was questioned before your lordship. And of course, my lord, arguments have been addressed on the merits, and your lordships have recorded a finding that this property is not granted land. And your lordships have recorded in multiple places, which I will bring to your lordships notice, that the register that has been produced, the Ketwari register which has been produced, is not enough evidence of a grant, because there is no grant certificate, there is no grant register, none of that is produced. Therefore, to say that this is a property which has been granted to that Manikya Raju is.
Show us the order of the division bench first.
Yes,
What is the,
I
you
showed
went
your
on
lordship the order
appeal,
of
what did the division
yes,
bench say?
Division bench order. I showed you all. The division
What
bench
is the
order.
scope of this review?
Yes. ಹೌದ್ರಿ ನಾವು ರಿಟ್ ಅಪೀಲ್ ಆಗಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಬಲ್ಲ.
Convenience. Mr. Hemant Pai, please mute yourself.
You know, my lord, it's available for your lordship's consideration at page 276.
276.
Yes, my lord, it is order dated 9th of October 2025.
Arguing for some time, crave leave to withdraw the appeal and prefer to file a review.
It doesn't take us too far. I'm confined to whatever is possible under the provisions of Order 47.
It only indicates the appellate court was against you. You have withdrawn it. That is what it indicates.
In any event, assuming that it to be that way.
Yes.
No, it is that.
I will take it. I mean, we all know, my lord, what happens when all these review liberty is given. I mean,
Now you filed so much here.
No, the
as a
question, my lord,
review.
is simple.
Yes.
Therefore, my lord, independent of, fortunately, my lord, if the appeal has been dismissed on merits, then of course I cannot file a review petition.
Absolutely.
But the only saving grace, so far as I am concerned, in this order is my appeal has not been dismissed on merits. I withdrew the
You
appeal.
have only escaped the dismissal.
I understand. I understand.
And you want to let us see, but what are your grounds of
My lord,
review?
grounds, my lord, is that my lord, this is a serious matter, my lord, which I request. I think the state government is required to answer. They did not produce before your lordship the grant records. And I showed to your lordships that even when we obtained the grant record after the disposal of the writ petition and filed it along with the review petition, there is a letter that has been addressed, an interdepartmental letter, which says there is no such record. Thereafter, my lord, it was inspected. It is there. So this is a clear case of suppression of records before this honorable court. What is the effect of the records is a different issue that your lordships will look at it independently. But one of the important aspects which your lordships have recorded in multiple times in the order is that there are no records which have been produced to show that in fact there was a grant in favor of the petitioners.
That was your duty to bring it, not their duty.
We could not get it. I will assume records are in their custody. But apart from the technicalities, who should produce, who should not produce. Here is a government who have the records with them. What they want to say on the basis of the records is a different issue.
That will be a little higher bar.
No, my lord, but so far the government is concerned, my lord, they are to be put to the higher bar.
Every case that you file, they'll have to go searching, find out all the papers.
Not only that,
and
my lord,
present it.
when I obtain it and produce it along with the review petition, there is a record here to say that such a record is not available. And then pursuant to the court's order, when we inspect, records are available. Today, there's answer to that record is, no, see there is one line which says it's struck off. I showed your lordships. Yes, my lord, I will straight away take your lordships through those records, and then, my lord, we are concerned with two survey numbers, survey number 68 and survey number 69. Now, my lord, please be kind enough to take page 72 and 73. I showed your lordship that of the convenience compilation.
Of the convenience.
Yes, ma'am. Please be kind enough to turn to
72.
Yes, my lord. My lord, it is dated, as your lordship will kindly see, 26 to 1932. And the typed copy of that is available at page 73.
Where is the date that we get? Mahiti Hakku Adhiyamadalli. That is the document that you are referring to?
Below that is the Darkastu Wahi Nakalu.
Darkastu Wahi Nakalu. You are mentioning a date. We don't see any date here.
Left side is after 26:32 and the left corner.
Original record, it will be much clearer. I think it is available.
Yes, they have the original.
Please see the original record.
26 to 32.
Yes.
I have the original.
Let them please see the original, my lord. Kindly, and I showed your lordships what a contradictory stand that they're taking before this court, and that is not fair, especially from the government, on which is the custodian of the records. And answer to my lord's question, should we put the government on a higher pedestal? Answer is yes, my lord. Private parties can do, should not do, but there is a little more.
No, not that. Can we ask the government to do a rowing inquiry into everything,
No,
produce
when
all
it
the
is
documents?
produced, when we have produced this record, I will show to your lordships what is the statement made.
You never produced this.
We
when
did,
the
we
writ
did in the review.
petitioners-
But I'm talking about in the review petition.
We are on the scope of the review. If you keep on producing newer documents in the
But
review,
if it is available with them and they are on record to say that document is not available, and then when we inspect it is available, and they can't tell lies before the court.
that is a different.
Well, that's it. That's a
That's
question,
a
my lord.
prejudicial argument. Okay, we'll keep that
No, my
prejudice
lord, not a
aside.
prejudice argument, my lord.
The issue is, did you have the ability to produce
No,
it at the
how
time
could
when
I-
your writ
I will-
petition was
The
filed?
only way in which I could get it was that in 2025, they uploaded something on the system, and then that set us search for the records.
When was our order passed?
18th of August 2025.
And they uploaded it in December.
December 25.
They have uploaded
So
on
this is Darkhast register, my lord.
No, I showed you a lot
My
of the entries
colleague
that they have
approached,
made.
my lord,
Yeah,
because the papers are, if I even pass it on,
that was uploaded
you grant may
on
go away, my lord.
28.
Ask your colleague to come.
ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಸರ್
ಅಲ್ಲ, ಇದು ತೋರಿಸ್ಬಿಡ್ತೀನಿ. Darkhast register ಅಷ್ಟೇ ಅಲ್ಲ.
Please, I want your lordship to see that.
All their cases based on this.
Sir, don't leave that to me. My
You don't-
case is based on something more.
It looks like there are a lot of new items which are coming out. So whether they will be part of the review is.
My lord, review independent of order 47, especially in a 226 jurisdiction, I would think, my lord, is a little enlarged. Where your lordship finds that there is a suppression before the court by the government with respect to a very important document.
That is.
There is no Darkhast to why Nakalu here.
My lord, if your lordship will kindly take the next one, my lord, Darkhast to Wahi Nakalu.
It's not there here in the original.
But that is the Darkhast register itself.
Heading ಯಾರು ಕೊಟ್ಟಿದ್ದು?
That was.
Those words
Where
are
he
not there
issued
in
the
this
certified copy.
record.
Heading ಯಾರು ಕೊಟ್ಟಿದ್ದು?
The rest of it is there.
Very well, my lord. Heading ಯಾರು ಕೊಟ್ಟಿರಿ? ಹೇಳ್ರಿ ನನಗೆ.
Who has written this heading?
One second.
Is in different handwriting also.
ಇದೆಯಂತೆ.
Once.
It is not here.
At the time of issuing the certified copy, they have written it and given, because only one page was issued.
Now I have placed the original.
ಅಲ್ಲೇ Darkhast
And what
to
is flagged, my lord?
ಸರ್ ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಇದ್ರೆ ಇದು ಇಲ್ಲ ನೀವೇ ಮುಗಿಸ್ಬಿಡಿ ನಾನು ಆಮೇಲೆ ನಾನು ಹೇಳ್ತೀನಿ. I mean, let me put my
Madi,
case.
I'm just
Sir,
explaining
permit
to
me.
the court.
Please see page 72, my lord. ಈ ದರ್ಖಾಸ್ತು ವಹಿ ನಕಲು
ಅದನ್ನ ಅವ್ರು ಬರೆದು ಕೊಟ್ಟಿದ್ರು.
My lord, kindly see the entry at page 72.
Somebody's
taken
grant
away
may go
bits.
away, my lord. Survey number. I'll just collect those
We have
papers.
taken away your bits of paper. Thankfully, there is nothing in this.
I'll just.
Illaram
ಇದು
ಬೇರೆ ಅವ್ರ ಜನರು
ಇಲ್ಲ
should
ಇದನ್ನ
not get
ಮುಟ್ಟಿದ ಮೇಲೆ
disturbed.
ನಾವು ಕೈ ತೊಳ್ಕೊಂಡ್ಬಿಡಿ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಇದು ಬಹಳ ಅಲರ್ಜಿ ಇರುತ್ತೆ.
RFA matters ಆದಾಗ ಗೊತ್ತಾಗುತ್ತೆ.
ಹಾಗೆ
Yes.
ನಾವು ಈ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ I will show you a lot. There is a line that is there. Now, what does it say, my lord? 26/2/1932, ಮಾಣಿಕ್ಯರಾಜು ಬೆಂಗಳೂರು, ಚಿಕ್ಕಸನ್ನೆ 69 ಕಾಯಂ. ಟೈಪ್ ಮಾಡಿ ಎಲ್ಲಿದೆ?
Where are you reading this one?
ಇದೆಲ್ಲಿದೆ
ಅದಿಲ್ಲ, that is separate. That is
ಅದು ಬೇರೆ
separate. That ಬೇರೆ.
ಕೆಳಗಡೆ ದರ್ಖಾಸ್ತು ವಹಿ ನಕಲು ಅಂತ ಇದೆಯಲ್ಲ.
Yes.
Now, ಅದು we have given a typed copy of it at page 73.
Yes.
26/2/1932, ಮಾಣಿಕ್ಯರಾಜು
ಬೆಂಗಳೂರು.
ಅಲ್ಲಿದೆ, ಮಾಣಿಕ್ಯರಾಜು ಅಂತ ಕಾಣುತ್ತೆ.
Yes.
ಚಿಕ್ಕಸಣ್ಣೆ 69, ಕಾಯಂ 45/24 ಬೆಂಗಳೂರು.
What is this 45/24?
That is the extent. Now, my lord, when we produce this along with the review petition, please see the stand that they have taken. Where is that letter?
Page 1.
Kindly turn to page 185. Because so many papers have given me. I don't want this.
185, convenience compilation. Yes.
This show me the letter. ಎಲ್ಲಿದೆ ಇದು?
ಇದೆ.
ನೋಡಿ, the
Page
convenience
185.
compilation 185 ತಾವು ನೋಡಿ. It is a letter dated 25/11/2025. Your lordship got it, ma'am?
Yes.
Yes. This is my note from the Tahsildar Devanahಳ್ಳಿ ತಾಲೂಕ್ addressed to ವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಗಳು ದೇವನಹಳ್ಳಿ ವಲಯ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ. ವಿಷಯ: ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಚಿಕ್ಕಸನ್ನೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 69ರಲ್ಲಿ ಮಾಣಿಕ್ಯರಾಜ್ ಎಂಬುವರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಜಮೀನಿನ ಮಂಜೂರಾತಿ ವಿವರ ನೀಡುವ ಕುರಿತು. ಉಲ್ಲೇಖ: ತಮ್ಮ ಕಚೇರಿ ಪತ್ರ 19/11/2025. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಚಿಕ್ಕಸನ್ನೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 69 ಹಳೆ ನಂಬರ್ 67ರಲ್ಲಿ 34 ಎಕರೆ ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರಿನಲ್ಲಿ RP ನಂಬರ್ 443 of 2025, that is the present proceedings, ರಂತೆ ದಾಖಲಿಸಿರುವ ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರು ಮಾಣಿಕ್ಯರಾಜ್ ಎಂಬುವರಿಗೆ ಚಿಕ್ಕಸನ್ನೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 69ನಲ್ಲಿ 45/24 ಎಕರೆ ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಸದರಿ ದಾಖಲೆಯ ದೃಢೀಕೃತ ನಕಲು ಹಾಗೂ ಮಂಜೂರಾತಿ ದಾಖಲೆಯ ನೈಜತೆಯ ಕುರಿತು ವರದಿ ನೀಡಲು ಕೋರುತ್ತೀರಿ. ತತ್ಸಂಬಂಧ ನಿಮ್ಮ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿರುವ ದಾಖಲೆಯ ಬಗ್ಗೆ ಈ ಕಚೇರಿಯ ಅಭಿಲೇಖಾಲಯ ಶಾಖೆಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗಿ ಸದರಿ ನಕಲಿನಲ್ಲಿ ಬರುವ ಯಾವುದೇ ದಾಖಲೆಯು ಲಭ್ಯವಿರುವುದು ಕಂಡುಬಂದಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ತಮಗೆ ತಿಳಿಯಪಡಿಸಿದೆ. So, my lord, the Tahsildar said there are no records with me.
This is Tahsildar Devanahಳ್ಳಿ.
Yes. And now please look at this. Now, my lord, please look at.
Where did you get that document from?
Which document, my lord?
That
This one.
you referred to
This,
at page 72.
from the Tahsildar's office. Who gave that RTI? Correct. Of course.
There's no signature.
Sir. I showed you, lordship, what is the stand now taken in the counter affidavit before the court.
Let him complete, Mr.
Yeah, ಮುಗಿಸ್ಬಿಡ್ತೀನಿ, sir.
Where did you get this?
My lord, if your lordship will kindly turn to page 72, it is from the Tahsildar's office, Devanahಳ್ಳಿ Taluku. Your lordship gets a seal also at the bottom. ಈ counter affidavit ತೋರಿಸಿ. ಎಲ್ರಿ ಭರತ್, come on, counter affidavit, stand here.
Where is the original of this?
Original of this, my lord.
Certified is what we have produced to the court.
You have produced it along with your review
Original is in
petition.
the book. Certified copy is what we produced to the court.
Page number original.
Page 73.
Because this is not legible, you can't make out.
Along with an IA, we had given it.
When did you file it?
Why don't you go and help the court officer to get the records to the.
When did you file it? Along with the IA and Tedakala, Mr. Chandan. Tell us which IA, when did you file?
ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲ ರೀ.
You keep on filing so many IAs.
I'll leave time of the court we are wasting.
It was filed on 30/10/25.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
IA number.
IA, in the convenience compilation also we have.
Convenience compilation, you have photocopy. You want to see the original.
A seal original ತೋರಿಸಿ.
30/10/25 is IA 2. Is that what? Yes, IA.
Yes, madam. Along with the IA too.
Tahsildar ಕಾರ್ಯಾಲಯ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು.
ಇದೆಯಾ?
ಇದೆ.
ಇದೆಯಾ?
ಅಲ್ಲಿ.
Now it is clear. Darkhast वही नकलू has been written in it.
Yes.
Now, kindly see. Now, my lord, please see.
Just one.
I'm sorry. I apologize.
Page. ಏನು ಕಂಟಿನ್ಯೂಸ್ ನಂಬರ್ ಮಾಡಿಸಿದ್ದೀರಾ? ಮಾಡಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ 298 ಅಂತಿದೆ, ಅದು ರನ್ನಿಂಗ್ ಇಂಡೆಕ್ಸ್ ಆಯಿತು. ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಗುಡ್. ಸ್ಕ್ಯಾನಿಂಗ್ ಆಗ್ತಾ ಇದೆ ಅದಕ್ಕೆ. IA 2 of 25. So this was issued to you on 16/10/25.
Yes. This inspection ಕೊಡ್ಲಿಲ್ಲ initially.
Initially first ಕೊಡ್ಲಿಲ್ಲ, second time.
First time ಯಾವ period ಕೊಟ್ರು? Order copy. Order ಮಾಡಿದಲ್ರಿ ಇಲ್ರಿ ಅದು.
That was 36 onwards.
Order ಮಾಡಿದ್ರಲ್ಲ ಎಲ್ಲದು.
This was with specific reference to survey number 69,
I'll
old
come to
survey
that.
number
I'll come to the next
67.
survey number separately. I'll finish survey one by one.
This does not mention any survey number, page 72.
It's mentioned. Centrally, the survey number 69. Just after.
69.
69.
That can't be made out properly.
Kayam, next to Kayam antide, other next to extensive.
This does not say old number 67.
No, it just says ಚಿಕ್ಕಸಾನೆ 69 ಅಂತಾರೆ.
So
now it is with reference to this document.
Original survey number 69 or new number 69?
New number 69. New number 69.
New number.
So if that was the thing, then they should have mentioned the old number.
But they have not. Now, my lord, the point I am trying to make before your lordship is this one. This document was produced along with the review petition. They understood it clearly, and then my lord gave that letter. Now, please see that letter in the context of this document. It is not as if the Learned Advocate General's office wrote to the Tahsildar without any background. That where is it?
185.
Not this.
What letter? 185, page 185. 185.
Not only Mr. Ron, your instructing counsels are not allowing you to argue. Not only Mr. Ron, your instructing counsels are not allowing you to argue.
What? RP number 443 they refer ಮಾಡ್ತಾರೆ.
Yes.
So it was not a question that was put to the Tahsildar without any background. It is with reference to this document, and please see what he says in the brackets. ಹಳೆ ನಂಬರ್ 67. And now, my lord, interestingly, please see what they say in the consolidated statement of objections that they have filed. You must get it quickly. Now, my lord, please see the consolidated statement of objections that they have filed. With so much of paper, this is what happens.
Page number.
Page number 3
of your convenience set.
There is a consolidated statement of objections ಹಾಕಿದ್ದಾರೆ ಅವರು.
Is it part of the convenience?
No, my lord, it's not.
Then please make a convenience set.
ಎಲ್ಲ ಹಾಕಿ ಒಂದು.
Actually, after we filed the convenience compilation, they filed this. That is why the problem.
On 10th of June 2026.
On 5th
Instead
of
of
June,
referring to all the objections, my lord, and 3 IAs, we
on
just
5th June, we filed the convenience compilation. On 10th June, they filed this.
ಇದೇ ಪಾಪ ಸಾಹೇಬ್ರು ಕೊಡ್ಬೇಕಾ ಪೇಪರ್ಸು. My lord, I feel very embarrassed, my lord, to trouble your lordship to turn these pages and find the
We
records.
don't have that. We have an interlocutory application IA3 which was filed on 2/6.
My lord, maybe my colleague can help the court master to get it.
Bharti.
Another copy we have, my lord.
No, we don't want another copy and confusing it.
The copy.
In the objection. You filed it on
there's
10th
this
June.
10th of June 2026. 10th of June.
2020?
Yes, 10 June.
10th of June.
This is the only thing apart
This,
from the.
this my lords can refer to, it is a comprehensive objections for all the. Sorry.
Everything else is there in the convenience set.
Correct.
This is the only thing which is missing, so this can be added to it.
Yes.
There's nothing else which is missing in the convenience set.
Yes.
If they're missing, then please make it proper and then we'll take it up. That's why we
No,
are.
that's all. This is the only one.
Yes.
At 8. My instructions are
Consolidate
nothing. Well, please be kind enough to turn to paragraph number 4.
Page 3.
At page 3.
Hmm.
It is submitted that the said certified copy is of the Darkhast register. It is to be noted that the entries have been struck off. So a new story today. First statement was ಏನು ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ. ಇವಾಗ ಇದೆ ಹೊಡೆದಾಕಿದೆ. And kindly see what a specious plea this is. It is submitted the Darkhast register examination. It is to be noted that there are no details of grant. Petitioners have not produced the issue register to substantiate grant in favor of T. Manikya Raju in respect to survey number 69. In the event if there was a grant, details of the grant would have been mentioned in Darkhast register. At best, the said entry only reflects that an application seeking for grant was filed. Firstly, the said entry does not help the petitioner in any manner, since there is no grant order or certificate produced by the petitioner. Secondly, the alleged grant is only after final notification dated 8/1/1921, issued under section 17 of the Mysore Forest Regulations. Petitioners are falsely contending that there has been a grant by relying upon the aforesaid document as a document of grant. The originals of the Darkhast register, the issue register, can be produced before this court if called upon to demonstrate that there is no grant in favor of T.V. Manikya Raju. I pause for a moment here, Manoj. I ask myself, how is this statement that is now made before this court complementary to the endorsement that has been issued, that the inter-office communication of the Tahsildar? And what is specious plea, Manoj, if I may say so? Please look at this Darkhast register once again. 72. What is this line that striking of that they are talking about?
Where is the grant order? You'll have to produce that for you to claim any right.
In respect to
even assuming that you want to draw an interpretation of it,
yes.
Even this letter also speaks of ಮಂಜೂರು ಆಗಿರೋ ಆಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಸದರಿ ದಾಖಲೆ ದೃಢೀಕರಣ.
No, that is, but your lordship is right, Manoj. That letter was not issued without a background. That letter was issued in the background of this entry.
Correct. That is what.
And to which they say there is nothing.
They are explaining that.
No, Manoj,
they have asked for production of to furnish the Darkhast order. You are not produced the Darkhast order to say that what they are saying is wrong. You are only saying that there is an entry, and this entry is sufficient.
According to us, it's sufficient.
Is that sufficient? Is what you will have to argue whether it is sufficient.
According to me, there is a presumption that these entries are right. Public records.
And the presumption that entry is what is not capable of being made out on that. Whether there is a grant order made, the grant order cannot be just that one line.
I understand.
There has to be a document.
Let me assume in a given case that there is no grant order. For some reason, it's the old grant, 1932, grant order is not there. Am I not entitled to show that with reference to secondary evidence? If primary evidence, namely the grant order, is not available for some reason, which is reasonable in this case, having regard to the fact that we are thinking about something that has happened some 80 years ago. Now, here is a contemporaneous record. Is it not something that should be given its due weight? Unless there is material to the contrary. I understand, my lord. This is the submission I am making. If your lordship asks me, show me the grant order, all that I can see, I don't have.
You are on a review.
No, I understand. Review.
Not
now,
even
this is there was no direct record of a grant. In the absence of a grant order, the direct record, the closest to a grant order, is a register that is maintained by the government in the official course of its business. Entry does not come there without any basis. There is a presumption that these records are right. Unless the government says, no, this entry has been cancelled in a manner known to law. And kindly see, Manoj, the statement that is made. Why do they say one line? Please see that entry, Manoj. But does it inspire any confidence in the question I ask myself, and I place it for your lordship's kind consideration? Is this not, my lord, trying to hide a fact before the court? And I think it is.
Assuming that also, how does it help you?
How
does that help you unless you
it
close the
helps
grant
me
order?
because the finding record, what happened in the writ proceedings, my lord, as your lordships are aware, of course, my lord, I'm carrying coal to Newcastle. Your lordships
That
have.
is 1 year ago, so. You'll
Your,
have to
my lord, what
refresh
was
our memory,
produced?
we won't remember.
I know, my lord, I understand. I understand. What was produced before your lordship was what is called the Ketwari register.
Yes.
Your lordship said Ketwari register by itself does not in any manner show a grant. Therefore, I cannot come to the conclusion that the property was a granted land to Manikyaraj.
It's only a revenue entry.
Then, my lord, what happened was there was some material that had been uploaded in the on the website in October of 2025. That led
What
us.
was uploaded?
I should. They uploaded what towards the yes. Yes, show it. But they uploaded
Page
what your
38.
lordships will find at page
38.
38
38
of the convenience
Compilation.
convenience compilation. Huh? ಏನಿದೆಲ್ಲ ಓದಕ್ಕೆ ಆಗಲ್ಲ. ಯಾವ್ದು?
Yes.
But at least
The center one is.
What is in the middle, my lord, is what is relevant for us. ಮೇಲ್ಗಡೆದು ಸಂಬಂಧ ಇಲ್ಲ. Kindly see on the side, my lord, what is written. ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ತಾಲೂಕು ದೇವನಹಳ್ಳಿ ಹೋಬಳಿ ಕಸಬಾ ಗ್ರಾಮ ಚಿಕ್ಕಸಣ್ಣೆ ದರಖಾಸ್ತು ಬಾಪ್ತು ರೀಸರ್ವೆ ಟಿಪ್ಪಣಿ ಪುಸ್ತಕ ಸರ್ವೆ ನಂಬರ್.
ಇದರಲ್ಲಿ ಏನು ಓದಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ ಅದಲ್ಲ, ಸೈಡ್ ಅಲ್ಲಿ ನಾವು
ಮೇಲ್ಗಡೆ
ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ತಾಲೂಕು
ಡೇಟ್ ಇದೆ
ಕೆಳಗಡೆ ಇದೆ 28. Survey number 87.
Survey number. My lord, one submission here, my lord, for clarification. Survey number 87 is to the right. The middle one is with respect to survey number 69, which is being type copy is in the next page. ಇದರಲ್ಲಿ 3 ಸರ್ವೆ ನಂಬರ್ ಕೊಡ್ತಾರೆ. One is 87 to the end of it. The
which we are not concerned.
Which you are not concerned. The middle one is survey number 89, 69. This is what was uploaded in the website, survey settlement.
ಅದು ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಡೇಟ್ 28/8/2025 ಅಂತ ಇದೆ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ.
The bottom, my lord, bottom
ಅಂದ್ರೆ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್
ಅಲ್ಲ, ಅವರದು ಸ್ಟಿಚ್ ಆಗಿರೋದು.
This document is digitally signed by the Department of Survey Settlement and Land Records on 28/8/2025 and does not require a physical signature ಅಂತ.
Yes.
That is it was put on the website on 28/8/2025. That is where, my lord, we started the chase.
What does this say? We can't even read anything.
Lord, madhya irodu, we have put a typed copy of now what they have done, Lord. This document was produced as annexed C, my lord.
They did not ask you to start argument. Is this type copy admitted by you or not?
No, it's not admitted. My learned friend's client may not admit it, but records at page 42 shows that that stand taken is not correct.
You have the original of this?
Yes. Please see page 42.
That is legible?
Yes, it is. Please see page 42, my lord. Exact what is stated in 42 is what is extracted
In 30.
at page 39.
38. What is stated here?
Survey number 69 ಅಂತ ಮೇಲೆ ಇದೆ.
They have produced.
ಅಲ್ಲಿ ಟಿವಿ ಮಾಣಿಕ್ಯ ರಾಜು ಅಂತ ಇದೆ. ಕುಷ್ಕಿ ಸಾಗು
ಸರ್ಕಾರಿ ತೋಪು ಕುಷ್ಕಿ ಸಾಗುವಳಿ.
ಹೌದು, ಇದಿಷ್ಟ.
ಸರ್ಕಾರಿ ತೋಪು ಕುಷ್ಕಿ ಸಾಗು ಸಹಜಾಯಂತೆ ಕರ್ದ ಟಿವಿ ಮಾಣಿಕ್ಯರಾಜು. This is what was.
I'm not able to make out anything in this 42
What was
about TV.
uploaded?
One question.
Is this what was uploaded? Is this what was uploaded?
That was what was uploaded in the.
Howdo, what was uploaded? This one.
This one. This is a. This is.
Yes,
Yes, yes, yes.
This is what was uploaded. 42 ತಾವು ನೋಡಿದ್ರೆ it may make a little more it may throw some light, my lord.
The beginning of it is 28/11/34. There's a date.
ಇಲ್ಲ ಕೆಳಗಡೆ ಅದಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 69 ಕಾಣುತ್ತೆ.
In Kannada.
In ಕನ್ನಡ.
My lord, immediately after the date 28/11/34, there is a line, and after the line next is survey number, below survey number is 69.
Yes.
Then Sarkari Topu Pushki Sagu, then some Saja Enteno Baritare, then the name
TV Manikyaraju.
TV Manikyaraju.
TV ಇದೆ, ಮಾಣಿಕ್ಯ ಇಲ್ಲ, ರಾಜು ಇದೆ.
ರಾಜು ಇದೆ.
ಮಾಣಿಕ್ಯನೂ ಇದೆ. ಅದೇ ನಾ ಸ್ವಲ್ಪ ಕಾಣಿಸಲ್ಲ ಅಷ್ಟೇ, ಬಟ್ I suppose may not.
Yes.
I have the original. Should I place it?
When you are, otherwise we'll be going back and. Yes.
Now, if we relate all this to the entry, my lord, that is found in the grant register. Extend to ಕೆಳಗಡೆ ಇದೆ. ತಾವು right hand.
What document is this at page 42?
Karda register.
This is the Karda register.
Karda register.
Karda, ಅದು ಕರ್ದ ಅಂತ ಬರೀತಾರೆ ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ?
Before TV Manikyaraju, Karda TV Manikyaraju ಅಂತ ಬರೀತಾರೆ.
What was produced before your lordships, my lord, when the writ petition was being argued, was a Khetware register.
Yes.
Correct?
And the extent is mentioned here.
And if your lordships are kind enough to see, my lord, on the right hand
43/24.
right hand corner at the bottom, 4369.
69. 60. 43 acres, some 64 and another. 43 is clear.
Not 45 acres.
43 ಇದೆ.
So not 45.
Not 45.
Not 40.
2 acres were taken away and survey 87 was formed.
I'm told, my lord, that it is 43. Because out of 45, some 2 acres were taken away to form
survey number 87.
And why is 69 there after that?
Miller? (69) or the Kannada word, we are not very sure, my lord, but 43 is visible. The Karda extract shows, my lord, the previous one which we showed.
The grant register.
ಇನ್ನೊಂದು Karda extract ತೋರಿಸಬಲ್ಲ, ಅದರಲ್ಲಿ 87 ತೋರಿಸ್ತಾರೆ. The uploaded version of the Karda extract shows survey number 87 was formed out of 2 acres from this land, 69. It was earlier totally 55 acres change. 2 acres was taken away and survey 87 was formed out of that. Next, after 42, sir, 43 is the revenue survey pattern. 43. Yeah, next page.
In page number 39, what you relied on typed copy, there are so many other references of geo number, etc. Were you not able to get the geo numbers?
In page number 39, my lord.
Yes. So again, there is no measurement.
ಹೌದು, ಮಂಜೂರ ಅಂತ GO number 11385 MILY.
75 as 45 acres, 24 guntas. 42 as 43 acres.
Page number 39 ನಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಬರ್ದಿಲ್ಲ.
39 ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ ಸರ್.
ಎಲ್ಲಿದೆ?
39 ಅಲ್ಲಿ extent ಇಲ್ಲ.
ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ ಸರ್.
ಎಲ್ಲಿದೆ ರೀ? 39 ಇಲ್ಲೇ ನೋಡಿ.
According to them, number ಇಲ್ಲ.
39 ಅಲ್ಲಿ.
39 ನಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ.
ಈ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಏನ್ರಿ? What is the government order? This is the reference to the
This is
This is the one in the gazette.
ಇಲ್ಲಿ. That is here in this portion.
113 FI, is that the one in the gazette?
Yes, yes.
Yes, sir. Yes, where is that? That, there is one correlation that I want to do, my lord. At page number 32, your lordship sees a reference to a government order.
32.
ಈಗ ತಾವು ನೋಡಿದ್ರಲ್ಲ.
39.
30?
9.
38, 39.
39.
39 is a type copy.
A type copy ತಾವು
38 we can't
ನೋಡಿದ್ರಲ್ಲ.
make out anything.
ಅದರಲ್ಲಿ your lordship saw a reference to a government order.
Yes.
Now, my lord, please be kind enough to turn to page 41.
Yes.
Kindly see page 300, serial number 311 at the bottom. Subedar TV Manikya Raju sanctions the grant of 12 acres of wet or 30 acres of dry land for his services in the field to the Chief Commandant, Mysore State Troops and Revenue Commissioner in Mysore. And kindly see, my lord, the number at the bottom, G11384-5. This is the grant. Where do I have it? I don't have it.
Finally, there is something now. Until now. But this is again 12 acres of wet or 30 acres of land where? In which survey number? This is what? This is a recommendation.
This is a recommendation. But he was granted 43 acres.
Sanctions.
Sanctions.
Yes, but no survey number, nothing is mentioned here.
Well, that is why, my lord, that reference to the government order becomes relevant. Your lordships are right, my lord. This is exactly the problem that we had too. Now, I have to link up to show their survey number. I link it up by this process, my lord. There is that reference number 11384-5. That is the one that your lordship will find at page number 38.
So your contention is this approval ended up in this sanction at page 39.
And the entry in the grant register.
Even the K12 has this.
The easiest thing that could have been.
So 41 to 39 to 72.
Yes, that's right. Yes, yes. Yes, sir.
329.
And I'm given to understand, my lord, that even the K12
register.
The K12 register that was before your lordship at the time when the writ petition was disposed of also refers to this government order number. We cancel. But please be kind enough. Any number. Yes, very there. Number
Page 180, type copy is at 181. Page 100. Page 100.
Yes, where is the number?
102.
Where is the reference to the government order? Government order reference is there. Government order.
105.
105, huh? Now, a government order reference is there. So these are the documents, Manoj, that I have to link up and say there was a grant. The easiest thing, I confess, Manoj, the easiest thing would have been to produce one piece of paper, namely the grant. I don't have it. Now, Manoj, is that fatal? Are all these documents not germane to the contours? It's not one document. There is a series of documents, including, my lord, an entry made in a solemn register maintained by the government in the course of its business, namely the grant register. This is a submission I'm making, my lord. Ultimately, my lord, it is a question of, I understand, my lord, the strict contours of Order 47. I'm not for a moment saying, but there have been difficulties in getting this document because it was all, my lord, came to light in October when this uploading was done. That set us to make some inquiries. We have got these documents. It is not as if these documents are not available with the government. It required so much of effort to get it. I ask myself, were they not duty bound to produce it before your lordships? And in a matter of like this, my respectful request to your lordship is, especially in the review jurisdiction, where your lordships find on the face of it, there are some relevant records which are exclusively in the custody of the authority. They should produce before. What your lordship does with that record is a different issue, my lord. But to put a private citizen at a disadvantage and say, you go and produce all the documents with the government, why should they produce? My lord, that attitude on the part of the government, my lord, my respectful submission is please deprecate it. Otherwise, my lord, the government citizen will be at a great disadvantage in this country. And and jurisdiction of your lordship under Order 47, my lord, is a very sacred jurisdiction. It is not only to correct an error that has been committed by the court. If afterwards we are able to show to your lordship that there are certain relevant documents which are in the custody of the other side which have not been produced, independent of the question whether I could have secured it with all my due diligence, they should produce it. Unless your lordship comes to the conclusion that these documents are not germane at all, that's a different issue. That's a totally different issue. This is not an argument in prejudice, my lord. This is only for the purpose of upholding the solemnity of proceedings before this court. I would earnestly beseech the court to look at it in that manner. Of course, my lord, at the cost of repetition, I'm saying if these documents, your lordships, after examination, come to the conclusion that they were not germane at all for the proceedings, then, my lord, the whole thing is a wild goose chase. But when your lordship looks at these documents, is it possible to say that it is not germane? Entry in a grant register, and what a specious plea, my lord. To say, oh, that has been struck off. How has it been struck off? One line. Is there an order by which this entry has been struck off? Who struck it off? When was it struck off? Is there a signature to that line? Under whose authority was it struck off? Please see the way they rely upon the striking off, my lord. It doesn't inspire any bit of confidence before the court. Now, if I am right in my submission that this property was a granted land, your lordship will ask me the question, how does it take your case further? My lord, please look at the provisions of the statute. What is it? Section 29. Lord, in this context, please see the Mysore Forest Act of 1900. Idi sir, you kodಬೇಕು. Have an extra copy. ಇಲ್ಲಿ ಸಿಗುತ್ತೆ 1900 ಏನ್ರಿ may I pass on the book? I have the iPad.
You have another copy?
Ide. It's okay. I know. Section
20. Which provision do you want us to see?
My lord, may I trouble your lordship to kindly see, my lord, section 21. 20, na?
20. No right of discussion shall be acquired in the forest except by
21 read.
Shall be acquired in the state forest except.
My lord, kindly see section 20, my lord. No right of any description shall be acquired in or over a state forest except by succession or under grant or contract in writing made by or on behalf of the government or of some person in whom such right or the power to create such right was vested when the notification under section 17 was published. So therefore, my lord, a plain reading of section 20 indicates that even where a particular land has been declared to be a forest land under the provisions of this act, there is no prohibition for a grant. except by succession or under grant. In other words, my lord, nobody can simply go and occupy forest land. For example, my lord, you pay that protest fees and then say regularize the property. It can't be done. Another But is there a bar against the grant of a forest land? No, unless it is granted to you. Now, our attempt before the court is assuming for the sake of argument that this property has been rightly notified under the provisions of the 1900 Act. There is a grant in our.
But where is the grant order?
Well, that answer to that question, my lord, I have to say without any doubt, my lord. But that grant order, if that grant order was there, my lord, we would have produced it at the very first. Now, this is why we have done all this exercise in order to show, is it a case where I could have created multiple documents? Now, who is to explain as to how those entries have come, both in the grant register and in the Kharda register? And my lord, that government notification that I showed to your lordships, where there's a reference to the government order. Well, looking at the practicalities of it, to simply put to me, my lord, where is the grant order? My lord, I am helpless. I am helpless, my lord. But my respectful request to your lordship is, please don't put that to me so strictly.
When it's forest land, we have to look at it very strictly.
Please look at it. I understand, because forest land is trust property. I agree, my lord. There is no doubt about it. But today, we are now seeing as to whether all these contemporaneous records with the government can be ignored in the absence of primary evidence.
When your vendor bought it, you bought it, everything.
Those things are not in dispute. My lord, the question, my lord, is whether it was granted in favor of.
You had an option not to buy it because it was not there. You bought it knowing fully well that it is not there.
My lord, it was not there. Here, and when did they wake up, my lord? When did they wake up?
If you are claiming under Manik Raj, you might have been right in saying that.
But there have been successive transfers.
Manik Raj would be that he was granted, we were there, it is lost, something could be done. With some 3-4 transactions have happened. And each of you knew that it was not there.
But it's worse. Because there are multiple transactions. If Manikya was there, your lordships could have asked Manikya, Mr. Manikya, where is your document under which you are claiming? We are in a worse situation, my lord. We are 4th generation. And government auctions it, my lord. It is in fact auctioned by the government for recovery of loan revenue, which Manikya did not pay. Manikya didn't pay. It was auctioned, purchased by somebody.
Government auction.
Kindly see that government auction, my lord. See the number? See the number? Show me where it is, wherever it is. Appeal. List of document.
Writ petition
Writ petition file illa. A writ petition file alli one document hakidiri andre convenience compilation.
We are not going to be looking at anything else except the convenience set.
I know, Lord.
We won't go.
That document relating to the auction that had been made by the government for recovery is in the writ petition. Adane convenience compilation.
No treasure hunting in so many papers. You will have to produce it along with one set.
How do the right court write it?
Even if we mark and make a note, how will we refer to it? But then you keep on filing memos, IAs. You should file it once. Now you are, especially when you are on a review.
The supplementary compilation. Supplementary compilation, because that's a very important document. If the government itself has auctioned the property for the purpose of recovering land revenue, is it not, I ask myself, my lord, and I humbly place it for your lordship's consideration, a relevant circumstance? Lord, I thought, my lord, that even in a civil proceeding, If I can't produce the original document, I produce all the secondary evidence in order to prove a fact.
You are now in a writ petition.
Well, it is in a writ petition, my lord, my respectful.
In a writ petition, you are in a review.
Yes, my lord. In a writ petition, first, my lord, in a writ, I'll answer that question on writ petition. In a writ petition, my lord, the rules are more liberal because your lordships are looking at the broader picture of doing justice. Your lordships are not shackled by the.
It sounds good, but is that the case?
Well, it should be that way, my lord, because it's a constitutional right. It should be that way, my lord. Technicality should not come in the way of doing justice, especially in a writ petition, where your lordships are looking at a very important aspect as to whether there is.
We should file a suit for declaration, succeed in that.
Today, in the
Establish
context
all
of your
this.
lordship's order, doors are closed. Nothing I can do. Your lordships have given a categorical finding that sorry, you have no right, this is forest land.
In the review, we can give you that liberty.
My lord, what has happened, my lord, is this. I must also tell your lordships, my lord. The property has been developed, sites have been formed, it is sold to so many people who have put in their life serving. That is the reason why we are troubling your lordships so much.
No, we understand that, but it's
So,
still
my
a
lord,
forest land.
driving me to file another suit.
Looking
My
at
lord,
it as
yes.
a forest land. Forest lands have to be preserved as far as possible till eternity.
And in the suit, my lord, they filed, they lost.
That was a
That your
different-
lordships have, my lord, that your lordships have considered, your lordships have referred to it, and formed some opinion, my lord. So I can't argue on that once again. I am now principally placing my case in review on the ground that these documents, which are very germane and relevant to the issue, in the context of the findings that have been recorded by this honorable court in the writ petition, were not available. Even after due diligence, these documents are available. In support of that, my lord, I would beseech your lordships as a matter of law to see if a citizen should be put to that strict standard, saying, prove to me what are all the efforts that you took. Don't worry whether the government had it, whether they did not produce it before. That, my lord, your lordships, I respectfully request, please do not lay it down as a law, because it becomes so difficult for a citizen to approach this court. In every writ petition, my lord, so many times we don't know what is happening with the government.
The government only doesn't know what is happening with the government. How will they produce all these things? To put it at such a high bar.
My lord, it should be, my lord. My lord, unless your lordships as a matter of law put it at that high bar, my lord, the government will never improve.
See, these are, if,
In any event, my lord.
if going forward from today when it is computerized, you can probably say they'll have to produce.
In fact, my lord, the constitution makers never visualized this type of a situation, my lord. That is why they said that every government record must be given its due credit.
But
Our
who will
papa,
know
they never
what
realized
has
that.
happened in 1929 and what order has been passed by
No, my
which
lord.
department? Where is it? How
If
will
they
get
don't
to
know, how do I know?
It's your property.
I understand.
You are
but
claiming a right over the
I am
property.
not for a moment. It was their property too. They didn't know. They auctioned their property for recovery of land revenue. If it was forest land, I asked myself, why did you auction the property?
Here you have two issues. We'll ask them about that. But
This is the problem that we have in this case, my lord. And I ask myself once again the question, my lord, and I place it for your lordship's kind consideration. Can it be said that every one of these entries have no credibility? It's difficult to fathom that submission. And look at this statement they make, my lord. My lord, that's a very important aspect of the case that I request your lordship to kindly note of, to take note of. Here is the Tahsildar who writes to the government officer, the forest officer, saying, sorry, with respect to this, as placed before the court in RP number so and so, there are no records available to us.
there is no grant order available.
No, my lord. Please see, there are no records, is what he says. No, my lord, respectfully. No grant. Get me the constitution. Get me the constitution first.
185.
Yes, my lord.
ಸಾಹೇಬ್ರೆ ಸದರಿ ನಕಲಿನಲ್ಲಿ ಕಂಡು
But your lordship may kindly see that page 185, my lord. Second paragraph. That ಸಂಬಂಧ ನಿಮ್ಮ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿರುವ ದಾಖಲೆ ಬಗ್ಗೆ, that is with respect to the grant register ಈ ಕಚೇರಿಯ ಅಭಿಲೇಖಾಲಯ ಶಾಖೆಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗೆ ಸದರಿ ನಕಲಿನಲ್ಲಿ ಕಂಡುಬರುವ ಯಾವುದೇ ದಾಖಲೆಯು ಲಭ್ಯವಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ.
ಕಂಡು ಬರುದಿರ ಅಂದ್ರೆ
Yes.
ಅದ್ರಲ್ಲಿ ದರ್ಖಾಸ್ತ್ go back to the first para.
Yes, my lord. That's only asking for, that is, in fact, worse for them.
ಚಿಕ್ಕಸ್ವಾಮಿ ಗ್ರಾಮದ so and so ಮಂಜೂರಾಗಿರುವ ತಿಳಿಸಿದ್ದು ಸದರಿ ದಾಖಲೆಯನ್ನು
ಸದರಿ ದಾಖಲೆ. ಸದರಿ ದಾಖಲೆ.
ಮಂಜೂರಾಗಿರುವ ಆಗಿ ತಿಳಿಸಿರೋದು ಸದರಿ ದಾಖಲೆ.
ಸದರಿ ದಾಖಲೆ is with
ಸದರಿ
reference
ದಾಖಲೆ is ಮಂಜೂರಾಗಿರೋದು is grant order.
No, my lord. Respectfully, if they had not referred to RP, they would have been right.
That
They
will not
refer,
be.
kindly see, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಚಿಕ್ಕಸನಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ so and so ರಲ್ಲಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರಿವರ RP ನಂತೆ ದಾಖಲಿಸಿರುವ ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಮಾಣಿಕ್ಯರಾಜ್ ಎಂಬುವರಿಗೆ ಚಿಕ್ಕಸನೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ so and so ಜಮೀನು ಮಂಜೂರಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು ಸದರಿ ದಾಖಲೆಯ ದೃಢೀಕೃತ ನಕಲು ಹಾಗೂ ಮಂಜೂರಾತಿ ದಾಖಲೆಯ ನೈಜತೆಯ ಕುರಿತು ವರದಿ ನೀಡಲು ಕೋರುತ್ತಾರೆ. That is with respect to the document that was produced. Well, that's what he is saying. ಸದರಿ ದಾಖಲೆಯ ದೃಢೀಕೃತ ನಕಲು ಹಾಗೂ ಮಂಜೂರಾತಿ ದಾಖಲೆಯ ನೈಜತೆಯ ಕುರಿತು.
ದೃಢೀಕರಣ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Only from the grant order.
No, ದೃಢೀಕರಣ is, my lord, the officer was not asked to find out as whether there is a grant order or not. ನೋಡಿಯಪ್ಪ, they have produced the grant register. ಅದು ನಿಜವೋ ಸುಳ್ಳು ಹೇಳಿ. That is all that they are asking.
That is a little
No,
too
that's my,
far.
that's my
Too far
submission.
to say that.
That's my submission.
They
my lord,
asked for-
if the first paragraph was not there, then, my lord, there is room for interpretation of this letter. In the context of the first paragraph, where the authority is saying, look, there is some document that has been produced with the RP. I ask you to verify whether it is genuine or not. He comes up and says, sorry, with reference to that document, there are no records with us. And now, interestingly, in the counter, please see the counter, and I'll kindly see one line striking off. What kind of a? Kindly now go back to page number 3, my lord, of the consolidated statement of objections.
Yes.
ಒಂದು ಕೊಟ್ರೆ ಇನ್ನೊಂದು ಕೊಟ್ಟಿಲ್ಲ, ಇನ್ನೊಂದು ಕೊಟ್ರೆ ಇನ್ನೊಂದು ಕೊಟ್ಟಿಲ್ಲ. It is submitted that the said certified copy is of the Darkhas register. So now they admit Darkhas register. It is to be noted that the entries have been struck off. But please see that striking off. I want your lordship to kindly see whether this plea carries any creditworthiness. Please see that. Show me that entry striking off. Yes. My lord, kindly see that striking off, my lord.
72. Yes.
I don't know where it is. That's why I'm struggling. Yes.
72.
Lord, please see page 72, my lord.
Yes.
What is that striking off, my lord? A one line ideyala.
When was the default?
I'm sorry, my lord.
When was the default in paying the taxes?
Oh, when was the default?
After
ಎಲ್ಲಿದೆ
for 34, 35 and 35, 36.
Dates. ನಿಮ್ಮ list of dates ಅಲ್ಲಿ my lord, kindly turn to. My lord, I have to. I am a little embarrassed, my lord, because the answer to your lordship's question, unfortunately, my lord, and wrongly so according to me, has not been put in the convenience compilation. That record is available in the writ petition. And
Please do one thing. Please
and I
put
agree, my lord, I have to be put.
We'll take it up again. This is the second time it's getting adjourned for this. Chandan, please don't embarrass Mr. Raghavan for this.
I will put this in one compilation.
Please put everything. Next time we are not going to give any time.
I will
Whatever
see
is
that it
there
will
is
not
what
happen.
we'll look into.
I will see that it will not happen.
Please don't do.
Sure.
No, I could not bestow my attention on what is put in the convener. I'm sorry, my lord. I will look at it myself.
See, you are on a review. So until there's a clarity on review, we are not going to exercise the jurisdiction of review if it is so to be exercised. You have appellate remedy, obviously, for any order that we pass. But on a review, you'll have to be clear and categorical as to what it is and all those documents. Mr. Rohn, you will have to explain, apart from all the other arguments that have been advanced,
Yes.
that government order which is there, the printout which is there at page 42.
Yes.
Not 42, page 41, item number 311. It clearly mentions Subedar TV Muniraju and there's a government order reference which is there. That government order reference is what is there at page 38.
I'll
So they are linked. So if they are so linked, how did that entry happen way back in 1938, 1929? And this so-called struck off is 25/3/32.
No, struck off is, there's a line, that's all I'm explaining.
Correct.
I didn't say it is granted and struck off.
Even if we are to assume that it is struck off, that is in 32 is the date of entry, which has been made and it is struck off. Then 35, you sell the property on account of violation or.
No, there's no auction proceedings. I have said in my statement of objections in the writ petition, my lord, that there is no auction proceedings at all. There's no grant, there's no auction proceedings.
Okay, anyway, we'll.
That's my
There are
stand.
things so far that you have to do.
And my lord, if just one other submission, I had produced the certified copies of all the grant order in the writ petition itself. Booklets of certified copies were produced. I'm just bringing it.
Whatever you want to rely upon,
No, no,
please
no.
file a convenience set. Don't ask us to be looking.
No, no,
there
I
and
kept
there.
the original itself present, my lord.
File it with us. Whatever you want to rely. We won't be taking all your originals. Okay, just by touching it, some 5 pieces fell down.
All right, I'll just
By
again.
the time we go through it, then we'll give you only
Pieces.
of paper.
Powder.
Then you will say, court destroyed the book. Bada adella.
I'll produce the certified copy.
You produce a certified copy, we'll examine that from your book. That will do.
Yes.
But we'll return back the book to you.
Yes.
ಆ ಬುಕ್ಕಿನ ಸ್ವಲ್ಪ ಟೇಪ್ ಹಾಕಿ ಸ್ವಲ್ಪ ಹುಷಾರಾಗಿ ಇಟ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
You'll have to contact Intact for safeguarding. Otherwise, these papers, we don't know, have you digitized all these? What has happened?
I think it's scanned also. That's what I'm.
Please digitize everything so that
Yes, yes.
they don't get lost
Yes.
with time. This heard further arguments of Shri K.G. Raghavan, Learned Senior Counsel, appearing for the review petitioner. When will you do it, Chandan?
ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
We will do the convenience in 2-3 days.
Pre-list on 21st at 4 p.m.
My lord. Serial number 19, your lordship, pass or matter, your lordship. Respondent is also
Lord, 21st.
I sought instructions, your lordship. The grounds are free after 28th of this month. The grounds are available for their program after 28th of this month as on today.
20.
28.
28.
Yes.
Fix a date. And submit an application.
My lord, one submission.
Just one moment, please. We are hearing them. Fix a date.
Please, lordship.
And make an application. We'll direct them to consider that application.
Sure, lord.
Anyway, 28th, Allah.
Please, lordship.
Serial number?
19, your lordship.
19, list 1.
Please, lordship.
List 1, serial number 19, relist on 17th.
Please,
By that time, you do that.
Sure.
Yes.
30 movement. The 230 moved matter. Serial number 2 in the.
Both of you are in the same thing.
The same match.
Yes. Next.
Serial number 59.
Sincere apologies for the misunderstanding. We demolish some cost, maybe invoice or I've been deep trouble.
They could not have done that. Let them know that.
So, your lordship, I only tried to bring you on record the DCF order that sought our eviction.
Why did they construct it? Please. They can't be doing like those.
Please, for my personal request, your lordship.
Surprise. We could have vacated your interim order for violating. We are not doing that, knowing that there are apartments which are there. But this, which is in violation, has to go. You want us to vacate the entire order? We'll vacate it. You want that to happen? No litigant can take this kind of either.
Serial number 59, my lords. Serial number 59, my lords. You are seeking interim prayer, my lords, as the petitioner in lawful possession, and they are failing to get basic.
We won't be taking up anything, madam. Yes.
Serial number 2.
CCTV.
CCTV footage.
CCTV footage, my lord, that matter was heard by the Information Commission. I am told on several occasions, applications are filed. They have been regularly giving all the pen drive, my lord. This specific date, what they are before the court, my lord, that CCTV footage is not there, my lord. because
How can it not be
there was
there?
some power failure, my lord. There was undermined. Now, my lord, I will explain, my lord. The nodal officer is Assistant Commissioner of Police. My lord, they have given an application to the authority which is maintaining, my lord. Then they have given an endorsement which was placed before the Information Commissioner. Information Commissioner has looked into the matter. Then they said we have to be careful on the next date of hearing. In fact, my lord, I went one step ahead and asked them if at all they have any body-owned camera recording at least of that date, my lord, because now they have the body-owned camera.
It's very fishy that the concerned date CCTV is not there.
My lord, your lordship may direct the nodal officer to be present before the court. Let them explain, my lord. This is upon instruction. This is what I have got the information. I don't.
This to serial number one.
One, Swami.
And AG on instruction submit that on the relevant date, there being a power shutdown, the CCTV footage is not available. The concerned nodal officer is direct to file an affidavit and be present before this court on the next date of hearing. Relist on 17 July at 2:30 p.m.
Swami, one submission, Swami. One submission. ಸ್ವಾಮಿ ಅವರು CCTV ಫುಟೇಜ್ 18/9/2025 ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ. ಬಟ್ ನಾನು ಕೇಳಿರೋದು 16/10/2024 ಅಲ್ಲೇ ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಪವರ್ ಇರ್ಲಿಲ್ವಂತೆ. ಒಂದೇ ದಿನ ಪವರ್ ಇರ್ಲಿಲ್ಲ, ಅದು ಮಾತ್ರ ಹೋಗಿದೆ.
ಒಂದೇ ದಿನ ಅಂತಲ್ಲ, your lordship may kindly see
ಇಲ್ಲ
on
ಸ್ವಾಮಿ, ಅನ್ಯಾಯ ಆಗಿದೆ ಸ್ವಾಮಿ.
Metro net.
Petitioners are failing to get basic amenities.
Yes, list 3, sale number 2. Yes, Chandan, what is it? 22nd, we have 137 matters. My 23rd month. Yes, what is this?
Please, Lord. A notice is issued for sale of my property. I am allowed the landowner. The developer appears to have defaulted under RERA.
You are also equally responsible.
Lord, my respectful submission is twofold. One, my lords, if I were equally responsible, I should.
How much are you going to deposit?
Lords, I don't even know.
What is the amount claimed and what is the amount that
Lords,
will?
we don't know because I have pleaded that this is the first time I know of these proceedings.
We are not going to intervene at either.
My lord, my instructions are, my lord, the auction has not taken place. The auction was scheduled today at 11 a.m. There were no bidders.
You are lucky. The AG accepts notice for respond number 1, 2. K. Rajshekar for respond number 3. Yeah, the Infinite Builders is that GM Infinite.
Yes, please.
Yeah, who appeared for them in that? Shetty. Vignesh Shetty. Vignesh Shetty for respond number 4, 5, 6.
Lords, 6 and 7.
4, 5. Who are 6 and 7?
They may be dispensed, my lords. They are co-owners along with me.
Co-owners of the.
MO has been filed for dispensation notice. Not dispensation. You want to delete them? Delete it. Dispensation is not something which is.
Please.
6 and 7 are deleted. Relist on submission of letter AGA is that the auction did not complete today. He is placed on record. He is directed to obtain instruction and make his submission as to what is the total amount due and liable to be paid under the various orders, including the recovery certificate issued by the learned, issued by the RERA. The huge amounts.
Please, my lord. The only thing is I have not participated in any of the RERA proceedings.
If you don't participate, what do we
I have
do?
not received any notice.
You have chosen to give it to a developer who has messed up everything. Out of 3,500 apartments, we have a lot of facts we can give you in so many matters.
Please, my lords.
No, in this matter, they have not started.
3,500 matters, he has not even built 1,000.
Please.
They say it's an
Here
arbitral.
he has done nothing, my lords. Just
They say it's an arbitral order.
There are
2016. they
banks which are waiting for 1,500 crores.
Please. Plus NBFCs.
Banks and NBFCs. We list on so and so.
Grateful.
And take it up now.
One small second.
Ma'am, into 59. 6.
ಇಲ್ಲ ಅಂತಲ್ಲ ಮೇಡಮ್, ಇದ್ರೆ ಕೊಡ್ಸೋದು.
Ma'am, 59, ma'am.
This two are 12.10.
ಇಲ್ಲ ಅಂತಾರೆ.
Entry matter exchange submission.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿರ್ಲಿಲ್ಲ
ಸರ್ ಅದು
ಅಪ್ಲೋಡ್ ಆಗಿರಲಿಲ್ಲ ಈ ತರ
ಸಾಹೇಬ್ರ ಆಫೀಸರ್ಗೆ ಕಳೆದ ಕೋರ್ಟಿಗೆ
6th August.
ಇದು ನನ್ನ ಟೇಬಲ್ ಮೇಲೆ ಇಡೋ ಅವು ಡಿಸ್ಕಷನ್
ಇಲ್ಲ ಯಾವ್ದಿದ್ರು ರೀಚ್ ಆಗಲ್ಲ
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3
ಯಾವತ್ತಾದ್ರೂ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ
ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು
6th August.
ನಾಳೆ ಯಾವುದು ಇದೆಯಾ ಸಿಎಸ್ ಯಾವುದು ಇದೆ ಹಲೋ ಮಿಸ್ಟರ್ ಸುನಿಲ್ ಸುನಿಲ್
ಈ ಟೇಬಲ್ ಇದು ಸೆಕ್ಷನ್ ಇದು
6th August.
ಇಲ್ಲಿರೋದು ಸರ್
ಏನು ಹೇಳಿಲ್ಲ
ಯಾರ್ದು ಗೊತ್ತಿಲ್ಲಪ್ಪ ಯಾರ್ಯಾರು ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾರೆ ಇದು ನನ್ನ ಟೇಬಲ್ ಯಾಕೆ ನಮ್ಮ ಜೀವನದಲ್ಲಿ ಈ ತರ ಮಾಡೋದು ನೀವು ಏಕೆ ಹೀಗಾದೆ ಬೇಡ ಇದು ಕಳ್ಸ
ಇದು ಸೆಕ್ಷನ್
ಇದ್ಯಾವ್ದು 6688
ಇದೆಯಾ ನಾಳೆ ಇದೆಯಾ
ನಾಳೆ
ಅದು ಇವ್ರದ್ದು ಇರ್ಬೇಕಣ್ಣ ಅವ್ನು ಯಾವನ ಎಜುಕೇಶನ್ ಅವ್ನು ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿರೋ ಹೋಗಿ ಅವ್ನಿಗೆ ಎಜುಕೇಶನ್ ಒಂದು ಐತಾನೆ ಎಜುಕೇಶನ್ ಐತಲ್ಲ
ಕೊಟ್ಟು ಅದನ್ನ ನಾನು ಹೊಡೆದಾಕಿದೀನಿ PRS ಜೊತೆಗೆ ಹಾಕಿದೀನಿ ಅದು ಹೊಡೆದಾಕ್ತಿದೀನಿ ಅದಕ್ಕೆ ನಾನು ಏನು ಬರೆಯಕ್ಕೆ ಹೋಗಲ್ಲ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಹೌದು ಅದು ಮಾಡಲ್ಲ
ಸರ್ವಿಸ್ ಯಾರಿಗೆ
ಅಯ್ಯೋ ಮುಂಚೆ ಇನ್ನು ಎಷ್ಟು ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು ಅವ್ರು ಕೇಳೋ
ಸರ್ವಿಸ್ ಅಲ್ಲಿ
ಗೊತ್ತಾ ಇವಾಗ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಈ ಸರ್ವಿಸ್ ಕೋರ್ಟಲ್ಲಿ 9 ಇರ್ಬೇಕಣ್ಣ ಅವನ್ನೆಲ್ಲ 9 ಇಲ್ಲ
ಅವೆರಡು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಕಣಮ್ಮ ಅದೇ ಬೆಳಗ್ಗೆ ಅದೇನೋ 16/7 ಗುರುವಾರ ಥರ್ಸ್ಡೇ ಅದು ಎರಡು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ ಅದ್ ಏನು ಅಂದ್ರೆ ಅವತ್ತು ಹಂಗೆ ಬ್ಯಾಚ್ ಒಂದ್ ಇಡೀ ಲಿಸ್ಟ್ ಅದೇ ತರ ಮ್ಯಾಟ್ರಸ್ ನಮ್ಮ ಇಲ್ಲೇ ಬೆಳಗ್ಗೆಯಿಂದ ಕೊಯ್ರಿ ಆಗ್ತಾ ಇದೀನಿ ಅವು ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಇವಾಗ ಒಂದೊಂದು ಈಚ್ ಅಂಡ್ ಎವ್ರಿ ಕೇಸ್ ಹಾಕೊಂಡು ಚೆಕ್ ಮಾಡ್ತಿದ್ದೆ ಇಷ್ಟೊತ್ತು ಅವರು ನನಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಏನು ಅಂತ ಜಡ್ಜ್ನೇ ಹೋಗಿ ಕೇಳ್ತೀನಿ ಅಂತ ಅಂದಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅಂತದ್ದು ಅಲ್ಲಿವರೆಗೂ ಅದಂಗೆ ಪೆಂಡಿಂಗ್ ಉಳ್ಕೊಳುತ್ತೆ ಏನ್ ಮಾಡೋದು ಏನು ತೋರಿಸ್ಬೇಡಿ ಬಿಟ್ಬಿಡಿ ನೋಡೋಣ ಮಾಡಿದ್ರೆ ತಿರ್ಗಾ ಅದನ್ನ ಆಲ್ಟರ್ ಮಾಡೋದ್ ಕಷ್ಟ ಅಲ್ವಾ ಅಂತ